So at least it shouldn't kick me out, right?
Shouldn't. I mean, it's connected, it's hardwired to your router, not Wi-Fi.
So
So it should be
should be
stronger.
good to go even though nothing's, okay.
Right.
It seemed like I was waiting. Good morning, Judge. Are you there?
I am. Good morning.
This is Vicki Brown, your court reporter.
Yes, thank you. Where are you this morning?
I'm in Cyprus.
Very good. I'm in Bryan.
Okay.
Okay, and there I am.
Okay. But this is the correct Wi-Fi password.
That is the correct Wi-Fi password. You just got to make
Hi,
sure.
I'm sorry, it's Susan Teskey. We're trying to make sure that we can get everybody logged in, Judge. Hi. Or ma'am.
This is Vicki Brown. I'm your court reporter. Good morning.
Thank you. Hi, this is Susan Teskey with Burleson County. We're trying to get the other attorney able to log in.
Okay.
So if you can give me a minute, I was showing them how I logged in. I just hit the link. Did you not get the link?
No, we have the link. You
Yes.
just can't log onto Wi-Fi to use the link.
Oh, okay.
Yes.
That's all outside my,
Yeah.
and a typical problem we have in this courtroom. Doug. Hi, Judge.
Good morning.
Morning. I'm sorry. We're working with the other attorney to try to get them logged in.
Okay, we'll try personal hotspot, see if that works.
If not, I could probably give you the hot. No, I really can't give you my work phone, but I can try to.
Good morning, Judge
Let's try-
Delaney.
Try the personal hotspot. and it'll come up.
Okay.
Thank you.
Good morning.
Judge, good morning. I'll be just a moment, okay? Thank you.
So I need to stay down there and make sure that.
Well, somebody's at work. Yes. Thanks. Guess I need to go give this to John. Do you want to go give it to him? Yeah. We're right there. Tell him to have Hannah help him.
It might be a good idea for everyone to mute their devices while you're working on arrangements.
Judge?
Yes, just a moment.
Okay. Miss McNichol needs to talk to you. There you go. Why? I'm not giving her my phone to use.
I don't hear. She.
Yes.
Thank you.
Good morning.
Good morning, Judge Delaney. Miss Jones appeared here at the courthouse today. She stated she did not receive the Zoom link. We all got it. I don't know really what the issue was. Her and her client are here. We have them in a different room, but we cannot get the Wi-Fi to work for her to be able to pull everything up. And for her to be able to do exhibits or whatever it is she's needing to do. Her suggestion was she wanted to see if she could go back to Houston, go to her office, get her stuff set up, and maybe have the hearing sometime this afternoon. I'm just
Your
I'm-
Honor, I didn't file anything, but I have to be in court in Abilene at 4 o'clock on a family law matter. I could certainly do it by phone with no video. I would be happy to in the car if that's something that we need to do.
Can they do that? Oh, but she wants her.
So where are the two of you located right now?
I am inside the jury room at the courthouse annex, and she is in an attorney room down the hall. I offered to let her come in here, but they wanted their own room. And I'm just on cellular data on my phone because I know our county Wi-Fi is, in these courthouses.
Yeah, it's iffy at best.
I mean, she could
Okay.
come in here if she wants.
She does.
Where is Ms. Jones located?
She's in another room down the hall.
She has an excuse for
And
everything.
does she have email access there?
She said she
She
can't.
has email access on her phone. Yes, sir.
Sir, with your permission, I can take my phone into the other room with her if you'd like to ask her something directly.
Or would you like
Well,
me to go?
I prefer that the court coordinator, somebody on staff communicate with her about this.
I'll be happy to.
And it seems to me that if she's got her telephone and, well, she can access the Zoom hearing via that.
Yes, sir.
Or is there a computer that you have available? I'm sorry, who have I got here on the call?
I'm sorry, this is Susan Deske. I'm the county attorney.
Yes.
The only
Wait,
computer.
wait. Who's the other lady?
I'm Tracy.
Okay, Tracy.
Yes, sir.
Good to meet you, Tracy.
It's nice to meet you too.
Can you, if she cannot access the Zoom hearing via her phone, can you provide her a computer? Tracy, can you provide her a computer that she can use?
Yes, sir. I have the link on mine. She can come into my office. I can move everything and make it available where her and her client and her staff member can do it from my office.
Well, if you just arrange it with her the best way possible. I see no need to postpone this to 1:30. Surely there's some way that she can participate in this Zoom hearing with just a little work, and I'll stand by patiently waiting.
Okay. Yes, sir. I'll go ahead, take them upstairs and get that set up.
Thank you.
And Your Honor, I'm gonna put it back on mute. My assistant Stephanie C is here. I've got a
Good morning.
felony docket. If you don't mind, I'm gonna step out and work on a couple of things.
No problem.
Do you mind? Okay, but Stephanie will be here. Thank you.
So what kind of instrument are we working on here, Stephanie? Is that a cell phone?
Yes, sir. It's a cell phone.
On cellular data.
Yeah, and we're just on cellular data.
I couldn't understand what you said.
We're just on our cellular data, just our data off our cell phone. That's all we're using.
Because the Wi-Fi system there at the courthouse is not good enough?
It's in and out. So sometimes it's good, sometimes it's not.
So are you an assistant county attorney?
No, I'm just her assistant. I'm the VAC for the office.
Make sure you turn it up.
Can y'all hear us?
Yes.
Okay, just want to make sure it's all set up.
get them.
Tracy's going down to get them. So it might take them a while to set it up.
Okay.
Okay.
really sorry I'm here.
She's still set. She's gonna push. Not on me. Sorry, Judge.
Can I ask everyone to unmute their devices?
Judge, we're trying to figure out logistical stuff with the, I guess, I'm sorry, who are you?
I'm Janice. I'm the assistant court coordinator.
With Janice, the assistant court coordinator. We're trying to do administrative stuff.
You need a few more minutes then?
Yes, thank you.
All right.
So if you need me to send him something.
Okay, Judge, good morning. May I ask a question? So we're not on my computer because the Wi-Fi is not working. There will be some pleadings that the court should already have that I'll be using as evidence. So is it So just wanted to make sure that was okay, because if it was on my computer, then I could put it on the, I could share screen, but I can't do that because this isn't my computer.
I may have the paper version of what you're referring to already here in my file.
Okay, we'll try to figure it out.
Well, can you want to check first?
Well, so I can tell you that I can ask you what the paper version of, if you have these things, because I'm just gonna ask you to take judicial notice of the application for protective order and request for temporary ex parte protective order in Morris v. Butler. I'm gonna ask you to take judicial notice.
I'm sorry, hang on just a moment.
Okay,
I have the application for protective order in Wilson versus Butler.
right. No, this is Morris versus Butler. We've got the same parties. We got the same judge and the same county attorney in that case as well. And that's,
Your Honor, it's a different applicant in which this attorney did not represent her.
I could not understand what you said, but back to the question. I don't have a copy of the application in the other case that you referred to. But perhaps I don't need to have it. If you can, we can take that up, I think, as the hearing goes along, and determine whether I have to have someone email me that application. In fact, let me just go ahead and ask. Is the court coordinator handy?
they just walked out. They closed the door to give me privacy. You want for me to call them back in here?
If you tell me,
They're right outside. Can you ask the court coordinator?
Vicky, you don't need to be attempting to take this down yet. We haven't started the hearing yet.
I appreciate it. You'll let me know. Thank you, Judge.
So there are some documents, the judge, you need them emailed?
Yes.
Okay, there are some documents the judge needs emailed that you guys should have.
Okay,
There is an application for protective order in the Morris v. Butler case.
okay,
There is an officers or authorized persons return.
let me write it.
You know what? I can, yeah, there's an,
Here you go.
They have fixed the Wi-Fi.
so if you want to make a copy of this,
Oh, yeah.
you can make a copy. That way you can just have what for sure.
Okay, and
The yellowed thing.
do you have a case number?
Yeah, I do. It's all there.
Perfect.
So if you can make a copy. I need that back.
Yeah, I'll be right back.
So Judge, they're going to go make copies. And she said it'll be quick. She's just gonna make a copy of the documents that she's gonna email to you. Thank you. You got those, you see.
Thank you.
All right, Judge, we're back.
So, Ms. Jones, are you indicating to me that you're ready to proceed on the hearing, subject to my receipt of those exhibits?
So I want to get something preliminary. I'm ready to be on the record, Judge.
All right, we'll start record now.
May it please the court?
First, I need to call for announcements. This is case number 30546, entitled Cassandra Wilson versus Andrea Butler. This is a hearing on the motion to recuse judge and county attorney, but I've given notice to the parties that today's hearing involves recusal of the judge only. My name is John Delaney. I'm sitting as the judge on this hearing today by assignment of the presiding judge of the Second Administrative Region. So moving party is Ms. Jolanda Jones. Are you ready to proceed this morning?
Yes, Judge, and it's Jolanda as
Forgive me.
opposed to Jolanda. No worries. My mother caused me all kind of problems.
And
So,
for,
and I would like to first, I want to re-urge the mandatory legislative continuance that I filed on, I think, Thursday. So I'd like,
we'll get to that in a moment.
okay, and I so want,
Excuse me.
yes,
I haven't called on the opposing side to make
Okay.
their announcements.
oh, I'm sorry, Judge.
Ms. Deskey for the petitioner.
Yes, Your Honor, the state's ready.
Very well. Now, Ms. Jones.
Yes, Judge, so I'd like to re-urge the mandatory legislative continuance filed on Thursday. Filed on Thursday. I think filed on Friday. I'm sorry, the 9th of December. I'd like to re-urge that, reconsider that motion, because I do not believe that based on that motion that we should even be going forward today, because it's within the 30 days of the start of the 88th legislative session. And I did have to move things in order to be here today after I was informed of your ruling on Friday.
Well, the email that I sent out on Friday, actually, I think Thursday and Friday. Let me be sure of that. Yeah, I see from looking at the email on my computer that I announced the ruling on December the 8th at 3:06 p.m. that I was denying the motion for continuance, and then again on Friday afternoon after what I believe was an amended motion styled mandatory motion for legislative continuance. I announced a ruling by email at 5:01 p.m. that I was still denying the motion for continuance, and that is still my ruling.
Okay, thank you, Judge, and I would respectfully request to get an order if you need for me to draft a proposed order on those, I will.
So was a proposed order submitted by you in connection with either one of the motions?
No, the last time we filed motions, it was, I'm not certain who drafted it, but they came from someone. So
To address your request, I will find an order, or I will draft one myself and sign it and get it filed. What next?
Yes, Judge. So I would object to moving forward because I don't think it's a proper ruling, but I just need that objection for the record, Judge.
Understand.
And I need, well, actually would ask for judicial notice of the court's file, specifically the application for protective order and request for temporary ex parte protective order in Morris v. Butler, which I guess the coordinator here said she'll email to you. Judicial notice of officers or authorized persons return for application for protective order and request for temporary ex parte protective order in the Morris v. Butler case, Judge. I would like the judicial notice on the second motion to extend temporary ex parte protective order and motion for continuance in the Morris v. Butler case. Like for the court to take judicial notice of the second order to extend temporary ex parte protective order and resetting hearing on protective order in the Morris v. Butler case. I'd also like for the court to take judicial notice of the final protective order in the Morris v. Butler case, I would like the court to take judicial notice. No, the reporter's record on hearing on the protective order in Morris v. Butler case. And I'd like the court to take judicial notice of the reporter's record in the Wilson v. Butler case. So this case. And those are all official court records, and the coordinator is going to, I guess, pull those from the file.
I would be surprised if she had the reporter's record in the court's file. But if she does, she does. In any event, I have no problem. Well, first of all, Ms. Desky, what is your response to the request for the court to take judicial notice of these instruments?
Well, Your Honor, I'm a bit confused. On the Morris v. Butler case, Ms. Jones was not the attorney of record for that case. The respondent proceeded pro se after Ms. Jones clearly told Judge Campbell and myself that she would not be representing her on that case. She was only representing her on this Cassandra Wilson case, not the Morris case. Afterwards, Ms. Butler has hired an attorney who has filed an appeal, which is, that attorney is not Ms. Jones, so I'm not quite sure what Ms. Jones has to do with that other case, since she was not the attorney at the hearing. She was not at the attorney of the motion for new trial, and she's not the attorney for the appeal.
Judge, may I respond?
No, you may not yet. I'll respond. I fail to see what Ms. Jones' status or lack of status as the lawyer in that Morris versus Butler case has to do with the evidentiary relevance of the documents. So if you're making an objection, it's overruled, and I'll take judicial notice of any documents that are contained in the Morris versus Butler file that have been brought to my attention. The reporter's record that's been requested for me to take notice of is a matter I'm going to have to consider further, because I don't believe the reporter's record is going to be a file document in either of those court files.
Judge, I can try to get a copy of that, but we can move forward without that for right now. The
Very well.
reporter's.
Very well.
So may I proceed, Judge?
Well, I'm trying to decide whether to raise a procedural matter at this point. In the interest of time. First of all, let me ask,
And
plaintiff,
the question.
no,
Yes.
just a moment. Let me talk.
Yes, Judge.
Ms. Desky, has your side filed any kind of responsive pleading to the motion to recuse?
Just a general denial this morning, Judge. For the motion to recuse for myself, I believe Judge Campbell filed and requested someone's appointment as to his recusal.
May I ask a question, Judge? Because I'm confused.
And what is that question?
For whatever reason, I thought that the county attorney recused herself and somebody else was appointed. Was I wrong? Did I misunderstand?
It's
I have
news
not-
to me. So the answer is what? Ms. Deskey?
Oh, I'm sorry, sir. No, I have not filed or requested a recusal. I filed a general denial on the recusal.
I think that the first order of business would be to make a ruling on the recusal of the trial court judge. And if the recusal is granted, the successor judge would then deal with the motion to recuse the county attorney. If the motion recuse is overruled, then the current presiding judge would handle that recusal motion. So the matter before us today is simply the motion to recuse the current presiding trial judge, Judge Carson Campbell, I believe it is. Okay, so back to the procedural issue that I feel I have to deal with. As you allege, Ms. Jones, in your motion to recuse, the motion to recuse the trial court judge is governed by rules 18A and 18B of the Texas Rules of Civil Procedure. And the first rule, 18A, in paragraph B. So I'm looking at rule 18A, paragraph B, in parenthesis B, entitled Time for Filing Motion, says that, paraphrase somewhat, a motion to recuse must be filed as soon as practicable after the movement knows of the ground stated in the motion. And B, must not be filed after the 10th day before the date set for trial or other hearing, unless before that day, the movement neither knew nor reasonably should have known the grounds for the motion. Again, some paraphrasing there. So it's evident that the motion to recuse was filed on November the 14th. And the next trial hearing was set for November 17th. The hearing on the merits of this application for protective order. To repeat, the motion to recuse was filed November 14th, which is much less than 10 days before the November 17th hearing. And as I read the motion to recuse, all of the grounds alleged for the recusal of the sitting judge seem to have occurred on or around August 25. So I have to ask, Ms. Jones, what your basis would be for filing on November 14th.
So may I respond, Judge?
Absolutely.
So as Ms. Deskey said I was not the lawyer on the Morris v. Butler case. So I did not know what was going on with that case. Didn't want to know, hadn't been paid. I'm not going to get into that, but I didn't want to know anything about it. In preparation for the hearing on November 17th, my client told me I needed to speak with her other lawyer for the Morris v. Butler case. So as soon as I spoke with the Morris v. Butler, with the lawyer, whose last name is Jurek, if my memory serves me properly, she let me know some things that happened with in that case, but I did not know until I spoke with her that the Morris v. Butler case was actually filed in the 335th. I didn't know that. I thought they were all in the same court. And I did not know that an order had been entered in the Morris v. Butler case out of the 21st Judicial Court. And I learned that there were no transfers to the 335th. I learned, again, from Ms. Jurek, that Ms. Butler had not been noticed. Again, I just presumed, since I was set in the 21st, that the other case was. So as soon as I found that out, I filed it because I was preparing for trial. And my client kept saying, it's in the wrong court, it's in the wrong court. Like, what do you mean it's in the wrong court? You got to talk to my other lawyer. So I literally talked to her other lawyer. So I didn't have anything to do. I didn't realize that was germane. And now I found out that it absolutely is germane. I didn't know why one had to do with the other. But in a nutshell, Judge Campbell held a hearing, a final hearing for PO in a case that he had no jurisdiction over, and which was filed in another court. So in the 335th with Judge Corbett. So I didn't know that. I had no idea about that.
Okay, Ms. Deskey, I'd like your response to that dialogue.
Yes, Your Honor. We have two separate and different applicants for protective orders against this particular respondent. Ms. Jones represents her in one case. The other, she proceeded pro se. She was served in this other case that Ms. Jones is talking about on June 20th. There had been two other hearings that were reset. And so the state announced ready on that particular day. Ms. Butler, I believe.
What particular day?
What day was it? The August 15th. August 15th. And all these are 2022, Judge. So we have had,
okay, hang on. Were both cases scheduled for a hearing on that day?
yes, Your Honor.
The Morris case and the Wilson case?
Yes, sir.
So Judge, may I respond? Because I don't think that's accurate.
Well, let me hear her out, please, and then you can
Okay, I'm
point out,
sorry. I thought she was finished.
inaccuracies.
I apologize. I thought she was finished.
Nope. I interrupted her.
Okay.
Thank you, Judge. As you're aware, our district court judges cover 4 counties, and they are eligible to hear either one of the 21st or the 331st. Both judges are eligible and routinely hear cases on particular docket days. And the other times that Ms. Butler showed up on the other case and this case, every time Judge Campbell was the presiding judge. We had 2 other settings before that August 15th.
Okay, for now, Ms. Jones, you can respond.
Yes, Judge. So it was my knowledge at that time, and I believe now, we were prep set for a hearing on August 15th. That was our day. We prepared for that trial because we were prep set. We'd begun the hearing earlier, which I'll get to in this hearing. And it was interrupted and we were prep set. I was told that the docket was going to be clear. We were told that we wouldn't have any problems and we could go forward because it was just told that there was a lot of stuff. And so we had to stop because it was taking too long. So I went there fully expecting that the only case on the docket would be this one. That was my understanding. We were prepared. So I was surprised. I was surprised that there was something else set. So it was not my understanding that there was another case set on the docket. Now, I'm not her lawyer in that case, so I don't know what notices she received or she didn't receive. But for sure, and let me make sure I say the case number right, 3546 is the case that was prep set on August 15th. And I don't know about other judges sitting for other judges or any of that stuff. I just know that Judge Campbell was a judge in 3546 for Wilson v. Butler, and we were prep set on that day.
Okay, so we are scheduled today and we are in progress on a motion to recuse Judge Campbell in case number 30546.
Yes, Judge.
So the question I raised that I need to concentrate on is what could explain your delay in filing the motion to recuse in that case until November 14th within the 10-day restriction, since it appears that you had knowledge of the conduct that you're complaining of in your motion way back on August 15th.
No, I did not, Judge. I did not know about anything related to the other case, to the Morris v. Butler. And what I'm saying to you is there were representations made about me in the Morris v. Butler case that I knew nothing about, that the judge and the prosecutor knew I knew nothing about. I did not find out about the cases being in separate courts and representations being made about me in the Morris v. Butler case until I began to prepare for the hearing. So the hearing was set on November 17th. I don't prepare for hearings 2, 3, 4 weeks in advance. I prepare for hearings proximate to the hearings so that everyone remembers what happened. So I think the hearing was maybe on a Monday. I think the 14th was, I don't know what day it was. I don't want to confirm that the date of that hearing, whatever the date was, I confirmed as soon as I could meet with my client as close to the trial as possible. And it was only then that my client, and I can't speak for her with her relationship with her other lawyer, but it's my understanding based on speaking to her other lawyer that, I think her other lawyer was hired to appeal that other case.
Correct.
And so her other lawyer was waiting on things in that case. And so even in this case, there are things I didn't find out until the end of November related to that case that I think are germane to this case because she was waiting on reporters' records and things like that. So I had no way of knowing. I didn't have access to the file. And when I began to prepare for trial for this case, I ended up speaking with her lawyer because my client kept telling me it's in the wrong court, it's in the wrong court. I said, what do you mean it's in the wrong court? So I had to talk to her lawyer. So I absolutely filed this as soon as it was practicable when I was supposed to know, because I didn't realize, it didn't occur to me that Morris v. Butler had anything to do with Wilson v. Butler. I just didn't know. I did not know misrepresentations had been made about me in Morris v. Butler. I did not realize that my name is on an order in Morris v. Butler because I'm not in that case. I was served with nothing. I wasn't retained. So I wouldn't know any of those things.
When was the court proceeding that is relevant here in the Morris versus Butler case? What day?
Let me check, Judge. There was an order, Judge. I'm trying to find the date. No, not that. Not that. I'm just trying to find. Oh, let me look like this here. I'm looking, the second order to extend temporary ex parte protective order and resetting hearing on protective order. And the cause number 3690, I didn't even know this document existed. But it was filed on July 29th of 2022. I knew nothing about this document.
In your motion to recuse the judge that's before me today, in paragraph 2A,
Hold on, Judge. Let me pull that up. I'm sorry. Okay.
you make reference to Judge Campbell stopping the protective order trial because he thought it was going to go too long, and then he continued it to August 15th.
Yes, Judge.
And then in paragraph B, you refer to him refusing to preside over it on August 15th.
Yes, Judge.
And instead forced a respondent to go forward on a separate trial.
Yes, Judge. That's the case that I didn't know anything about.
Okay, were you present in court that day when that occurred?
I was present in court that day, Judge.
And so did the judge do something that day in the other case that gave you some concern about his bias or prejudice?
So actually, Judge, at that time, when the judge says we have a lot of other dockets, and I don't know how many counties this covers or whatever, I didn't realize a pattern, even though it was pref set. So at that time, I didn't see it, but over time, I've determined, especially after finding out that I'm in an order and representations are made about me in a case that I'm not in, saying I did stuff that I did not do or requested stuff that I did not request. It was just a compilation of things that said, oh, okay, I don't want to go into attorney-client privilege communications, but enough things were done where if I wasn't concerned on the 15th, which I was extremely frustrated on the 15th because I did prepare. I did believe that the docket was going to be cleared, but I was told that in these counties, just a lot of stuff happens. So when he said he was pref setting it again, but when I found out from the other lawyer about what was happening with the same judge and the same county attorney, and I didn't find about me until later, like that I was involved in this. So the basis of this motion to recuse a judge is not solely based on what happened on June 24th? I'm not solely concerned about that. I'm not solely, so it was a compilation of rulings and misrepresentations at best, especially related to me, that caused me concern to where I said, and at first, I will say that my client did not, I didn't realize I needed to speak with the other lawyer, but at some point, my client wouldn't allow me to speak with the other lawyer because if we talked, she had to pay me and she had to pay her other lawyer. So she didn't she didn't want me to call her or the lawyer, and that's just the truth. And when I couldn't understand what she was trying to explain to me, because she's not a lawyer, at some point I finally convinced my client to allow me to speak to her other lawyer, because I'd actually contacted her other lawyer, and her other lawyer wouldn't respond to me. And then I contacted my client. She told me, well, I instructed her not to talk to you. And I was like, why? And she was like, because if you talk to her, I got to pay for that. If she talks to you, she's got to pay for that. And it's costing me too much money.
All right. I'm not sure that
It's relevant, Judge, because I couldn't speak to my client, and those records aren't public. I also didn't realize I also didn't realize they were related. Normally.
Hang on a moment. In the motion to recuse that I'm trying to rule on today,
Yes, Judge.
you mentioned two dates. You mentioned August 15th and you mentioned November 17th. You don't mention a date when any other conduct occurred or any incident occurred that you would allege constitutes or shows evidence of bias or prejudice.
Yes, I do, Judge.
Okay, show me where.
If you go down to paragraph number 8, there are a number of specifically and based on information and belief that Judge Campbell presided over a case outside of his jurisdiction related to Butler. The court misrepresented Respondent Butler's readiness for trial in an official court record, proceeded to trial without Respondent Butler having proper notice of a case he lacked jurisdiction over. The court denied Respondent's request for time in a cause for which the court lacks jurisdiction and for which Respondent was entitled to an attorney. And the court did not follow the law when it issued the protective order in the case the 21st. I didn't have knowledge of that information because it was in the other case.
Hang on, please. Hang on, please. I am looking at your motion to recuse now. On page 4 of 7, I see a pair.
No, this has 8 pages, Judge.
Mine has 7. And there is no paragraph 8.
I think there may be. You're not looking at the amended one, Judge.
There's an amended motion to recuse.
Yes, Judge.
You're right. I wasn't provided that one.
They told me this morning that they sent it to you, Judge.
Your Honor, I believe it was filed at 6 o'clock last night via e-file.
All right, bear with me while I check email. All right, to make sure that this happens fast, I'm going to call the admin assistant, Tracy McNichol, by phone. Hello, is this Tracy?
Yes, sir.
This is John Delaney. We're in the middle of this hearing, and I'm informed that late yesterday, an amended motion to recuse was filed. Will you see that that's emailed to me right away, please?
I think we sent all that to you earlier this morning. Let me go back.
Who would have been the sender? Oh, I see. 841 motion and orders. You're sure right. I didn't see that. All right. Thank you very much. Sorry to bother you.
No, that's no problem, Judge. Just let us know if we can help you.
Okay, bye. All right, it's been pointed out to me that the first amended motion to recuse / disqualified judge and county attorney was emailed to me this morning. I have it on my screen now. Give me a moment. So looking at paragraph 8 in your amended motion to recuse, it sounds like you discovered some new grounds for your motion after preparing for today's recusal hearing, and that's what prompted you to file the amended motion to recuse. But you still don't mention any dates.
May I respond, Judge, or you?
Yes, sir.
Thank
Yes,
you.
of course. I'm finished.
So the pleading is, it's not the evidence, but after learning what I learned this weekend, I didn't know details of what went on in the other case. I'd been told sort of generally by my client's other lawyer that there were things that were done that were not fair in that case as well. So she actually didn't file, at least per her, she told me that she didn't have the evidence. She didn't have the reporter's record. She didn't have various records that she needed in order to vet about what, I guess, our client in separate cases told her. So she didn't file anything until later, like close to December, the end of November. So I didn't have any specifics, but after learning things at some point, look, I'm a lawyer. I've been practicing for 27 years. Never had my law license suspended, never anything. I worked very long and very hard to get this law license. The same with judges. So I think I don't even think I filed 5 recusals for judges in my 27 years of practice. So I think long and I think hard before I file recusals because I know what it is. So even though there were things being done like moving a pref set trial or hearing, that alone, even though it gave me pause, I just didn't want to go there. But after learning what I learned, after the other lawyer finally was out to speak with me and actually her sending me documents because she had finally received them from whoever she was receiving them from, because she was not her lawyer when that PO hearing happened in 3691. She wasn't her lawyer and she didn't have the record and stuff like that. So as soon as she told me that just compiled on, but I had been told by her without specifics by November that this stuff happened. I'm waiting to confirm it. Like your client, our client doesn't have a chance to be fair, but she didn't have specifics because she didn't have the documents. She just didn't have them.
Okay. Ms. Deskey, do you want to add anything by way of response about this question about time of filing?
Your Honor, if I may briefly respond to the items on the first amended motion to recuse that was filed last night. If I may briefly respond on A through F, I will leave all the things that have to do with me because that's not this hearing.
You're going to have to get closer to the mic on the device you're using.
Apologies, Judge. I had to plug in my phone. It was dying on me, but can you hear me now, sir?
Yes.
Okay, thank you. If I may briefly respond to everything or most of under 2, as far as A, that setting that she's talking about for August 15th was a regular docket day. It was just a light docket day. Then Miss Jones, Judge Campbell, and myself pulled out our calendars and settled on a special setting with no other things set for November 17th. We all agreed on that date. As far as under B, this case for Miss Butler on the other case had already been reset twice. It was for judicial economy because it's a lot of the same witnesses and it's the same respondents. So as we moved one case and reset it, we would reset for Miss Butler and the witnesses' sake the second case as well, which is why Miss Jones shows up in some of my amended motions, because I'm resetting Miss Butler's second case due to the attorney with the same witnesses resetting the other case. She had already had 2 other settings for that. As far as under D, just because Judge Campbell granted it does not make it wrong. And then also under F, when they're talking about the other case and the appeal, the Court of Appeals has denied the stay on that protective order, and we can certainly get you a copy of that order. I believe it came out last week.
Judge, may I respond?
Not yet.
Okay, I'm sorry.
Ms. Deskey, what I asked you to do was to address the question of the timeliness of the motion.
Your Honor, I cannot say when she spoke to her client. However, Ms. Butler was given a copy of the signed protective order by Judge Campbell on August 15th.
Okay, tell you what I'm going to do. I'll tell you what I'm going to do. I'm going to let you present your evidence, Ms. Jones. I'm not going to cut you off because of the timeliness issue, but I'll see where that evidence takes us. So now we're going to proceed on the merits of your amended motion to recuse. Is that clear?
Yes, but I want to make a correction about a representation. Yes, I know you've ruled, but I want to make a representation about the agreedness of the November 17th date, because that's not entirely accurate, Judge. Okay,
Well,
I'll waive that. I'll come back to it, Judge. I'll come back to it.
Okay,
I'll come back to it.
the ball is in your court now to present evidence in support of your amended motion to recuse.
Yes, Judge. The respondent calls Susan Deskey.
As a witness.
Yes.
Very well. Do you swear that the testimony you may give will be the whole truth, so help you God?
Yes, Your Honor.
You're going to have to get closer to the device.
Yes, Your Honor. Apologies.
Can you sit at a desk with that phone?
I'm in my jury room. Let me try holding it. Is that okay?
Much better.
Thank you, sir. I apologize.
All right, go ahead, Ms. Jones.
Yes, Judge. Ms. Deskey. I'm sorry, County Attorney Deskey. I don't want to disrespect you. You are the prosecuting attorney for Wilson v. Butler, cause number 3546 in the 21st Judicial District Court. Yes or no?
Yes.
You are the prosecuting attorney for Morris v. Butler, cause number 3691 in the 335th Judicial District Court. Yes?
I
no?
believe I don't have the cause numbers in front of me.
Are you the prosecutor for Morris v. Butler?
Yes, I am.
Okay. On June 30th, I'm sorry, on June 3rd, isn't it true that on June 3rd, 2022, You got a TXO granted in Morris v. Butler?
I'd have to pull my file. You'll give me a moment.
Yes, please.
You said June 3rd?
Yes.
Okay. The district clerk file stamped it June 2nd.
So the TXO was granted on June 2nd.
I'm looking up the judge's signature now. I filed it on June 2nd. And Judge Campbell signed it on June 3rd.
And isn't it true that I'm not the lawyer on Morris v. Butler?
It's true you've never filed an appearance on Morris v. Butler.
So are you saying that I am the lawyer on Morris v. Butler?
I'm saying that my not have a notice of appearance for you, Butler.
So you've never considered me the lawyer for Miss Butler and Morris v. Butler?
If I recall, we have had questions asking if you were going to represent on both, and you very clearly said they had not paid you for the.
Judge, I'm sorry, I'm losing some words from Miss Deskey.
Yes, I agree. Me too.
See if I have enough. Sorry, Judge. I've not, in my file does not show a notice of appearance for you on that particular case. And from conversations, I can't remember what exact dates, when you showed up for court, you made it very clear to myself and to Judge Campbell that you had not been paid on the second case and you were not representing her on the second case.
Okay. Isn't it true that on June 20th, 2022, Ms. Butler was served with that TXO at 7:58 in the morning?
That's what my records indicate.
Isn't it true that on June 24th, 2022, I appeared for a hearing in Wilson v. Butler and announced ready?
I don't recall what you announced.
Isn't it true that we had a hearing? We began a hearing on June 24th, 2022 in Wilson v. Butler.
I'm having to look at my records. I don't recall if we started a hearing on June 24th or I know we started one on August 15th. So I'm having to check my records.
Well, I'll move on. Isn't it true that on June 24th, 2022, Judge Campbell preferentially set the Wilson v. Butler case to August 15th of 2022?
No, ma'am, it was my understanding that it was a lighter docket day and it's our regular docket day, which is reflected on the docket sheet that goes out to all the attorneys. There were felonies, there were CPS cases, but it was a lighter docket day.
Isn't it true that on July 26th of 2022, you filed a second motion to extend the TXO and a motion for continuance in the Morris v. Butler case.
Yes, ma'am, and I cited in there, it was because the attorney on the other
Objection
case was,
non-responsive. Objection non-responsive.
I'll sustain.
yes, I did.
Isn't it true that in the second motion to extend temporary ex parte protective order and motion for continuance, that you alleged in your motion that respondent's attorney on another protective order has requested a continuance and it was granted by the court?
Yes, ma'am, I believe you were in a runoff.
Objection not responsive to the last part. I believe you're in a runoff, but
Overruled.
so in your motion for an extension of the temporary protective order and the motion for continuance, you allege that I requested it in this case number 3691.
I allege you requested it in the other case.
Okay, so let's move. So isn't it true that an order was signed by Judge Corbett on July 29th, 2022, based on your
Correct,
motion to extend that was filed on July 26th?
correct.
Is it isn't it true that the order that was signed by Judge Corbett says that respondent's attorney, Yolanda Jones, has requested that the temporary ex parte protective order be extended pursuant to Family Code section, what it says?
Which case are you asking about?
In cause number 3691, 30,691, does the order not read that respondent's attorney, Yolanda Jones, which is me, requested an extension pursuant to Family Code number 83.002B?
Right, and then when you continue, it
Objection
says,
not responsive.
I'll overrule.
correct.
I'll overrule now.
Yes, sir.
Finish your answer.
Correct.
I did overrule the objection.
Okay. Oh,
So
I'm sorry. So the second sentence in that says, because you had requested an extension on the other case, and they were the same witnesses for both cases, and
So
the same respondent.
objection, I'm sorry. Isn't it true that I never requested an extension of this 3691? Isn't that true?
It is, as the paperwork states, you had requested an extension on another case that had the exact same witnesses and respondent.
Isn't it true that they didn't have the exact same witnesses?
The majority of the witnesses, no ma'am, I disagree. The majority of the witnesses are the same witnesses, including law enforcement, et cetera.
Isn't it true, Ms. Desky, that the witnesses that you called for 3691, whoever they weren't my witnesses? Isn't that true?
No ma'am, they were my witnesses for both cases.
Well, I don't have anything to do with that. But so I just want to be clear that I did not request an extension of the TXO in cause number 3691.
Yes, ma'am, that was my request.
Okay, so it was not my request. It was not Attorney Yolanda Jones's request in 3691. Is that accurate?
Yes, ma'am.
And in fact, isn't it true I wasn't notified of this temporary ex parte protective order extension?
Unless you were the attorney of record in the file, no ma'am, you would not have gotten any notices.
So you didn't send me a notice of it.
Ma'am, unless you're attorney of record in a file, you do not receive notices on these cases.
Objection non-responsive. It's yes or no. Did you send me a copy of this extension of the TXO in motion order?
I'm unaware if the clerk sent you anything or not.
Would you have ordered the clerk to send it to me?
Ma'am, I don't order the clerk to do anything.
So do you have, please look in your file right now. Do you have any indication that you sent me notice of this order? Specifically, the order signed on July 29, 2022, styled the second order to extend temporary ex parte protective order and resetting hearing on protective order in cause number 3691.
Ma'am, I do not see an e-file receipt showing service to you.
I don't think that was a question. Maybe I'm being inarticulate. Did you, yes or no, send this to me?
Ma'am, the only thing I can go by is the e-file certificate of service. I'm not.
So it's your testimony that you can't tell, you can't say, no, I didn't send it to you.
You're not on the e-file service, ma'am.
Okay, so I wasn't sent it.
As far, I don't know who sent you. It doesn't appear that my office sent it.
Would you have instructed them to?
Ma'am, I don't recall.
And you will agree that in cause number 3691, the court that case was pending in is the 335th Judicial District Court, yes or no?
From the Stala case, it appears to be.
So is that a yes?
Yes, ma'am.
I interpret that as a yes.
And isn't it true that Judge Corbett signed that order on July 27th, 2022?
Yes, it is.
Isn't it also true that every pleading in cause number 3691 was filed in the 335th Judicial District Court, with the exception of the final order?
As I've stated, the district clerks assign the courts. I do not.
Objection non-responsive, Judge.
Trying to answer, Your Honor.
Let me rephrase this very simple. Isn't it true that every pleading, with the exception of the final protective order, was filed in the 335th Judicial District Court?
I'm looking at Judge Campbell's signature on June 3rd for the TRO. But
Okay.
yes, the 335th is what is the style of the case.
I'd like for you to look at let me just move to something else. Hold on, Judge. Also, in the final protective order in cause number 3691, isn't it true that you filed the final protective order, the proposed order, and the judge signs it if the judge agrees with it?
With modifications made by the court, if
Okay.
necessary.
Okay, sorry for interrupting you. So you file it, the judge modifies it as the judge deems necessary.
what is deemed on the hearing, yes.
Yes. So would you agree with me that in the final protective order for cause number 3691, the box is checked for appeared in person and pro se and announced ready?
Yes, I believe that's part of the court's file.
Okay, but isn't it true that Ms. Butler did not announce ready for that?
I don't
protective order trial?
recall.
Well, what do you need to be able to recall it?
I don't recall every word that was spoken. We had a full docket with a lot of things going on.
So Judge, I have an administrative question for you, Judge. I have on an email the reporter's record for that trial. May I give this to the, I guess, email it to the coordinator here so they can, I guess, make a copy of it and send it to you, and I can give Ms. Desky a copy of it?
I don't know why you can't send it directly to me by email with a copy to Ms. Desky.
Because it's on my client's phone. You just want it from that to send it on my client's phone?
I don't care where it comes from.
All right, I'll have her send it.
How long is this document?
It is 114 pages.
Can we just send me one sheet?
I mean, I want to give you a complete record, Judge, but I guess I could, I mean, I don't know how I would pull out one page of it, like the part about what I'm asking.
Maybe we could handle it this way. What if you read into the record the relevant language from the
Okay.
reporter's record, and if there's no objection from opposing counsel, I'll treat that as evidence. Hello?
I'm waiting to hear the response of opposing counsel, Judge.
Judge, I'm trying to look through my files to see if I have it as well.
So, Ms. Jones, what you can do once they locate a copy of the document is you can tell her what you, by page number, line number, what have you, what you propose to read.
All right, I can sort of was in the flow of my examination, so I can, I mean, unless she opposes what's in the official court's record, I can read it in, Judge.
I just need to make sure it is a complete picture of what was said. What page are you looking at?
I'm looking at page 4, lines 12 through 17. In the reporter's record, cause number 3691.
And I believe that a more complete picture would go through page 5 and line 4, in which the court responded.
So, Judge, may I read it?
You may, and opposing counsel can respond with additional portions of the same document for optional completeness.
Yes. So,
Read,
the court,
read what you want now.
starting at on page 4, line 12. The court. And Ms. Butler, are you ready? Ms. Butler, well, no, sir, because I haven't had time to hire counsel. My attorney and I, we only paid for the other case. That was, we were hoping to be heard today and not this one. The court, she told us she wasn't representing you. Ms. Butler, no, she's not. No, she's way too expensive. I'm going to hire a different attorney for this one. Ms. Deskey, Your Honor, this was filed on June 2nd, the court, that's what I'm looking at. Page 5, starting at page number 1, I'm going to proceed with the hearing, ma'am. The record will reflect that Ms. Butler is here pro se without an attorney. And that's through where, Judge, that's through where Ms. County Attorney Deskey wanted me to read to. But I submit the relevant portion to the question that I asked her was, which did my client, isn't it true my client did not announce ready, was said on page 4, line 14.
All right, Ms. Deskey, did you want to offer some additional portion?
Just, Your Honor, Judge, lines 9 through 11 were the state announced ready. And then otherwise I have no objection.
All right, then I'll consider all of that dialogue just read into the record.
So after your review of the transcript, isn't it true, Ms. Deskey, that Ms. Butler did not announce ready for the August 15th hearing?
That's what it would appear.
And to be clear, the court record that's being discussed right now is a reporter's record from August 15th.
Yes, Judge. Isn't so?
You may proceed.
So when you look back to the final protective order for cause number 3691, so would you agree that the part of this order that's checked that says announce ready is false?
Sorry, I have to look at that. Yes, I'm not sure who. Yes.
So it's your testimony that you did not check the appeared in person and pro se and announce ready. You did not check that.
No, ma'am, my testimony is I don't recall who checked that. Could have been me or it could have been anyone. I'm not sure.
So did I just hear you say you could have checked that?
I could have or I could not have. I don't recall.
Let's move on.
Before you ask your next question, reporter, are you doing okay or do you need a break?
I'm doing all right, Judge, but thank you for asking. I can go a little bit longer.
Okay.
So isn't it true, Ms. Deskey, that on August 15th of 2022, that I, Jolanda Jones, did not participate in that hearing on cause number 50, what is it? 3691.
That is correct.
Isn't it also correct that I advised you that, to my knowledge, well, you would agree that we had a hearing set in cause number 3546 on August 15th, correct?
I believe so. The docket sheet reflects it.
Okay, so yes, we were set in Wilson v. Butler on August 15th. Yes.
Yes.
Okay. And I announced ready to go on August 15th. Is that not accurate?
I believe so.
And I told you in the court, before the court, that from what I knew, Ms. Butler was prepared to go forward on cause number 3546. Is that accurate?
I don't recall what you told the court that day.
Okay. Isn't it true, Attorney Deskey, that a PO hearing is quasi-criminal?
Not from my understanding under the law, ma'am. It's a civil matter.
Ms. Deskey, would you repeat your answer?
Not from what my understanding that it is a civil matter, not criminal matter.
And in the hearing that was set on, well, in the hearing that took place on August 15th, that is cause number 3691, isn't it true that that was pending in the 335th?
I believe it was.
Can you check?
I believe the district clerk filed it in the 335th. We don't determine courts.
I didn't ask you that. Isn't it true it was pending in the 335th?
I do believe so, yes.
Isn't it true that there are no transfer orders from the 21st Judicial District Court to the 335th Judicial District Court in cause number 50691?
It's true, there's no requirement. I
Objection
believe the courts are
non-responsive.
set up.
So
Not
we
that
may,
I'm aware of.
hang on. Let's try to get this matter out of our way. These cases are not cases like family law cases that are pending in courts of continuing jurisdiction. In counties like Burleson, well, in any county where there are multiple district courts, the judges can freely exchange benches and make rulings in each other's courts. So the fact that one of the cases before us is in the 21st and another one that we're talking about is in the 335th is of no legal significance, in my opinion. In other words, I fail to see that Judge Campbell did anything wrong by taking action in a case that had been filed in the 335th District Court. If you believe differently, Ms. Jones, explain it to me.
So, Judge, I actually do believe it's different. Now, again, let me be clear. I only know about Ms. Butler's case I'm terrible with numbers, in 3691, to the extent I believe it overlaps with my case and the judge and the county attorney, right? But showing, but the service documents and every pleading in the caption says the 335th. The final protective order, Judge, says it was ordered in the 21st. I do believe that to be legally significant.
Explain why.
Because it was filed in the 335th, you have to have jurisdiction. What I would say is, where is there something that says that if something is filed in one court, it can be heard in another court? Because Judge Campbell is the judge for the 21st Judicial District Court. Judge Corbett is a judge in the 335th Judicial District Court. And I've seen no documentation filed transferring it. I've seen an order filed, Judge, where you were assigned to this from your 270, I think you're in the 272nd, not certain what county, but in the 272nd, where you were assigned. And I literally, my 27 years of practice, and I practiced in small towns. Yes, I've heard of visiting judges. If a visiting judge is visiting in, say, Angleton or whatever, but not that you have the authority to preside over a court that you're not the judge over. And the final order in 3691 says it's in the 21st Judicial District Court, and it's not. It's in the 335th.
So isn't that plainly just a ministerial error?
No, I don't believe so. Because before you could, judge, before you could preside over this, you had to be assigned, I guess, to preside over it in the 21st. I do not believe it to be ministerial. Now, let me be clear. This issue with 3691 is being handled by my client's other lawyer. And as I said, I've talked to her about how this is just one other example of how Ms. Butler is not being treated fairly. But I will say I was absolutely prepared to go to trial on August 15th, and the judge refused to preside over that case in the 21st, which that case was set in the 21st, and instead went forward on a case that was set in the 335th on the same day that we were pref set. We were pref set from that day because there was on June, I think it's June 24th, there was a whole thing, Judge, when I objected to the case being moved because I had already started cross-examining the applicant, and the judge stopped it on his own motion. And there was a big to-do about why he stopped it. And no, I didn't want to move forward. I'd already prepared. My witnesses were here. And the judge says, we can't do it. We don't have the capacity. So I'm going to—
Wait. The dialogue I was interested in trying to have here is whether there's any legal significance to Judge Campbell presiding over a case pending in the 335th District Court.
I believe there is.
And now we've morphed into some complaint about why he chose to take up the 335th case on August 15th instead of your 21st District Court case. So
yes, Judge, I
don't want to get the two matters confused.
Well, I don't want.
Then there's the third issue that you have raised, and that is the fact that the judgment signed in the 335th case mistakenly records that it's in the 21st District Court.
I never have alleged that it was mistakenly in the 21st court. I've never said that.
Oh, well, then perhaps you think that there's something malicious about it.
And I didn't use the word malicious either, Judge. I just believe that Judge Campbell did not have jurisdiction to preside over a PO hearing that was in the 335th. That is always what I said. Those are my words.
Okay, so the reporter is not confused. You're using the term PO, which is your abbreviation for protective order.
Yes, Judge. Yeah, not the other PO. I'm sorry.
When I hear your use of the term PO, it sounds like you're saying appeal, but I know what you're saying. All right, so I'm gonna time out. We're going to conclude this hearing sometime today that we're in right now.
Yes,
we're
Judge.
going to finish it today.
Yes, Judge.
But the county attorney represented to me at some point that she was supposed to be in Abilene at some point this afternoon. So, Ms. Jeske, when do you anticipate you have to leave for that?
Fairly quickly. I have a 4 o'clock hearing on a family law matter. But with the court's permission, I will be traveling by myself. I can prop my phone up in my car and continue.
You can't do that.
Yeah, I can. I do work calls in the car all the time.
All right, let's wait a minute. Is there such a thing as an assistant county attorney that can stand in for you for the balance of this recusal hearing?
he doesn't handle protective order, but
Well, this is not a protective order. This is a motion to recuse.
yes, yes, sir. I talked to Mr. Brennan about it.
I'm sorry, I'm not
We do have
understanding the
an
witness. I'm
actual
not
docket
understanding
going
the
on
witness.
today as well.
We're losing you. I'm sorry.
Sorry. I apologize. I am in my jury room, which obviously does not have any phone plugs because they're not supposed to have phones in here. Anyway, I can certainly do so by phone, maybe with not video myself. I can ask Mr. Brennan to step in this afternoon as well, whatever the court would like for me to do. Also, Judge Corbett's on the docket today, on the bench today, if we need some clarification over the statutory where they can sit for either judge.
All I know is that we're going to finish this today. And if you can appear by telephone in your car safely,
Yes, sir.
I'm okay with it.
Judge,
But as far as you testifying as a witness and needing to have access to documents, I want to get that part over with. So, Miss Jones, continue with this witness.
so isn't it true that there is no transfer document of cause number 3691 from court 335 to court 21?
Not that I am aware of.
Well, would you have been the person who would do that?
I think she's answered your question.
I guess, Judge, I'm struggling with questions that are like simple yes or no answers, and then there's explanation.
Well, I've already ruled that there is no legal necessity for a transfer document to be signed between these two courts.
I didn't realize that was a ruling.
Well, it is now.
Okay. I'm reviewing my records, Judge. Ms. Deskey, is it not true? Isn't it true that we had begun a hearing on August 15th? We had begun the PO, the final trial hearing in cause number in cause number 3546.
As I recall, yes.
Isn't it also true that you direct examined Cassandra Wilson in that hearing? Is that accurate?
Yes, I did.
Isn't it also true that sorry. Isn't it also true that at the time that the hearing was stopped on the judge's motion, that I was cross-examining Cassandra Wilson?
I believe so, but I'm not sure, and I don't have the transcript in front of me.
Do I need to get you that?
Just a moment. Where were we? I believe on page 24.
Where on page 24 are you directing?
Believe it says so on 15 and 16. It overruled an objection of yours and then reset the hearing.
Okay, so isn't it true that Ms. Wilson testified that she'd never been around anything aggressive related to my
I'd have
client?
to require I'd have to review the entire transcript.
Can you do that now?
Well, I would object to the relevance of the judge's motion to recuse.
It's absolutely relevant because it goes to what the judge did in trial related to his bias or prejudice against my client, Miss Butler. And when the applicant testifies that she has never seen anybody so aggressive or dangerous, and then I start cross-examining her on her third-degree conviction for aggravated assault with a deadly weapon, that's absolutely relevant to the impeachment of that witness. And the
From
judge
30 years.
I'm not finished, Judge.
Okay.
And the judge interrupting my cross-examination of the applicant at a very crucial time when she opened the door for impeachment to her criminal convictions is absolutely relevant. I think the timing of the interruption of the hearing goes to whether the judge is biased or prejudiced against my client, because the judge didn't do that when you were direct examining her.
If you recall, this is a stalking protective order, not a family violence protective order. And if I recall, it was 30 years in the past that she had an assault charge. Yes, ma'am.
So it's absolutely relevant because she opened the door to it. She testified in an effort to get the protective order granted against my client that she never had anything so violent done in her life. So if I have a criminal conviction for aggravated assault with a deadly weapon that your client cut somebody with a box cutter across her face, that goes directly to impeachment.
I would disagree, ma'am.
Hang on a moment. So the basic point is that you are complaining of Judge Campbell making the ruling that he made that's been discussed here.
Which ruling, Judge?
The ruling that you're referring to, the one saying, cutting you off, in your words, from continuing the cross-examination of the complaining party.
Yes, at a crucial time. She just lied. I caught her in it, and then he stopped the hearing and said, we're going to move this.
Okay, I overrule the objection.
So,
As to relevance.
thank you, Judge. So isn't it true that after Cassandra Wilson had testified that she had never seen anything so violent or aggressive towards her, that I asked her about her criminal conviction for aggravated assault with a deadly weapon, which is a third-degree felony, whereby she cut a woman's face with a box cutter because she thought the woman was messing with her boyfriend. Isn't that true?
I'm trying to read back through the transcript now. I'm sorry, do you have a page number of the transcript where she says she had never seen anything so violent?
You have it. I'm just waiting for you to look through it. But I can tell you that on page 24, which is the page you brought reference to at line 6, any objection to me reading what it says?
Well, no objection. It's the transcript.
Okay. So, well, let me start at the top of 24. You objected that, your words, Your Honor, I'd object to stuff that's more than 20 years old. I've not seen any judgments or sentences or anything like that.
I'll skip down to line 15 on page 24, where after, because your client had opened the door to it by her testimony, the judge says, I'm going to overrule your objection. So the judge overruled your objection.
Correct.
Okay. So would you, and would you agree that after the judge overruled your objection, the judge said on line 16, the next thing I'm going to do is I'm going to recess this case. This is not going to be a short 15-minute hearing. It looks like it's going to take all day. So I'm going to take care of other matters and then we'll come back to this. So we'll stand in recess on this case.
Yes, he recessed.
Okay. So going back, right when I was cross-examining Cassandra Wilson on her criminal conviction for aggravated assault with a deadly weapon, 3rd-degree felony, range of punishment 2 to 10 years in prison, up to a $10,000 fine, is when the judge stopped the hearing.
According to the transcript, yes, I don't recall what else might have been going on in the courtroom at the time.
So hold on. I'm looking through something. And let me see this, find this. In the transcript, you said you have the transcript for the PO trial in the Morris case?
Okay, I'll have to switch transcripts. I'm looking at the Wilson case. Yes, I do have a copy.
Would you agree that the court says in the ruling in cause number 3691, says the court is of the opinion something's going on, and then goes on to grant the protective order based on one event?
I disagree. It was one event.
I'm trying to pull it up on the transcript. Let me read it. Can you look on page 64 of that transcript, of the transcript of the hearing for 691, last three, on line 6, would you agree that it says the court? Well, the court is of the opinion something's going on, and I've got to hear and decide on one thing, and one thing only.
I don't believe it says one thing only.
I'm sorry, it says, I'm sorry, it's small. Well, the court is of the opinion something's going on, and I've got to hear and decide one thing. And one thing that I will bring everyone's attention to is if you made a big deal about not having a Black Lincoln. Do you see that part?
In May, yes.
Yes, in May. I'm sorry, I left off in May. Isn't it true that the court made its ruling on in the cause number ending 361? Is that 391? I'm sorry, 691, based on one occurrence?
No, it is not, but that is the matter up on appeal right now.
Well, but I'm talking about this hearing that happened. This has nothing to do with the appeal right now.
No, ma'am, it was an incident in November and another one in May.
I'll get back to that. I've got to actually now go find it in the transcript where it talks about the one occurrence. So is it, look at page 64. Line 12.
Yes, ma'am.
Isn't it true that the only event that the judge made his ruling on was the event that happened in November? And specifically, line 12 says the court, the event was in November.
No,
So
ma'am, if you read the whole,
it says, so the event was in November. So there, Ms. Butler says the court says the protective order will be granted. Do you see that part?
yes, ma'am, but if you read the entire transcript, there was testimony on a May issue and a November issue. She contested the one issue, never contested the other issue. And so the court ruled on the two issues on the stalking protective order.
Is it not true, if you look at page 60, starting at line 13? They say, she's saying that back in May that I swerved my car near her when, Your Honor, I didn't have my car because her car was in the shop. And I'm sorry, I added the cars in the shop. That's not in the transcript, but I digress. She's saying that back in May that the car swerved near her when, Your Honor, I didn't have my car in May. Do you agree that it says that? Page 60, lines 13 through 15.
On her testimony, yes, but there were other people's testimony that disagreed with that.
Yes, but hold on one second. Okay, so I'm sorry. Okay, so this happened, her testimony happened during the hearing on April 15th when Miss Butler was without counsel. Is that accurate?
That would be August 15th, not April 15th.
Yes, ma'am, August 15th.
I believe she was pro se that day.
Yes.
As far as I am aware, no one filed a notice of appearance in that case in my file.
Right, and before that hearing started, Miss Butler said she was not ready. Is that accurate?
I don't recall exactly what she stated. She said she had prepared for a different hearing, but they were both set.
Right, but I don't agree that they were both set, but the transcript says what it says, that she was not ready. And so she went forward for a hearing that she wasn't ready on, and she contested the May date, correct?
I'd have to look back through it. I don't remember if it was November or May date that she was contesting, but there was testimony of two different dates.
Right. So you started off in this hearing contesting two separate dates. Is that accurate?
Yes, ma'am.
May and November of, is it 21? May and November of 2021. Is that accurate?
I'm looking. May was 2022.
Okay, I'm sorry. So May of 2022 and November of when?
2021.
Okay, so we've got a date, May 2022. We've got a date, November 2021, that you brought for the protective order in that case.
Yes, ma'am, a stalking protective order.
You would agree that Miss Butler asked for time to hire a lawyer prior to this hearing?
I believe her wording was she hasn't hired a lawyer yet.
She told you she wasn't ready. She wanted to have a lawyer for this hearing. Is that not true? Is that not what the transcript?
Ma'am, all I can recall is what you've read from the transcript. I don't have an independent recollection of that
You
hearing.
haven't- So you don't have the transcript there? I thought you had the transcript.
Yes,
there.
ma'am. Is it the one that you've asked me and I've answered a bunch of times already?
It's the one, I just want to be clear that Miss Butler, and now let me direct you to where to look in the transcript. Maybe that'll make it easy.
Yes, I believe it's on page 414 through 18, right after the state announced ready and she had been served.
Right, so it says that she hasn't had time to hire counsel, she's not ready. And she wants to hire counsel. Would you agree that that's what she asked for?
I believe it said she only paid for an attorney in the other case and was hoping that one would be heard, not this one.
Right, but she said isn't that true that she said she was gonna hire a different attorney for that case? For the 691 case?
I believe that she was, yes, I believe on line 20, it says so.
Right, so you brought to May 2020, I'm sorry. So you brought forth two allegations, May of 2022 and November of 2021. Is that accurate?
That's the two I proceeded on, yes.
Yes, and you would agree that protective orders require more than one occurrence? Is that?
On a stalking protective order, yes, it's one or more.
No, it's more than one occurrence.
Yes,
So it requires more than one.
yes.
Okay, so would you agree that had Ms. Butler had the opportunity to hire a lawyer and prepare for a hearing, that Ms. Butler could have had evidence to show you that at least one of those occurrences, she literally did not have physical possession of her car?
I disagree. She brought witnesses to that hearing that testified to certain things, and the court, as the trier of fact, weighed the evidence.
So isn't it true that the witnesses that Ms. Butler presented were not witnesses, actually they were witnesses she brought to testify in the case that we were actually set for? And that's why they were there?
I have no idea who her witnesses were on what case.
Okay. So would you agree that she contested at least one of the occurrences in that protective order hearing?
Yes, ma'am.
Okay. So isn't it? Hold on. Isn't it true that the extension of the protective order that we talked about, hold on, let me find it. I'm gonna direct you to the second order to extend temporary ex parte protective order, resetting hearing on protective order that was signed on July 29th. Isn't it true that Ms. Butler was never served with this extension of the temporary protective order?
I don't know what the clerk's office does.
Can you check?
No, ma'am. I'm in this hearing. The clerk's office is upstairs and down the hall. She would have been there when the resets were announced.
So this motion that you filed, I direct you to the second motion to extend temporary ex parte protective order and motion for continuance. Miss Butler was not present in the court when you filed that motion on, what day was this filed?
I don't recall.
But it's an ex parte motion. So are you saying to me that this motion was served, this motion to extend the temporary ex parte protective order motion for continuance? You're testifying that this motion was served on Miss Butler.
No, ma'am, I testified that I don't recall.
So, and you're telling me, or are you telling me that this second order to extend temporary ex parte protective order, you're resetting hearing on a protective order, Miss Butler participated in the hearing to extend this order, this temporary protective order?
Ma'am, it's my testimony. I don't recall.
Is it ordinary for you to, once you receive, let me see something. So with the second motion to extend temporary ex parte protective order and motion for continuance, that document, you already had a temporary a temporary ex parte protective order against Ms. Butler. Isn't that accurate?
Yes, ma'am.
And it was going to expire. Isn't that accurate?
Yes, ma'am. When a hearing date is passed, we have to extend it.
So that wasn't the question. So isn't it true that it was going to expire? If it did get extended?
Probably.
Okay, so before the temporary ex parte protective order expired, you filed this second motion to extend temporary ex parte protective order and motion for continuance, and you did not give notice to Ms. Butler.
I testified that I don't recall if she had notice or she did not. I don't recall.
So let me ask you this. What do you need to do to find out whether you noticed my client for the fact that you were going to try to extend the temporary ex parte protective order? Do we need to take a recess and you go get it?
Let me ask, is this
I am
germane
working
to,
off-
just a minute, is this relevant to the motion to recuse the judge?
Yeah, yes, Judge, it is. It is relevant to the motion to recuse the judge because there are a series of actions by this county attorney and by the judge in signing orders and participating in hearings that show that my client is either biased or prejudiced against her. They're extending a temporary ex parte protective order with no notice to my client. The judges are ruling on them with no notice to my client, which sets dates for other hearings where they say she's supposed to come to, and she has no idea that there's a hearing set. So these two motions are absolutely germane to the August 15th hearing. Absolutely.
And Your Honor, she never filed an answer. She was properly served in June.
That's not the point, Judge. The
All
point
right,
is,
hang on. I'm not going to interrupt this hearing to order this witness to go find evidence that supports your contentions about lack of notice. If your client has knowledge that she was not served and she wants to present that, then she's more than welcome to. But let me point out that Rule 18A about recusal of judges says that the grounds must not be based solely on the judge's rulings in the case. So I'm trying to understand how the failure of the system or the judge or the county attorney to give notice to your client of this new ex parte order extension could form the basis of a recusal.
Well, yes, Judge, this isn't the only basis, Judge, but if the hearing went forward on August 15th, and they say my client was noticed and my client was not noticed of August 15th in that cause number, then she was forced to go to trial when she had no notice. It's absolutely germane to it. And this isn't based on one occurrence, and that's my point. One thing, I mean, if you lie once, are you a liar? Probably not, maybe not. Or if you lie twice, if you lie 5 times, then maybe you are. And this was a compilation, which was why it was so hard for me to file it, because I have to figure out whether my client can get a fair shot. But if my client doesn't know, and we've got judges, whether it's Judge Corbett, well, in most of the instances in this case, it's been Judge Campbell making these rulings.
Okay,
and for my client to go forward when she wasn't noticed and she wasn't prepared to be able to fight that she wasn't noticed because she wasn't noticed. She didn't bring anything for that. So it's absolutely germane to whether my client is given a fair shot in any of these.
We will see. Press on with your examination of this witness.
Yes, thank you. So on the second order to extend temporary ex parte protective order and resetting hearing on the protective order, isn't it true on that document, it orders that a hearing is now set on August 15th, 2022 at 9 a.m.?
Yes,
Okay. And isn't it true that you don't have any notices, any kind of receipts to show that this document was served on Miss Butler?
I have nothing in my file to say that. The court sends out notices. And the clerk.
Don't you direct the court to send out notices in hearings related that you're responsible for?
Ma'am, I don't do the docket. I don't handle the district clerk's office.
Okay. So you don't have any records in your file to show where you noticed Miss Butler of a hearing date on August 15th of 2020.
Correct.
Okay. When the court notices attorneys or parties in a suit on e-file Texas, don't you get a receipt of that?
I get a copy of the docket every week, as do all attorneys that are on there.
Objection non-responsive. When a document is served by you, when an order is served, is it not true that when service is made to all parties, you get something from via email, at least that's how I get them, via email, that the document was served, and then you can go click on the link and see what document was served? Is that not true?
If whoever files it hits the button for e-file and serve.
Okay, so you don't have anything from e-file and served that this document was served on Miss Butler, do you?
Unless she has an email with e-file Texas, it wouldn't be on there.
Objection non-responsive.
Overruled.
Is it not true that you do not have in your files a document from e-file Texas that Ms. Butler was served with that extension of that temporary ex parte protective order?
Unless whoever filed it added me as well, I would not have a copy either.
But I'm not asking you that. I'm asking you, do you, in your files, do you have a copy of anything from e-file Texas that shows that the second order to extend temporary ex parte protective order and resetting hearing on protective order was served on Ms. Butler in your file?
No, ma'am, unless she had filed an answer with an email on e-file, she would not be listed on that service.
I'm going to ask you again. Do you have in your files?
No.
Receipt. Thank you.
You're welcome.
Did you give notice to Ms. Butler that Judge Campbell was acting as a visiting judge in the 21st for the 335th?
He was not a visiting judge. He is a sitting judge in both districts, as is Judge Corbett.
Objection non-responsive.
Overruled.
Statutorily.
The question is, did you give any notice to Ms. Butler that Judge Campbell was a visiting judge for the 335th?
I cannot answer that because he is not a visiting judge. He is a sitting judge.
Okay, look, we're not going to quibble over the fine points in that question and answer.
Judge,
We know he was not a visiting judge. And we know these benches are interchangeable between these two lawyers. There's a local rule to that effect in Burleson County. And so whether he gave notice to your client about his status in one court or the other is of no significance.
would you agree with me, Ms. Deskey, that if Ms. Butler did not receive notice of that extension ordering her to come to court on August 15th in cause number 3691, if she didn't receive that, then she would not have had proper notice to have to go forward on August 15th. Would you agree with me on that?
No, I disagree that she didn't have notice.
That's not the question. Objection non-responsive. Would you agree with me
No,
that if
ma'am.
Ms. Butler, may I finish the question?
Sure.
Would you agree with me that if Ms. Butler did not receive notice of the August 15th setting, then she was not afforded due process and being forced to a hearing on August 15th? That's if she did not receive notice.
I just agree she didn't receive notice, so I have an answer.
But I'm not asking you that. I'm asking you, would you agree that if she was not served with a document that tells her that she has to be in court on August 15th, that she would not have had sufficient notice and that violates her due process rights under the Constitution, both US and Texas Constitution, to be forced to go forward with a hearing on August 15th if she was not noticed?
No, ma'am, I disagree. Actual notice.
I'm sorry?
She had actual, so the manner and method is not relevant.
So let me be clear. So are you testifying? Are you testifying that on July
on July 26, 2022, that there was a hearing in this court on cause number 30691?
I would have to look at the transcript for that particular day.
Transcript, what transcript?
I don't know. If you're asking me what occurred in court particular day, I have to look at the transcript.
So is it your testimony? Because you did say that Ms. Butler had actual notice of the August 15th hearing. So in response to that, my question is, on July 26th of 2022 is the day that you filed this second motion to extend temporary ex parte protective order and motion for continuance. Is that accurate?
I believe so.
And is it your testimony that you served this on Ms. Butler? Yes or no?
No, ma'am. I answered. I did not personally serve her with it.
Okay. Did you have someone else serve her with it?
Not that I am aware of. That
Okay.
piece of, ma'am.
Oh, okay. So on July 29th of 2022, on the date that the second order to extend temporary ex parte protective order and resetting hearing on protective order, is it your testimony that Ms. Butler was there in person when this order extending it to August 15th was there? It's your testimony that she received actual notice of this on July 27th because she was there?
I don't recall if she was in person or not.
So when was she given actual notice?
I have answered every time that we said that she was there.
I didn't ask you that. On what day did Ms. Butler receive actual notice of the second order to extend temporary ex parte protective order and resetting hearing on protective order? What day did Ms. Butler receive actual notice?
I don't recall.
And is it your testimony that either that you through some method gave her actual notice?
Do I remember exactly on this particular case? No, ma'am, but we usually reset the dates with the person in the courtroom on anything that I do, including criminal defendants.
So your testimony is that Ms. Butler signed a reset in person in the courtroom to
No, ma'am.
August 15th. I'm not finished. So it's your testimony. You just testified that you reset people with the person in the courtroom. Did you not just testify to that?
Sometimes we do. I don't always.
Okay, well, but you made it seem like you did that with my client. So
No,
I'm trying
ma'am,
to
I did not.
Okay, so it's not your testimony that Ms. Butler was in the courtroom on July 29th, 2022 to sign an actual reset for this order.
No, ma'am, we do not do resets on civil matters. Those are under criminal matters unless it is an actual trial, not a hearing.
Okay, I'm confused. So you're saying that this was a criminal matter?
No, ma'am. I have a docket. I have criminal, civil, CPS, and juveniles all on the same day. And then there are private civil matters that come in as well. I don't know how they handle those.
Okay, so I'm just trying to figure out where the actual notice occurred. So I got to ask you these questions. So where would the documentation reside that would show the actual notice to Ms. Butler?
I'm not aware of what other people in the courtroom keep documentation of. I have nothing in my file. I don't know if court.
So if you don't have any documentation of actual service, is this your testimony that in your office, you do not have any documentation of actual service, of notice to Ms. Butler for actual service for this reset, for this extension to August 15, 2022? Nothing in your office?
Nothing written in my office. Correct.
Where would that information be? How would I find it?
I don't know, possibly a court reporter, a district clerk, a court coordinator. They all make their own notations.
So, but how do you prove, I guess my question is, how do you prove that my client had notice? On your
Well,
word?
she was there.
So you're testifying that my client was in court on July 29th of 2022?
No, ma'am. She was there on the August 15th hearing.
Right, but that's on July 29th, when her case was moved until August 15th. Where's her notice of that?
I have no written documentation of notice within my file.
Okay, so how would somebody, if you don't keep good records, how would somebody be able to prove where the notice was?
And I would object to if I don't keep good records. There are several departments within the courtroom that keep their own records.
So my question is this. The question is, did my client have notice of the August 15th hearing or not? So if you don't have documentation of it, where would it reside? You're the county attorney, right?
No, ma'am, I do not supervise the district clerk's office. I do not supervise the judge's office. I do not supervise the court reporter's office. I do not supervise adult probation. I do only my office do I have responsibility for. There is nothing in my file showing notice.
Right. Is it not your obligation as the county attorney prosecuting Andrea Butler to make sure she gets noticed of hearings? Are you telling me that's not your job?
No, ma'am, we usually do that through the e-file system when they file an answer, and we have the ability to let them know. Yes, ma'am. Otherwise, we generally, in general, do it in the courtroom while the person is present to check calendars.
Was there a court setting in court on July 29, 2022 in cause number 3691?
I would have to look at the docket sheet, and I don't have access to those. That's the court coordinator and district court's office to be able to access old dockets.
So you have no, so where might, since I need to obviously go try to find this, where might I find proof that my client was noticed of the August 15th hearing? So if you don't have
Again, ma'am, I don't know any other departments or their manners or their methods of anything. I have no knowledge of that.
But I didn't, so you have no knowledge of where I might look if you don't have it to find out proof that my client was noticed of the August 15th hearing. In cause number 3691. Your testimony, I just want to be clear. Your testimony is that you don't know who would give Ms. Butler notice for the August 15th hearing. Is that what you're telling me?
No, ma'am. That's not what I testified to. No, ma'am.
What did you testify to? Let me ask the questions so I can make sure I understand. Would you agree that you filed this motion for extension?
Yes.
Okay. Would you agree that you have a copy of this order extending it to August 15th?
Yes, ma'am.
You have that. But you do not have, and again, you are the prosecuting attorney. You do not have in your records proof that you served my client with this notice of change.
There you, I'm sorry, you froze for a moment.
Okay, I'm sorry. So you do not have any documentation that Ms. Butler was served notice of this August 15th, 2020.
Just a minute. I have heard that question now at least 5 times, and I have heard the answer 5 times, and we're not going to continue to plow that ground.
Judge, may I respond?
My
Why would-
client, I'd like to
No,
respond.
no. I don't want a response. If you want to search other offices about evidence of the notice of the July 29 hearing, you're free to do that. But this hearing cannot be prolonged any longer on this narrow question with this witness.
Well,
And I don't need a response to that.
but I'm respectfully disagreeing that it's not important, that it's not germane, and that it's narrow.
I did
Because
not,
notice-
hey, whoa, I did not say it's not important. I just said we're not going to burn up any more time with this witness because you're not getting what you want. And I know what she said, and I know what you've asked. So it doesn't need to be asked or answered again. That's all. Now, housekeeping. Everybody involved in this probably needs to take some kind of nourishment at the noon hour. Lawyer I'm sorry, Miss Desky. Keep
Yes,
wanting to
sir.
call you by another last name. You have got yourself in a position where you've got a hearing 240 miles away this afternoon. Is there any way you can get relief from that so we can finish this matter?
It has to do with my being in CPS custody.
I didn't hear what she said,
I'm-
Judge.
I'm sorry, I could not understand you.
Yes, sir. It has to do with my daughter CPS care and trying to get her moved with family.
You just blanked out again.
Sorry, it is a special setting having to do with my 4-year-old granddaughter in CPS care and getting her moved.
So are you one of the attorneys in that case?
No, sir, I am the grandmother that the court has asked me to appear. Sir, if I can make, I'm sorry, Stephanie, I mean, I could ask my assistant to ride with me with the files.
Do you have to physically be in Abilene or could you appear there over Zoom?
No, sir, they don't have Zoom and they don't have the ability up there. I asked. Believe me, I don't want to drive to Abilene and back today.
Well, I sat for a district court in Taylor County on a case that had every single hearing by Zoom. So I think that if we adjourn for the noon hour,
Yes, sir.
you could make a call up there and explain your circumstances and see if you can't get permission to do your appearance either by Zoom or over the telephone. I know they've got telephones there.
Yes, sir.
Are you appearing before one of these?
It is. It's an associate judge that only does those matters.
Correct. They've got an associate judge there full-time, just does these CPS cases. And I know who she is. I just can't call her name. I handled CPS cases in 3 counties for 10 years. That's not exactly accurate, but for 10 years, I had a CPS court docket. And we routinely let people appear by telephone. And then when Zoom came around, we allowed that. Glad to do it. I'm sure she will be glad to do it.
Okay, I will
So-
make that happen.
If you can't get her on the phone, then you can call the CASA volunteer on the case or the
Yes, sir.
child's lawyer and find out the information.
Okay. Yes, sir.
In the world we're in, there's no reason for you to have to drive 500 miles in a day for a court hearing. I understand the importance of grandchildren. I understand the importance of CPS involvement.
Yes,
But
sir.
surely what you need to work out can be handled this way. All right. So counsel, does anybody have an objection to us adjourning for say an hour and a half to give everybody time to do what they need to do, come back at 2 o'clock. I could also make it 2:30 if you wanted.
Whatever you'd like, Judge. We'll make it happen.
So Judge, may I say this, if Miss Deskey has to try to resolve some stuff, I literally could be back in Houston in 2 hours, and then I can continue this from my office. Because right now I've kicked some very nice lady out of her office so that I could have access to her office.
Okay, I don't have a problem adjourning for 2 hours.
No, sir.
So, and then we'll come back it's 12:30 right now. So that
2:30,
will-
2:30.
I should be able to be back in Houston by then. I should. This is like an hour and 45-minute drive.
Right. Ms. Brown, how about you? Are you available at 2 o'clock and beyond?
Yes, sir, I am. Thank you for asking. Yes.
All right, so,
As fast as we can.
Ms. Deskey, you may need to communicate with me about your issues.
Yes, sir. If you'd like, I can. McNichol.
No, we don't need to have it filtered by a court coordinator. I'm going to give you a telephone number and you may call me directly. And I may then generate an email to everyone. But this is an administrative matter, perfectly
Yes, sir.
okay, so that nobody gets excited about this. I want to know whether you've been instructed by the court there that you've got to go, or whether you're going to be available in person, one way or the other. And perhaps you can generate an email to me and to Ms. Jones to communicate that. I'm not saying you have to talk to me by phone. Okay?
Yes, sir. I'll make it work.
Yes, I'll say if she gets your number, I want your number.
Well, you just heard it, didn't you? Did I give it?
No, you
No, you
didn't.
didn't give it.
You did not give it.
You said
right, here-
email, sir.
You both got my email. Here's my phone number in case you need to reach me. And I
Okay.
don't have a secretary or anybody else to filter this through. It's 979-219-1100. 979-219-1100.
Thank you, sir.
Thank you.
Now, if you have to get on the road, then you have to get on the road.
Okay.
You have my permission to do that,
Thank you.
but you need to be available by phone, like you said. And if we can't make that work out in the boondocks of Central Texas en route to Abilene, where there are multiple dead zones, I'm not sure what we're going to do. We'll cross
I will
that
make
bridge.
it work.
We'll cross that bridge when we get to it.
Thank you, Judge.
But I would very
Thank you,
much
Judge.
like to get this motion resolved today, if at all possible. Okay, all that said, we're due to reconvene at 2:30 on this
Thank
same
you,
Zoom,
sir.
on this same Zoom hearing.
Thank you.
Okay. Thank you.
All right, good day.
I think it's like yesterday.
Should I mute it?
Yes, definitely.
Hmm. Beth, I saw your email today with the forwarded email forwarded from Ken. Period. With the invitation to the mediation via Google Meet. Period. I am involved in another court hearing that will resume at 2:00 and be going the rest of the afternoon, I'm afraid. Period. If you need me to take a break to answer a question, I'll have my phone on to get a text or a call. Period. Beth, if you need to get in touch with me today, feel free to call or text. Period. I'm in a Zoom hearing myself. Period. We're in a noon break now to resume at 2 p.m. Period. I'll be happy to take a break in my hearing to answer your call. Period. Hmm. Vicky, can you hear me?
Yes, Judge.
I told him we were resuming at 2:30, right?
Yes, 2:30, yes.
Okay.
Okay, see you then. Yep. Okay.
Yeah. Who said that? You. Yeah. I'll look at, pull those into one PDF instead of. That would all have to do is add that front one. And we will come to this meeting tomorrow. So that's supposed to be that work. But you'll have more people. Yes. Oh, yeah.
You know, when you're not gonna be there. The judge heard the questions there to answer. There's first word. Other than that, and I don't get what happened or why it was silent. I wish I knew a little bit more. That was just like some serious.
Well, I think she's the. Activist type, you know, she's the. I think she's helped some, yeah, I think she's been like on the, if I remember right, she's been on the Houston City Council. So. I think she has. I should just figure out from someone.
So.
Who's over there?
It has half. They're not. It's not in the wrong court. If that's your big hurdle right now, that's a non-issue. And the judge stated it's not an issue. And now it seems like you're issue to notice, like. You're not gonna get that out of this one, so it's not. It's. It seems like. From, we showed up, she had 2 cases, our procedure online.
And then why don't you do both?
They just called me a case.
Oh, we're not okay.
And she wasn't represented, she said she was. And then they move forward anyway. That doesn't seem fair.
Yeah.
You know, not know why they did that. Maybe there were other reasons.
Mm-hmm.
Maybe it didn't happen that way, but if it happened that way, that's enough.
Yeah. I think she's already in the House of Representatives, actually. Sworn in May, but this isn't the, you know, they don't meet for 30 years. And with that special election. They only meet every, Texas legislature only meets every. Right, and that'd be January, but she was sworn in May, so it all sounds like, I guess maybe she won the election. That could be that. It may not be right now, you know, where it runs up in January.
Maybe she won.
Yeah. I think she's in almost a very, very, Republican.
Maybe she should have. She's as close to a legislative session. That was her thing.
Mhm. Good unfortunate survivor Kaleo, police. Third person film was from 8 to 11, she was a member of the Eastern City Council, school board member in the Early Pittsburgh, Texas. In 16, she appeared in the reality series Sisters in Law, focused on civil rights. Jones is openly lesbian, though she was once married to an abusive husband. And advocate for LGBT causes and domestic violence. She became the first black member of the LGBT elected. Special election, Bishop Steve retired. The Garnett Coleman.
So she didn't unseat a Republican.
No.
So she's a. She kind of gets, it's not rude, she kind of gets excited, like, oh, sorry, you know, when we raise her, she respects the ring.
Yes. Oh, she knows, she definitely knows her corporate form.
Mm-hmm.
You can, I can tell this by listening, I know
Yeah.
this. Heptathlon athlete, which is women's equivalent of the, men's, like Bruce Jenner was, the decathlon. They only competed, you could see 5 or 7 of them, 17.
But it should be called the
Well, yeah, the men's is decathlon, the women's is heptathlon.
Oh, you did say it.
Wow.
It's proof that it's not bristles. It's like squeaky fire.
Oh, yeah.
And it's like, from the footage they're showing, it's like, well, yeah. That might be. It's like, what are we doing with brooms? Okay, there's the broom.
Mhm.
But what are we doing? Always in the leaves. I watch all of it. Watch
Genius.
it. Yeah, but watch it. It's everything, instead of leaving, like, look at that, I got everything.
Yeah.
So why doesn't someone come up with this sooner? And why
Yeah,
don't we use some
exactly.
brooms? I
So
mean, that's,
they are, where's that faster?
that's a thing of beauty right there.
One like.
Mm-hmm.
Sure, there's one right there.
Stop now.
Mhm. Unless I stop you here, which I do.
Looks like. You have to replace it. To try to save. Yeah. Still fascinated by it.
So did you say yes to a baseball cap? Up there. Oh, they're probably like $35. And that in your time. It's probably was on cap advertisement. More than anything else.
I think last, I think that's what I think. Pleasure to make perfect.
Yeah. Let me do some research and see if I can see any. All right, we put start. When I put water in,
Usually I say that. Just one sure.
no,
Trying to
that's
get clarification.
what I used to do. I stir it. Right. Smooth. Ooh. Oh, yeah. For the smooth, yeah.
She's in now, so she don't have to stay with you. Check on her, she's not gonna like it. Check on her, have 3 hours go by. I mean, she's fine, I'm just saying.
Yeah, she's usually pretty quiet when she moves around.
All
Keep her down.
Yeah.
Ms. Brown, you probably ought to mute.
It looks like I got moved off. Can't.
Huh? Finish, right.
Hi, is the judge on? I can't tell. I'm driving. Is the judge on yet?
Yes, I'm here.
Judge, I'm still driving. There was just traffic, unfortunately, and I forgot some documents at the courthouse, and the staff is kind enough to call me and tell me I forgot them, like my code and stuff I was using for the hearing. So I turned around and got it. So I'm still driving. So I sent an email. Actually, I had Sean McLaughlin, who's sitting with me, to send an email to ask if we could start at 3, because I'm not in my office. I'm not going to be at my office by 2:30, but I think with the way the traffic is going, that I'll be there by 3 o'clock. But I don't feel comfortable driving, trying to conduct the hearing, especially when I need to look at my notes that I've made in preparation and to take notes about the answers. I don't feel safe. I can't speak for Ms. Deskey. I don't even want to look down at the phone because I don't want to take my eyes off the road. But I'm in Houston. I'm in Houston vicinity. There's just traffic in places. I mean, you got to pass by the Galleria. I don't know if you're familiar with Houston, but yeah.
Okay, you think you'll be ready to go at 3 o'clock?
I think so. I didn't stop to get gas yet, and I'm on E. And I guess I'll eat stuff out of my fridge once I get to my office, but I haven't even stopped to get gas, and I'm on E. So I think that I'll be ready by 3. Yes, Judge.
All right, Ms. Deskey, where are you? Ms. Deskey, can you hear me?
Yes, Your Honor.
Where are you?
I am in my conference room trying to get this set up.
Okay, so you are still in Burleson County?
Yes, sir, I am.
So Ms. Jones just signed on and told me that she hadn't gotten to her destination yet and wants to reschedule for 3 o'clock. Do you still have to participate in the hearing at 4?
They are going to, and I will be able to participate by phone, and I asked someone to text me if they are going to need me, and then I would ask for a brief recess. But I spent the lunch break filing a written report with as many parties as I could get a hold of.
Okay, so we will adjourn until 3 o'clock.
Thank you, Judge.
And Ms. Jones, if you haven't gotten there yet, we'll stay together until you're ready, but
Yes, Judge. Yes, Judge.
I implore everybody to use their best efforts to resume at 3 or quickly after, okay?
Yes, Judge. Like I said, I haven't even stopped to get anything to eat or get gas because I'm just trying to get back.
All right, then.
Thank you, Judge. May I be excused?
Of course.
Thank you.
Thank you. Sorry, I got to figure out how to do my video on my laptop now. No, video settings. Video, original video.
You are not muted. You might want to do that.
Thank you, sir.
I'm getting my stuff together. I just drove up. I'm getting my notebook out and stuff like that. I just wanted to make sure I was here on time. Please. Judge, I don't know if you heard me. I just got in. I'm unloading stuff in my office and get my notebook
Yes.
out. I just wanted to make sure I was on time.
Heard you. All is well.
Okay, Judge, I think I'm ready.
Ms. Deskey, are you ready?
Yes, Your Honor.
All right, let the record show that we are back reassembled via Zoom. Both attorneys are present and the defendant, Andrea Butler, appears to be present. So, Ms. Jones, you still have the witness, Ms. Deskey.
Yes, Judge.
Proceed when you're ready.
Yes, Judge. May I have the court reporter read back the last thing we were on?
Let me go back through our discussions just a moment.
The last note I have is that you ask if, in fact, the July 29th order is false, where it recites that Ms. Butler appeared and announced ready.
Okay, I can pick up there, Judge.
Okay.
Judge, may I proceed?
Of course.
Thank you. Ms. Deskey, have you had a chance to look at your files to see if you found any evidence of service to Ms. Butler related to the August 15th hearing?
During the recess, I had to do a couple of pleas and file a court report in Abilene. So no, ma'am, I have not looked at my files.
Okay, so Judge, I'd like for you to take judicial notice of the Burleson County Clerk's file of the second order to extend temporary ex parte protective order and setting hearing on protective order, as well as the second motion to extend temporary ex parte protective order and motion for continuance. And why don't I do this for I guess clarification purposes on the record? The motion, and this is all in the clerk's file, Judge. The motion to extend, I'd like to just mark as exhibit 1, and this is for judicial notice of that in the clerk's file. The order to extend, Judge, I would like to be exhibit 2. And then in the clerk's file, there is an email from Rochelle Wilson in the clerk's file related to the order dated Friday, July 29th at 1:09 p.m. I'd like that to be exhibit 3, defense exhibit 3. I should say respondents exhibit 3. There is also, Judge, in the clerk's file, an automated certificate of e-service that tells who was served with that order, which was exhibit 2. And also, Judge, there is, I'm not certain what this document is called. Oh, these are just the fees I paid for the certified records. I don't think those matter. So I'd like the court to take judicial notice of the clerk's file in cause number 3691, specifically the motion to extend being defense exhibit 1, the order on the extension being defense exhibit 2, the email from Rochelle Wilson being defense exhibit 3 about that order signed by Judge RTC, and the automatic certificate of e-service being defense exhibit 4.
So are you offering those exhibits into evidence?
Yes, Judge, I am.
Any objection?
I'm not sure what exhibit 3 is, Your Honor.
It's the email from Rochelle Wilson,
On what particular date?
July 29th.
Sorry, we're checking our file, Your Honor. Ms. Jones, was there an attachment to that file?
No, the only thing in the file is the motion, which is 1, the order, which is 2, the email from Rochelle Wilson, which is 3, and the automatic certificate of e-service as exhibit 4. That's it. That's all. That's all. Those are all the documents in the clerk's file, Burleson County clerk's file related to that order.
Okay. And so can you tell me if the email refers to attached here is the motion, the order?
So the email says attached, you will find a copy of the second order to extend temporary ex parte protective order and resetting hearing on protective order.
Then I have,
I'm sorry, I didn't hear you.
I have no objection.
Okay, thank you.
All right, so I don't have physical possession of exhibits 1, 2, 3, and 4.
So I asked when I was there, I asked the nice lady, I can't remember. I asked her to email it to you.
Oh, well, I may have it.
I mean, I didn't mark it as exhibits yet because I just got it, but I told her what I would need for her to get to you.
So after what time would that email have been sent to me?
You know what, Judge? It was before I left Burleson County because I had to go there, so I'm not certain when she would have done it. I have a receipt for payment at 12:46 p.m., but I'd actually spoken to her before that. because she had to walk over, I guess, to whoever certifies official records. So, but I wasn't really looking at my clock watch.
Well, I don't have them at the moment.
Do you, I don't have her number.
I don't have her number.
I don't have her number, Judge. Is there any way you could call her and ask her to send them? Because she pulled them out. She's the one who pulled them out. I don't have her phone number.
I'm not going to stop and phone her up. So I'll say that exhibits 1 through 4 that you've just described are admitted, and we'll worry about the inclusion of them in some record on appeal if necessary later. Go on.
Okay. So, Miss Deskey. On, where'd it go? So on Defense Exhibit 4, there's an automatic certificate of e-service. That's status as of 7/28/2022 at 2:01 p.m. Central Standard Time. It says the people that were served were Stephanie C. at email ssee@burlesoncounty.org. And that was timestamp submitted at 7/28/22, 10:06, 10 a.m. It was actually sent to her twice. And then there's one that says Susan R. Deskey, S. Deskey @burlesoncounty.org, sent at 10:06 a.m. on 7/28/2022. So do you, County Attorney Deskey, this has already been admitted. Are you denying that you received this e-service?
I can't admit it tonight because I've not been served what you're talking about. I do have things in my file, but I'm not sure exactly since I've not seen your exhibits. I will admit there was an e-service on 7/28/2022 with Miss C and myself on it.
Okay, so I will say I haven't seen that. But Judge, what I can do on this, because I just got back and I only have one copy of the document. Whenever we take the break for Ms. Deskey to go to the hearing, I can try to have my staff, scan it in so that I can publish it, if that's okay. And so you haven't seen this, Ms. Deskey, but I do not see where Ms. Butler was served from the official court file. And if you have any evidence to show the contrary of that, I'd like to know about it.
I do not.
Okay. And I would like to, the judge mentioned the local rules. So are you familiar with the local rules of Bastrop, Burleson, Lee, and Washington counties, Ms. Deskey?
I don't have the rules in front of me.
Are you familiar with them?
I don't have them in front of me. I know they exist. I cannot quote from them.
Great, Judge. I'd like to enter into evidence and have judicially noticed the Supreme Court of Texas miscellaneous docket number 14-9114 dated June 9th, 2014, which when you go on the Burleson County website, it has this document as the local rules by which to follow in this court. So
I've seen it. I'll take judicial notice of it. Doesn't require admission as an exhibit.
Okay, thank you. So I would like to refer the court to, this is Exhibit 5. I would like to refer the court to page 8
contested hearings. 6.14.
All right, bear with me a minute.
Yes, Judge, I'm patient.
Say again the page, please.
Page 8, under contested hearings, section 6.14.
All right, I read it.
And so Ms. Deskey, did you cause to be delivered to Ms. Butler as a pro se party a copy of the setting request, moving it from, I think, June 3rd until August 15th?
Believe I've already been asked and answered that.
I'm sorry, Ms. Court Reporter, can you remind me what her answer was? Because I don't believe I asked that specific question.
I think she's referring to earlier testimony where she said that she and her office weren't responsible in Burleson County for issuing setting notices. That was something that either the clerk or the court coordinator would handle.
Okay, thank you, Judge. You have a way better memory than me.
Well, let me
So-
confirm. Is that what you're referring to, Ms. Deskey?
Yes, Your Honor.
All right. So let's read what 6.14 says for fairness. It says the attorney or party filing the setting request shall cause to be delivered to all attorneys of record and all parties pro se in the case a copy of the setting request. The original setting request shall be retained with the original papers in the court's file.
Okay, thank you, Judge. Now, Ms. Deskey. I would ask you on August 15th of 2022, explain to me why the hearing in cause number 3691 went forward.
I can't answer that. That was the ruling by Judge Campbell.
I'm sorry, I didn't understand you.
I said, I can't answer that. That was Judge Campbell's ruling.
So was there, well, but you requested, you were seeking relief in that hearing for Miss, I don't know who the person's name, for Morris, weren't you?
I was in every one of the settings on that case, whereas this was a reset. It was not an actual setting. The first setting was served with her in June when she received those papers.
Okay, but I'm asking, was there an emergency that existed in order for the hearing to go on August 15th?
I announced ready for everything that my office is ready for. It is up to the judge to make a ruling on that. We were ready to proceed.
So, but my question is, was there a bona fide emergency that existed that required that the hearing take place on August 15th?
That would be a question for Judge Campbell since it's his ruling.
Was there any special attention required to have that hearing on August 15th?
Again, ma'am, that was Judge Campbell's ruling. And I wouldn't hazard any type of guess on why he ruled the way he did and when he did.
So did you contact the judge? Did you contact the judge to ask for a special hearing on August 15th related to the case that was set for the 335th?
No, ma'am, that was just the actual settings from the reset of the previous settings.
So you did not contact the judge for the hearing to go forward?
No, ma'am, I do not set court dates. The judge or the court coordinator sets the court dates.
And so does that mean that you didn't ask the judge on this particular 8/15/22 court date for cause number 3691? You didn't ask the judge to consider that matter?
I'm not understanding your question. Could you please repeat it?
Yeah, let me try to explain it better. So for the cause number 3691, 30, 6, not for that case, for the Morris case, you did not contact any judge that had jurisdiction and ask them to consider the matter?
I did not ask for a particular date. The court coordinator or the judge sets the particular dates.
I think if I understand this line correctly, the gist of your question is whether this lawyer or somebody acting for her asked Judge Campbell to take up the Morrison case or Morris case over the Wilson case on August 15th.
Yes, Judge.
No,
Okay.
Your Honor, the state announced ready for both cases.
All right.
So Judge, I'd like to just to have read into the record on page 15.
Of what?
I'm sorry, of Exhibit 5, titled Ancillary Proceedings, Temporary Orders and Emergency Matters, 7.13.
Your Honor, I've not seen that particular item, nor am I aware if that was the last one that was filed on the court. I have not seen what she's talking about.
What
What exists.
This is the local rules.
Right, but I don't have it in my hands.
I'm
Well,
gonna read it.
Neither do I. You can get it on your computer screen. Here's what it says. 7.13. In the event a bona fide emergency exists or a matter requires special attention and the judge of the court where the case is pending is unavailable, the attorney or party seeking relief shall contact any judge who has jurisdiction, and the judge can consider the matter, but the case shall remain in the court originally filed.
And so my answer would be an application for a protective order in and of itself is asking for a serious issue and relief.
In any case, do you disagree after the judge's reading, Ms. Deskey, that the local rules are mandatory and not discretionary, specifically that the attorney seeking relief shall contact the judge? Are you disputing that?
Well, let's pause here a minute before we get caught up in too many formal words. What is your point that you're trying to make about 7.13?
So my point that I'm making, Judge, is that in order for Judge Campbell to be able to preside over the case number 30.691, certain things had to be done by Ms. Deskey, which she didn't do. So first of all, there was supposed to be a bona fide emergency. Ms. Deskey said there was not an emergency. It also says that the matter has to require special attention. Ms. Deskey said that there was no special attention. And she said that she didn't contact the judge, namely Judge Campbell, to see if he could consider it. And also at the end, it says that the case shall remain in the court originally filed. The order on this case was filed in the 335th. I'm sorry, this case was filed in the 335th, and the order says the 21st court.
I think you ought to move on. I don't see that this has any application to the point you're trying to make about Judge Campbell taking up one case over the other.
So
it has no relation.
Judge, as I read these local rules, these rules say there's only under certain circumstances where a judge can sit over in another jurisdiction. It doesn't say you can just do it. It says under ancillary matters and temporary orders and emergency matters. This was not a temporary order case, Judge. The temporary ex parte order had already been issued. So it wasn't that. The only other way for them to do it is for it to be an emergency matter. And the matters that needed to exist, Ms. Deskey already said they didn't exist. So I actually believe it to be germane to whether Judge Campbell could preside over this hearing that was out of the 335th. Further, Judge, there was a preferentially set motion on 30.546, which is Wilson versus Butler, that was pref set on August 15th. And the judge did not preside over that. So I think it's absolutely germane to whether Judge Campbell had whether he even had jurisdiction. And he certainly didn't have jurisdiction to change it from the originally filed court.
Look at local rule 3.10. I'll read it.
Okay.
The courts may at any time exchange cases and benches to accommodate their dockets or to expedite the court's trials pursuant to order affecting the exchange of benches for the district courts and county court at law of Bastrop County, Texas. The district judges of the 21st and 335th district courts may also exchange to accommodate their dockets or to expedite the court's trials.
So, Judge, I don't disagree that 3.10 says what you just said it said, but nowhere in 3.10 does it say you can change courts. And I would respectfully submit to you, Judge, that 7.13 is more specific, and it tells when you can do that under emergency matters. So to the extent that they conflict, rules 3.10 and rules 7.13, 7.13 speaks more directly to what happened, especially in light of the fact that we had a preferentially set hearing on 30.546, and instead the court refused to preside over the pref set case and instead presided over the other case where the requisites for him to be able to do that, where the requisites for Judge Campbell to be able to do that did not happen.
Sorry, we disagree.
Okay. I would also like to have judicial notice, Judge, of the civil docket in the file, which I'll call.
Now, wait a minute. It's either going to be an exhibit or I'm going to take judicial notice of it. It shouldn't be both.
So I'll take judicial notice, Judge.
Of what?
Of the civil docket in case number 30.691.
clarify what you mean by the civil docket.
Well, well, you can't see the docket. It says civil docket. Case, it came from the clerk's file, Judge. I got it before I left. It says civil docket number 3691, Deborah Land Morris versus Andrea Monique Butler. And it's the docket sheet to tell about everything. And I would like to
Okay.
take
You're referring me to the docket sheet in case number 30691.
Yes, Judge, but it's not, well, I know them to be docket sheets, but this just says civil docket. So I'm just reading what the document says.
All right, so how do I access that document?
Before I left, I asked, I can't remember the lady's name. It wasn't Tracy, but it was another lady whose name I don't know. I told her that I would be using these in court, and she said she would email them to you. And then I left. So it's in the court's file. It's the official records of the court's file. And the clerk's file.
Okay, I'll take judicial notice of it. Tell me what you want us to know about it.
To this, that there is no indication of notice to Andrea Butler for the August 15th, 2022 hearing in cause number 3691.
Okay, no notice to Andrea Butler of what, please?
Of the August 15th, 2022 hearing in cause number 3691.
All right, I'll take your word for it for now.
Yes, Judge, when you get the docket, when you get it, you'll see it says it. Just making sure I cover everything, or at least try to. I just want to reiterate that I didn't ask for a reset of this. I didn't ask for a reset. Well, I didn't request that the TXO in 30.691 get moved to August 15th. You don't have any documentation in your files, Ms. Deskey, that shows where I requested that.
Not that I recall.
Judge, I'll pass the witness subject to recall.
Ms. Deskey, do you have any testimony of your own you want to give at this point, or you want to wait till later?
No, Your Honor, from what I understand, this is a motion to recuse Judge Campbell. I can't answer a lot of questions because they're Judge Campbell's rules. I don't know why he ruled how he did. But as far as the docket sheet, I neither generate nor maintain that document, so I'm not aware of anything other than what are papers that I have generated and I've maintained.
All right, let's go on then, Ms. Jones.
Yes, I'd like to call Andrea Butler.
Raise your right hand and be sworn, please. Do you swear the testimony you'll give will be the whole truth, so help you God?
Yes.
Very well. Put your hand down.
Ms. Butler, when on June 3rd, a temporary ex parte protective order was entered against you. Were you in court on June 3rd of 2022?
No, I was not. And I was not aware that there was even a temporary protective order granted on June 3rd of 2022.
Okay, when did you become aware of the protective order that was the temporary ex parte protective order that was was entered against you?
Not until July, whenever we went to court in July. No,
Can
I'm
you look
sorry,
at,
not
can
July.
you look at any documents to help you remember?
To move this along,
Okay, I was
at some point, hang on. At some point, she got notice and she showed up in court on July 29th. Is that right?
June 20th, I'm sorry. I was served and showed up in court June 24th.
Okay.
Yes, sir. I apologize.
Okay, so you showed up in court on June 4th, but that on June 24th, that was not my question. My question was, when did you become aware of the June 3rd temporary protective order?
Well, not till recently. I mean, because I never knew that there was even a protective order in June. I didn't know I had a protective order against me in June.
Well, didn't a police officer come and serve you with something?
Yes, and June,
Okay, when was that?
20th, he served me.
Okay, so you got,
He served me on June 20th.
okay, so you got served on June 20th.
Correct.
And you testified that you showed up in court for June 24th.
Correct.
Why did you show up in court for June 24th?
Well, that's for the for a hearing on the temporary protective order.
Which temporary protective order?
Well, the case, well, for Wilson and Butler.
So you had a notice, huh? So the case that I represented you on, you were going to be in court on June 24th of 2022 for that protective order hearing. Is that accurate?
For our case, if I'm understanding you correctly, June 20th, I was served to appear in court for Deborah and I's case. That's the order that I was served, okay? I was not served for August 15th.
That's not my question.
And when I, okay.
Listen to my question, please.
Mhm.
On June 24th, 2022, you showed up for court. Is that accurate?
Correct. Correct.
Did you have a hearing set for June 24th of 2022 in either of the cases?
Yes, prior, yes, correct.
What case were you set for a hearing on June 24th?
Wilson and Butler.
And that's the case that I represent you on.
That's correct.
Were you prepared? Were you prepared to go forward with the protective order hearing in Wilson v. Butler on June 24th?
Yes, I was.
Had you prepared for Wilson v. Butler on June 24th?
Yes, we did.
Did you bring witnesses to court on June 24th for Wilson v. Butler?
Yes, only Wilson versus Butler case. I sure did.
And did you, without going into anything attorney-client privilege, did you prepare with your lawyer, namely me, for the case on 6/24/2022 in Wilson v. Butler?
Correct.
Okay, so on 6/24, but by 6/24, you had been served with the Morris case.
Yes.
Did you know, did you believe that you had to be ready for trial in that case on June 24th?
No, or I would have been. No, absolutely not.
Why do you say absolutely not?
Because I don't go anywhere unprepared. So absolutely not.
Okay. So did a hearing happen on June 24th of 2022 for the Wilson v. Butler case?
It was attempted,
What does that mean?
meaning like we were ready, we announced ready, we had our witnesses. The judge asked if we were going to be 15 minutes, and which the DA said she could do it in 15 minutes, which I don't see how. When they had about 12 witnesses, there was no way that you could have spoke to each witness within a 15-minute time frame, including myself and my witnesses.
So, so you didn't answer my question. Can you just listen to my
sorry.
question and just try
Ask me
to
again.
answer my question narrowly? So did a hearing start in Wilson v. Butler on June 24th of 2022? Did a hearing start? Let me rephrase it. Did Ms. Deskey call any witnesses? On
She did.
6/24? Okay. So who did she
She
call?
did.
Who did she call?
Cassandra Wilson.
Okay.
Cassandra Wilson.
Okay.
So yes,
she-
the hearing did start. Yes.
Miss Butler, just please listen to my questions because you're talking about other stuff, okay? I'm trying to make it easy. So did Ms. Deskey ask I'm not asking what questions. Did Ms. Deskey ask Ms. Wilson any questions?
Yes, she did.
Okay. At any point, did Ms. Deskey stop asking Ms. Wilson questions and pass the witness to me?
She did.
Okay. Did I begin asking any questions to Ms. Wilson?
Yes, you did.
So when I began asking Ms. Deskey questions, if you recall, what questions was I asking? Well, first of all, did the judge stop the hearing?
The judge did stop the hearing.
Okay. Was I finished questioning Ms. Wilson?
Wilson. No, you were in the middle of questioning Ms. Wilson when you were interrupted.
Okay, so if you recall, what questions was I asking when the judge interrupted my questioning, my cross-examination of Ms. Wilson?
About her criminal background.
Okay. After the judge interrupted my questioning of Ms. Wilson, what happened next?
He said that it would need to be set on a date that he said, this is not going to be 15 minutes. I'm going to need a full docket to hear this case. So he said that he would set us on a day that he did not have any other people coming in.
So do you recall the word preferential setting?
Yes, those were the exact words.
Okay, did you understand what preferential setting meant when you heard it?
No, I didn't. I was unsure at the moment. So when you and I went to the back, I asked you, I said, well, what does preferentially set mean? And then you broke it down and explained to me what it meant. So I was like, oh, okay, so that's good. We'll have a full day so that way we can get through all of the witnesses that they brought, which is about 12 different faces, and then my 4 witnesses.
Okay, so is it fair to say that when I got interrupted cross-examining Ms. Wilson, that I was in agreement with stopping in the middle of my cross-examination? Do you remember anything about that?
Yeah, you were not in agreement. You were wanting to go forward.
All right, and did I verbalize that to the court?
You sure did. Very clear.
I'm sorry, I didn't hear you.
Yes, you were very clear that we were ready and we want to continue and move forward, because it's costing me each time you came down, each and every time you came to Burleson County, it was costing me. And so you asked if we can move forward, and the judge would refuse to move forward because it was not 15 minutes.
So when you found out that we were stopping, over my objection, were you concerned about whether the hearing on August 15th would like have the same outcome as this one, specifically that we would start and then it would stop? Were you concerned about that?
Very concerned, because to me, it felt like they were now given time to go and sorry, I don't know the word I'm looking for. They needed more time to re-prep for trial. It's like, go back and retrain Cassandra, go back and let me tell her what to say and what not to say. So it wasn't fair for us, especially when they announced ready and then we announced ready. And then when you were cross-examining her, which she was sitting on the stand lying, lies after lies after lies, and then we get stopped. So no, it wasn't.
So at no point did I say, okay, Judge, we're just gonna do this. And I agree with it.
You did not
So-
agree with it.
Okay. So we get set for August 15th. Did you have any notice of a hearing for cause number 3691 Morris v. Butler? Did you know that case was set for August 15th?
Absolutely not. We were supposed to be preferentially set. From my understanding, a clear docket, just Wilson versus Butler, not Butler versus Morris, not anybody else, just Wilson and Butler. That was my understanding, because if I knew that I was going to go forth August 15th with Miss Morris and myself, I would have been prepared. All my evidence that I submitted with my appeal case, I would have had it ready that day. And I told the judge loud and clear that I was not ready to move forward that case. I had not got my evidence together. I really hadn't had time to even look over it, because we've been prepping for our case with Wilson and Butler. So I hadn't even had time to look over the documents.
So were you in court? Were you in the Burleson County Courthouse on July 26th of 2022?
I don't know. July 26th, I was not in court. I only remember being in court June 24th, August 15th, July 26th.
Let me ask you this. Are you familiar in preparing for this hearing today? Did you have the opportunity to see what we're calling Defense Exhibit 1, but the second motion to extend temporary ex parte protective order and motion for continuance that we talked about earlier today? Were you able to see that document?
Okay, ask me that question again and slower.
Are you familiar with the document that the motion to extend that temporary protective order that was entered against you on June 3rd? Did you see that document on July 26th of 2022?
No, ma'am. I didn't see any of these documents that were submitted me for that case. The only document I've seen and was handed was the paperwork to appear in court on June 24th. And that was it. I was never received any notice. I didn't even know I had a protective order against me. So no.
Okay, so you were not in court. So did you sign a reset on that second motion to extend the temporary order? Did somebody get you to sign a reset or something saying you would come back?
No.
Okay.
No, ma'am.
Did you receive anything in the mail saying that you have to come to court? So you weren't in court.
And the courts have my email, and the courts have my address. The courts have every which way possible to reach me. I'm not hard to reach here in Burleson County.
Okay, so you heard testimony about you being
actually served notice of this hearing on August 15th of 2022. Did you receive any actual notice of that?
No.
We also have an exhibit that's Defense Exhibit 2, which is the order that actually extended your temporary ex parte protective order that was signed on July 29th by Judge Corbett. Do you remember testimony about that?
Okay, repeat that question again.
There was an order that extended your temporary protective order that they put on June 3rd. There was an order that for you.
For which case? Wilson or Morris?
Morris. So on the Morris case, let me just try to help you get where we are because I'm using legal terms. On June 3rd, a temporary ex parte protective order was entered against you, but you didn't know about it. Is that accurate?
Correct.
On June 20th, you got notice that you had a temporary ex parte protective order entered against you. Is that on June 20th of 2022? Is that accurate?
Correct.
Okay, and how did you get notice of that? How did you get notice?
I was served.
By who?
The constable served me.
Okay. For this order, extending the temporary ex parte protective order, did you get served by a constable on that one? Telling you had to be to court for August 15th?
No.
Okay. Did you give me permission? First of all, did I represent you on cause number 3691 on Morris v. Butler?
No, you didn't. You let the clerks know. I told them, not the clerks, I'm sorry, the courts know. I told the courts you were not representing me, so absolutely not.
So, did you receive an email noticing you of your court setting on August 15th of 2022 for case number 3691 Morris v. Butler? Did you receive an email notice?
No, ma'am.
Did you receive actual notice?
No, ma'am.
I'm sorry. Did you receive actual notice of the court setting in cause number 3691 to come to court on August 15th? Did you receive any kind of notice?
I didn't receive any notice, any email, phones, text, a tap on the shoulder. I received no notice, none.
So you heard testimony by Ms. Desky saying you received actual notice. Is that true?
Correct. She was correct. She was, and from what I remember a couple hours ago, she said that I would have been served in the courtroom, which was not true either, because I wasn't even served in the courtroom.
So were you in court on July? Were you in court on July 29th of 2022?
July 29th. No, we were not in court July 29th.
So you weren't in court July 26th?
I can't remember. You mean June?
No, I mean July. When the motion and order was heard and signed, were you there to receive actual notice of either the motion, which is Defense Exhibit number 1, or the order, which is Defense Exhibit number 2?
No.
On August 15th, there was a hearing.
Correct.
I want to go back to that
Yes,
day.
correct.
I want to go back to that day. On August 15th, you had court. Is that accurate?
True.
Why did you believe you had court?
Because I was given notice through my attorney that I had to appear in court on August 15th for a preferentially set date for Wilson versus Butler, not anything else, anyone else.
So on August 15th, you show up at court. Is that accurate?
True.
And did you show up with witnesses?
I did. That were ready. Yes.
And did you prepare with your lawyer, me, for that setting?
We did.
And announce ready to proceed.
Yes, ma'am.
When I advised you that we were not going forward on the August 15th, what, if anything, did you say? I'm sorry, not going
I mean,
forward on the Wilson v. Butler case.
Mm-hmm.
Were you confused?
I was, because we were ready, and that date was supposed to be ours. I was ready to get that over with and get it behind me. We were ready.
So the court didn't preside over the Wilson v. Butler case. I for the record, after the court dismissed the Wilson v. Butler case, did I leave Burleson County?
Correct, immediately, to get back on the road home.
So was I there when you had your hearing?
No, you were not. You didn't even walk back in the courtroom. You told me in the witness room, hey, they're calling you. And that was it. And you left.
So when you went into the courtroom, what happened? What did you tell the court about your preparedness for a hearing on the Morris v. Butler case?
Okay, well, first I want to say I was extremely confused because I thought I was going home right behind you. So then when I walked into the courtroom, it was a different case, Morris versus Butler, that was brought to my attention. And I clearly stated that I was not prepared nor ready to go forward. Absolutely not. And even though the DA knew you were not my attorney, she asked me, is Miss Jones going to be representing you? And I said, no, because I know you heard when she told you she was not representing me. And I'm telling you again, she's not representing me. I don't have an attorney for that case, and I'm not ready to move forward. I made that clear.
And did you want to try to hire a lawyer for that case?
I did. I was really hoping the courts would reset it so that I could have time to hire counsel for that case and then move forward with that case, not go in blindsided.
And so there was some testimony about sharing the same witnesses. Think back to the Wilson v. Butler case. You and I never talked about the same witnesses in preparation for either the Wilson v. Butler case or the Morris v. Butler case. Is that accurate?
That's completely accurate. And I can tell you this, the witnesses that were there for Miss Wilson's case were not the exact same Wilson's witnesses that was there for Miss Morris's case. The only witness Miss Morris had was her husband, who really wasn't even a helpful witness, but he was the only witness that Miss Morris had. And they did not have the same witnesses. Absolutely not.
So was there ever a representation made by you that the witnesses in the Morris v. Butler case and the witnesses in the Wilson v. Butler case were the same witnesses? Did you make that representation to anybody?
No, ma'am. As a matter of fact, those witnesses that were for Wilson's case went home when our case was dismissed. They did not stay for Miss Morris's case, so they were not the same witnesses. That's false information. That's just another lie that's been put on record. That is not true.
So let me just make sure I got this. So when Wilson v. Butler got reset on August 15th, then the witnesses that were there for Wilson v. Butler left and did not participate in the Morris v. Butler case that you went on, or that you were forced to go on. Is that accurate?
Okay, let me say this so that I'm very clear and it's not misconstrued. The witnesses, whether they left or went to the restroom or went to lunch, wherever they went, they were not called forward. They did not have any parts of the Morris versus Butler's case. They were only the witnesses for Miss Wilson's case and my case, not Miss Morris's case and my case. They were not the same witnesses.
Okay, let me, I want to go back to something in the Wilson v. Butler case. When the judge, before I was dismissed and I left, the judge asked us about a date in the future. There was testimony earlier by Ms. Desky that we all pulled out our calendars to see when I was available. Do you remember that testimony?
I do. I remember her saying that.
Okay, so do you recall that I was running for the general election when that happened? Do you recall that?
Mm-hmm.
When the judge asked me about a date moving forward, did I tell him I didn't have anything available until the election, and then after I got elected, I wouldn't have anything available until after the legislative session? Did that come up?
That's exactly what you told him.
And share what you remember.
Well, okay, so this is what I remember about that particular day. When Judge Campbell interrupted our case and said, well, we're going to go on to another date, move the case to another date. It was moved to another date, which you were not. It was more of an agreement with Judge Campbell and the DA. It was not an agreement with you, Judge Campbell, and the DA. So with that being said, you were in Colorado on business for state rep, and we were not able to make it to that date. So it was another, I mean, if they want to call it miscommunication, but that's not what I'm going to call it.
Do you recall the judge saying to me that I better find a date because he wasn't waiting till after the session? Do you recall that?
Yes, he did.
And do you recall me telling the judge that since I ended up having an opponent in the general election, and since I ended up winning a special election, that I had, for the most part, reset my docket till after the election. So all the cases I had during the election cycle, that I was full, like I didn't have any availability. Do you recall that?
Yes, I do.
Okay, and do you recall me emphatically telling the judge that I had no time to do a hearing, and that therefore, if we didn't go forward on August 15th, that I would not be able to do anything for almost a year later? Do you recall that?
I do recall that, but the judge was not trying to hear you. He was fainting in his chair. He was throwing his head back. He was just, he wasn't trying to hear anything we had to say, honestly.
Do you recall the judge telling me that I wasn't that busy?
I do. Yes, ma'am.
Do you recall the judge ordering me to pull out my calendar and figure out when I could come in? Do you recall that?
Correct. Yep.
Do you recall me? And all this stuff happened after the judge interrupted the hearing, correct?
That's correct.
Do you recall? Do you recall?
Excuse me.
Yes, Judge.
Up until you said what you just said, I thought you were referring to the date of August 15th.
This is August 15th, Judge.
Well, but you then said the judge cut me off and wouldn't let me finish the hearing. That was-
So you know what? I confused them. So you're right. I take that part back. When we got, I confused them. So on August 15th, when we did not go, this isn't the interrupted hearing, right? This is on August 15th, the prep set hearing. After the judge said he was not going on August 15th, the prep set, do you recall me trying to employ the judge to please let's go on that date, because it was the only time I had to do it where I didn't have any conflicts? Do you recall that?
I do. And I was praying that the court would move forward and allow me my right to my day in trial, especially since it's costing me. This is costing me not $175 and a $25 serving fee. This is costing me thousands of dollars. Financial stress, financial drain. It's causing me.
Do you recall the judge ordering me that I better find a date because he was not going to wait until after the session ended? Do you recall that?
Those were his words. Yes, I do recall that.
And
Clear as day.
And so, do you recall me telling the judge that I knew from my own calendar that I could see in front of me that I absolutely had nothing available before the election? Do you recall me saying that?
That's right. You stood up and you told him. That's correct.
Do you recall me after the election? So the judge was like, okay, fine, let's get past that. Do you recall me telling the judge that I had a number of obligations that I knew I was going to have to do? I couldn't tell exactly, but that all of my cases that I had reset during the election all fell after November 8th, which was the election, and that I didn't have any availability. Do you recall that?
Yes, ma'am.
Do you recall the judge, despite that, telling me that I better pick a date? Do you recall that?
Yes, ma'am. Yes, ma'am.
Do you recall me telling the judge that the only day I might be available where I think I maybe can move something is November 17th? Do you recall that?
I do.
After I was forced to pick a date.
That's correct. And it felt like to me, well, it didn't feel like it. I seen it. It was more like, we're going to just keep pushing this off, and maybe she'll show up the next time in court without an attorney, and we can slap another protective order on this innocent woman. So that's what it was like for me. That's what it felt like for me. They would rather me show up without an attorney.
Do you recall, before I left, do you recall that I told the judge that it was going to take, the hearing was going to take at least 2 days, maybe more? Do you recall that?
Yes, ma'am.
Do you recall the judge?
And he said,
I'm sorry?
Yes, ma'am. Yes.
Do you recall the judge telling me that if we had to stay there till the middle of the night, we would stay there till the middle of the night because we were going to finish it on November 17th? Do you recall that?
That's true. Yes.
What's true?
Your statement you just made that we were going to stay in court. He said even if it ran over to 2 a.m., we were going to stay there and get through that case because it was not going to take 15 minutes. And he was refusing to even give us, like a break, come back the next morning. He says, if we got to just stay here all night, then that's what we'll do. Those were his words, Judge Campbell's words.
So the testimony you heard earlier about how we just pulled out our calendars and we all agreed that I would be available on November 17th, is that accurate?
I'm sorry, ask that question again.
I said, so the testimony you heard Ms. Desky testify to that we just pulled out our calendars
and picked November 17th, and I said I was available. Is that accurate?
That's not accurate. No, ma'am.
So
As a matter of
when,
fact, the date wasn't even set when we were in court, so that's not accurate.
so when it was obvious that I had to pick a date, and I gave them November 17th as the only date that I might be available. Do you recall us going back out in the witness room?
Yes,
And do you recall me going into the witness room, just trying to explain to you what just happened?
correct.
And did you think what happened to you in court related to the case that I'm hired on, Wilson B. Butler? Did you think that it was fair what happened?
Definitely not. Definitely was not fair. Absolutely not.
You talked about you could see the judge's actions, that he had issues with you. What specifically are you talking about? In the August,
Well, I can say, yes, August 15th date. I can say that when the DA Desky was questioning Miss Wilson, everything was good and fine. And then
hold on,
once
wait,
it was
because-
our turn,
oh, you're talking about for the hearing that I didn't participate in. You're talking about the hearing. Okay, all right. Okay, go ahead. I'm sorry, go on.
So August 15th, like I was saying, when Ms. Desky, the DA, was questioning her witness, Ms. Wilson, the judge, he was cool and complex and he listened, okay? So then when it was our turn to question Ms. Wilson, that's when the judge, I mean, you can tell his whole demeanor changed. Everything about him changed. Even the DA, she sat next to us laughing, making remarks. The judge sat on his bench, just falling out. He was throwing his head back, rolling his eyes. He wasn't trying to hear it. He wanted it to just be over. He would rather have did me like he did right after that. Just give you this protective order and go about your business. And I do understand that this is only a civil matter, but it's a very big deal for me. Being a single mother of 7 children, I am mom, I am dad, I'm everywhere for my kids. Their tuition has to be paid monthly. They have to have food and clothes on their table and on their back. And this is financially draining me and stressing me out because we keep getting reset. We don't get to have a fair day in trial. We keep getting interrupted. Yet Ms. Desky gets to speak. Yet Ms. Desky gets to ask the witnesses questions. But when it's our turn to speak, we have to be silent. We don't get to speak. We can't have a voice. We get interrupted. We get pushed back. We get moved, even though we were preferentially set. Because I heard the judge say that he was going to preferentially set us. We didn't even get that August 15th. Because when I arrived at the courtroom that day, I called my attorney. I said, Miss Jones, it doesn't look like we're going to be the only ones here today. There's a lot of cars out here. She was like, huh? I said, yes, ma'am. So when I went inside, I walked straight over to the docket that's hanging on the wall before you walk into courtroom. I think B is to the left. It was a full docket. And I said, well, doesn't look like we're the only ones on this docket today. So I don't see how this was preferentially set. So I'm thinking, well, maybe did I misunderstand her when she said preferentially set? Well, no, because I have common sense. I'm pretty smart. We were not given what we were told we were going to give.
So let's go back really quickly to the hearing that we did start on June 24th. How was the judge's demeanor in that? Did he interrupt Ms. Desky when she was direct examining Ms. Wilson?
Absolutely not. No, ma'am.
And when I started cross-examining Ms. Wilson, did the judge interrupt me?
Several times. And then just cut you off altogether. So yes, he did.
So when you participated in that hearing that you were not noticed for, did you do the best that you could under the circumstances?
Now we're talking about Morris v.
Oh, I'm sorry. I'm sorry, Judge. Yes, that's my fault. So we're back to August 15th. In that hearing,
The Morris case.
the Morris case. So in the Morris case, how long did it last?
30, 45 minutes, an hour. It definitely wasn't 15 minutes. It was longer than 15 minutes.
And you heard testimony about how the witnesses were the same. Were your witnesses the same? I'm sorry. You heard the testimony earlier from Ms. Deskey that the witnesses were the same in August 15th for both the Wilson versus Butler case and the Morris versus Butler case. Were your witnesses the same?
My witnesses were the same, yes.
Right. Is that because they were the witnesses that do this for me? Name the witnesses that were sworn in. So were witnesses sworn in the case on August 15th that you went on the Morris case? Were there witnesses sworn in?
Just one witness.
Okay, and who was that witness?
Her husband, Robert James Johnson. Miss Morris's husband, Robert James Johnson.
There were no other witnesses?
No, ma'am.
Okay, let's go back to the June 24th hearing, the Wilson v. Butler. Tell me what witnesses that you identified that were there on Wilson's side. What witnesses were there?
Okay, Michael Kennedy.
Your Honor, I'd object. Nobody ever asked me for a witness list. And as I'm going through a hearing, I have the right to call or not call whoever I planned to use, and that changes.
Judge, may I respond?
Well, I suppose you can offer that testimony, but this is not a time to object. Right?
Are you talking to me or Ms. Deskey, Judge?
Ms. Deskey. You are muted right now, Ms. Deskey.
Yes, sir.
Are you objecting to this witness's testimony on some ground?
I'm objecting to her commentary on what witnesses I used and did not use.
Judge, may I respond?
No, the objection is overruled. Go on.
Thank you. What witnesses, Ms. Butler, did the state, let me go back. Before the hearing on June 24th, in our case, the Wilson v. Butler case, were witnesses sworn in to tell the truth, the whole truth, and nothing but the truth? Did that happen?
Yes, ma'am. Yes,
Okay.
ma'am.
Were there Wilson witnesses?
Yes, ma'am.
Were there Butler witnesses?
Yes, ma'am.
Did all the witnesses stand in front of the judge at the same time?
Yes, ma'am, they did. Every one of them.
Okay. So did you recognize the Wilson witnesses?
Only some. Once I go through and name them, I can tell you which ones I recognize and which ones I've never seen a day in my life. They just found them out of the blue sky.
Okay, so tell me, who were the Wilson witnesses?
Michael Jermaine Kennedy.
Can you spell these names if you know how to spell them?
Michael, Michael. Kennedy is Canady.
Okay, anybody else?
Marquisha Kennedy. I don't know how to spell Marquisha. Kennedy spelled the same way as Michael's last name.
Okay, anybody else?
Okisha Tyndall.
Do you know how to spell Okisha?
No.
How do you spell
names,
Tyndall?
I don't know.
Do you know how to spell
Tyndall?
Tyndall?
Tyndall with a T.
Oh, Tyndall. Do you know how to spell that?
Tyndall. No.
Okay. Who, anybody else?
It's Michael, Marquisha, Lakeisha, Deborah,
Deborah who?
Deborah Morris,
Was a witness in the Wilson case?
correct.
Okay. Who else?
Okay. Even our husband, Robert James Johnson, sworn in that case.
Robert James Johnson was sworn in our
Correct.
case as well. Okay. Who else?
Yes. And then I remember a Priscilla, Priscilla Lopez, if I'm correct.
Okay. Did you know her?
I don't know who she is. I've never seen the lady. No clue.
Okay. Who else?
There was a Denisha Bradley or Deasia Bradley. I'm not sure if it's Denisha or Deasia.
I'm sorry, say it again, ma'am.
It's either Denisha Bradley or Deasia Bradley. I'm not sure the name because I don't know who she is.
Anybody else?
As far as I can remember, I'm praying I'm remembering all right now, but I'm sure there's somebody I'm leaving out because each time that we went to court for Miss Wilson, there was new faces that I've never seen as witnesses. So the faces that we seen August 15th were not the same faces that we seen the next time I'm sorry, the faces that we seen in June were not the same faces I seen in August. There was totally new faces.
So you're saying the witnesses that were going to testify against you on June 24th were not the same people that testified against you on August 15th?
That's absolutely correct. Yes, ma'am.
So let's go back to August 15th. And wait, did I miss out? Did I miss anybody? Let me repeat to you so I can make sure. Let me repeat to you so I can make sure that I have everybody. You said Michael Kennedy. You said Robert James Johnson. You said, did you mention Hazel Fisher?
I'm sorry, I didn't. Hazel Fisher Butler. That's who it was. And Cassandra Wilson swore herself in also as a witness.
Parties are witnesses anyway, Miss Butler.
Okay.
Let's see. So, and you said Deborah Morris, Priscilla Lopez, either Denisha or Deisha Bradley, Hazel Fisher, Cassandra Wilson. Was Cassandra Wilson? Okay. And was Miss Wilson's husband there?
No, ma'am.
Okay. So to the best of your ability, those are the witnesses that raised their hands and took the oath to testify in the June 24th trial.
That's correct. Yes, ma'am.
Okay. And I want to go back to the trial that we started on June 24th.
Okay.
Do you, before we were interrupted by the judge? In that case, if you recall, Miss Wilson admitted, hold on. Hold on. In that case, Ms. Wilson admitted that she had a conviction for aggravated assault with a deadly weapon. Is that true? This was before the judge interrupted me. Okay.
Correct. Yes.
Is it, if you recall, when I was cross-examining her on that aggravated assault. If you recall, she said she was 19 years old and she had a fight with people. Do you recall that?
Right. She said 5 girls jumped her at a party. We were drinking in a party and 5 girls jumped me.
Okay. Do you recall her admitting that she cut a girl's face and neck with a razor blade? Do you recall that?
Yes.
Do you recall her admitting that she hit another woman over the head with a bottle?
Yes. Specifically a beer bottle. Yes.
Do you recall that she said she did it while she was drinking?
Correct. At a party. Correct.
Okay. So, before that line of questioning, Miss Butler, if you remember, do you recall Miss Wilson saying she had never been around anybody so violent before you started stalking her? Do you recall that?
Before I allegedly started stalking her? Yes.
And is that when you recall I started asking questions about her violent past?
Correct.
Okay. And if you recall when County Attorney Deskey objected to my line of questioning related to convictions for her, do you recall the judge overruling her objection?
Yes.
And allowing, okay. And so I continued to ask questions. Do you recall that?
Correct. Correct. Yes.
I then moved on to another conviction she had related to assault, family violence. That was later in time. Do you recall that?
Correct. On her husband. Yes.
Right.
Correct.
And is that about the time the judge cut me off?
Correct.
Now let's go back to the hearing. Let's go back to the hearing on August 15th. So that hearing starts, you don't have a lawyer, you've announced that you're not ready, and there were, when County Attorney Deskey was asking Ms. Wilson about her case, did I hear you testify earlier that the judge just let, that there were no interruptions, the judge just let her get everything out in that case? Is that accurate?
He did, freely. He sure did.
At some point, who cross-examined? So then did you then cross-examine Ms. Deskey?
I'm sorry, you said, did I?
Yeah, did you then cross-examine? That means when you ask questions, did you start asking Ms. Wilson questions?
Yes.
Okay, so did the judge afford you the same leeway in asking questions as he afforded County Attorney Deskey?
Absolutely not. He wasn't trying to hear it. No, ma'am.
What does that mean?
He was ready for it to be over. It wasn't 15 minutes, although Deborah and I's case lasted about an hour. He wanted 15 minutes. He wanted us in and out. He kept cutting us off. I mean,
you said he kept cutting us. Miss Butler, you said he kept cutting us off. Who is us?
I'm sorry. Myself, well, my attorney, Ms. Jones, you.
No. You're on the wrong hearing. We're on August 15th. We're on the August 15th hearing where you were your own lawyer.
Oh, okay. I'm sorry. Okay. Actually,
Okay.
you got to tell me Morris or Wilson, because this is
okay.
a lot.
Okay, so I'll call it Morris or Wilson. In the Morris case, did the judge allow Ms. Deskey to ask all the questions that she wanted?
Yes, he did.
Did he interrupt her?
No, he did not.
Okay. When you began asking Ms. Wilson questions as your own lawyer, did the judge interrupt you?
No, he did not.
The judge did not interrupt you in the Morris case?
When I was in the Morris case, he did not. He objected to things. Is that what you mean? Objected or interrupted?
Hold on. The judge objected
So you're asking
Yes.
Miss Wilson questions and the judge
Miss
objected.
Morris.
I'm sorry, say it again.
Miss Morris questions, right? We're on Miss Morris, right?
Oh, I'm sorry. I
You
said
keep saying
Wilson.
Wilson.
That's my fault. I'm sorry. When you were at, so I stand corrected. When Miss Deskey asked Miss Morris questions, the judge, you said that the judge did not interrupt her. Is that accurate?
That's true.
Okay, I'm sorry, it's my mistake. I was saying Wilson and not Morris. When you were asking Miss Morris questions, did the judge interrupt you?
Yes.
You said something. I just want to make sure I hear it. Did you say the judge objected to you asking Miss Morris questions?
I can't honestly quote that because
When you say
I
object, what do you
misunderstood
mean?
at first. Well, when I say object, and my meaning was the judge like cut me off, okay? And when he cut me off, he said, while I was questioning Miss Morris's husband, Robert, the judge cut me off and said that he was going to throw me in jail for 160 days or however many days. And for what reason to this day, I still don't know, because I was not disrespecting the courts in any manner. So the threat was very unnecessary. So it just left me confused. And not only did it leave me confused, it really left me really nervous to even finish, because I'm like, you know, I'm not an attorney, first of all. I'm representing myself in this matter. And even though I asked for an attorney or time to get an attorney, it made me really nervous to even move forward, because I was like, well, what am I saying or what am I doing wrong? It's going to get me thrown in jail and away from my family, and them back at home with their families continue to laugh about this entire matter. So it left me very confused and upset.
So I want to get back to the judge threatened to throw you in jail.
Yes, ma'am. For no apparent reason, no reason.
Did Miss Deskey ask him to throw you in jail?
No, she did not.
So the judge did that on his own motion.
He did.
So,
and again, I was not disrespectful to the court. I didn't do anything that I know. I didn't act inappropriate in any way to be threatened to be thrown in jail. For 100 and think he said 60 days or 80 days. I can't really remember, but I know I didn't do anything wrong to be thrown in jail for no reason. So the threat was definitely unnecessary.
Have you had, Judge, I'd like to take judicial notice of the, and you've already done this actually. So I actually want to go through. Do you have a copy, Miss Butler, of the hearing?
Yes.
From August 15th in the trial, in the Morris trial, Morris case?
I do, yes.
Can you, because I wasn't there, could you tell us, can you find the part where the judge threatened to throw you in jail?
Yes,
ma'am.
ma'am.
Tell us where it is.
1 second. I'm sorry, 1 second, I'm looking.
Judge, while my client is looking for that in the record, in the reporter's record, is there any way, like maybe while she's doing that, I need to try to call the Harris County courts. I have cases in Harris County tomorrow, but I'm not anywhere close to being finished with Miss Butler. And I have an obligation at, I think, 6 p.m. If you'll just hold, I need to ask my staff.
Why don't we take a 10-minute break right here?
Okay. Keep looking, Miss Butler.
Yes,
I
Your Honor.
will.
Thank you.
I'll find it.
I need to go to find out from my staff because I have a state rep obligation at 6 o'clock where I'm the person who has to be there. And I may be able to get them to maybe move my settings in Harris County tomorrow. But I have to have time to call the court and see. I mean, it is late. I don't know if they're still there. So is that okay, Judge?
I declared a 10-minute recess. Do what you need to do.
Okay, thank you.
Judge, to put you on alert, this is the reporter, Vicky. I have court elsewhere tomorrow, and I'm not sure if they could arrange, if y'all are talking about continuing this, they would have to arrange for a different reporter.
Understood.
Okay, thank you.
Your Honor, and I have court in Lake County, but I have someone covering that tomorrow. But at lunchtime, I'm handling law enforcement for juvenile cases.
I'm
Tomorrow.
gonna do my best to finish this tonight.
Thank you, sir.
Judge,
I spoke with the judge in Harris, with the judges in Harris County. They both said that I could reset my clients, so I can fix that. But I don't, you don't know this, but my loft is, I have two suites right next to each other. My state staff is gone. So I haven't been able to reach them yet to find out what time my state obligations are, but I know, I want to say it's a 6, if my memory serves me correctly, but they're gone. I can't reach them right now. They're
Then
trying-
we better hurry.
Okay. So Ms. Butler, did you
Or-
find?
Or you
Oh, I'm
may
sorry.
have, you may have to be late.
Well, but I'm the person who's speaking, like I'm the person that everybody's coming for.
I'm really
I mean,
sorry. I'm really sorry, but we're going to finish this case today.
Okay, please let me call my staff so I can tell them that I can't be there so they can try to fix it.
As you like.
Okay.
Mhm.
Okay, Judge, I'm back.
Very well, let's
I'm
proceed.
informed, and for the record, because I do have an objection to this going late to the legislative, the mandated legislative continuance, I would say that I just informed something for my legislative duties that I told them that I could not attend. So they're gonna just have to figure it out.
Well, let's be clear. I did not order you not to attend. I said
Yes,
that
Judge,
I said that you might be late, but that this hearing we're in takes first precedence.
okay, well, this hearing, Judge, is going to go over, and they need me there, right? The way the program is set up, they need me there. So I'm, for all intents and purposes, I can't attend if this takes precedence. And again, I don't think that I should have to be here, but that's neither here nor there. We started it. So I'm gonna go through, I'm gonna follow the instructions of the court with objection, but I'm doing it. So I am missing legislative things because of this hearing for it setting on November 17th and then moved here. Again, so may we be back on the record, please, Judge?
I believe you
I guess
are.
we always were on the record. I'm sorry. May I continue with my direct examination of Ms. Butler, Judge?
Yes.
Ms. Butler, did you find the part in the hearing for August, in the Morris case? Did you find the part where the judge threatened to throw you in jail?
I did. It's actually on page 46, line 1 through line 4.
Okay, say it again.
Page 46, line 1 through line 4.
Okay.
And
okay,
it reads.
and so what does it say?
Okay, and it reads, the court. You may want to watch your conduct in the court because I can hold you in contempt and I'll put you in jail for up to 180 days. Do you understand that? I responded in line 5, yes, sir, because first of all, I didn't know why I was going to be held in contempt. So I just said, yes, sir. I'm definitely not going to argue with a judge. So I just simply said, yes, sir.
So, Ms. Butler, before the judge threatened to hold you in contempt and put you in jail for up to 180 days, what line of questioning in the transcript happened?
Okay, page 45, line 20 through 25.
What was that?
And it line 20, it says witness sworn. And then it says line 21 says the court. Okay, you can have your seat, ma'am. And your name is Ms. Burns? Ms. Burns? Your name is Burns, Ms. Burns. So then Ms. Burns replied, Darlene Burns. Line 24. Oh, I'm sorry, I said that wrong. My thumb must have moved it. Page 45, I'm sorry. Line 20 through 25. It says, Your Honor, and then it has a Q with a period by Ms. Butler. And then it says, Robert, what kids do my kids, which I meant, what school does my kids go to? Okay. Line 22, the court. Ma'am, I sustain the objection. You don't get to ask it. Line 24, Ms. Butler, pass the witness, Your Honor.
So did you understand, Ms. Butler, like what the judge said you did wrong?
Absolutely not. I went to cosmetology school and nursing school, not law school.
Okay, so did you understand why? So in lines 20 through 25, you are asking questions to Robert. Who is Robert?
That's Miss Morris's husband.
So Robert, what's his last name?
Johnson.
Robert Johnson. So you were asking Mr. Johnson, what kids do my kids, what school does my kids go to? The court told you, ma'am, I sustain the objection. You don't get to ask it. What does sustaining an objection mean? If you know.
Well, I still don't know because I never asked you or my other attorney, Lynn, about it. I just,
So you didn't know what that meant. And then, do you know why you passed the witness?
because like I said previously, after I was threatened to be thrown in jail, right after the judge said that, no, I'm sorry, because that was before. So when I was speaking to Robert, mainly everything was a joke. He was just kind of laughing. He was throwing himself around the witness stand. And honestly, he was not
Who is he?
agreeing.
Who is he?
Mr. Johnson.
You say he.
Mr. Johnson.
Okay, so you're asking him questions and he's doing what?
He's kind of just throwing himself around the witness stand. And he kept saying, do you want me to be honest? Do you really want me to be honest? And so it's kind of like, why are you doing this? Just answer the question and let's go forth. Although, I mean, that's what I was thinking. That's not what I said, but it was just like, let's go for it. But he wasn't want to answer my questions that I had to ask him. But when Ms. Desky was asking him questions, he answered the questions and he made it very clear that he has never witnessed me harass his wife or stalk his wife. He made it very clear. He also made it very clear that he did not witness. He made it very clear that he did not witness any of his wife's alleged accusations that she wrote in the affidavit and gave to the attorney, Susan Desky.
Okay.
So her only witness was really not a witness because.
Okay, I got it. Go on.
So can you, so for a clear record, can you go to the hearing transcript and specify where in the transcript Robert said he didn't witness any of Miss Morris's allegations against you?
Help me understand what that's got to do with the motion to recuse.
It's got to do with the motion to recuse, Judge, because if Judge Campbell is treating my client unfairly during hearings, in the hearing that I had, and I'm sorry, in the Wilson hearing and in the Morris hearing, and if Judge Campbell is allowing Ms. Desky to ask questions and the witnesses are answering her questions and then turn around on my client's end, on Ms. Butler's part, and not affording her the same, I guess, leeway. And if the judge is ruling on things and there are witnesses that Ms. Desky calls that absolutely undermine the allegations brought against Ms. Butler, that's absolutely relevant to whether the judge entered an order according to the facts presented in the case and not because he has prejudice or bias against my client. So it's absolutely relevant. It's about what he did, not only just rulings, as Ms. Butler has talked about his demeanor during these hearings when Ms. Desky is asking questions versus his demeanor when I was asking questions in the Wilson case and when Ms. Butler was asking questions in the Morris case. That absolutely goes to whether he's treating Ms. Butler differently than he's treating, I guess, the state side. And that goes exactly to, that's how I show the bias and prejudice or making rulings contrary to the law. And I wasn't present at this hearing. So all I can do, because Ms. Butler was, is ask her, show me where this happened in the hearing. Because otherwise it's uncorroborated.
Okay, just a moment. On page 45 of the transcript, which I have on the screen in front of me now, Ms. Butler examining this witness.
Yes, Judge, I'm asking Ms. Butler to show me where in the transcript. She just said, that-
I got it. I understand that. Just
Okay.
be still a moment. Let me try to pull this together.
okay,
On page 45, line 6, Ms. Butler, cross-examining the state's witness, says, quote, "So I just want to be clear. You said that you have never witnessed me stalking or calling or coming by your home. You were never on the scene. Just yes or no." Answer: well, I seen you drive by our house 3 or 4 times personally, but when you engaged with my wife at the time, no, I was never around. She called me crying and upset for what you had done. So your client in this exchange got before the court the fact that this man had not seen any stalking going on personally. But then she goes on to a matter that drew an objection as to relevance. She asked, "Robert, what kids do my school go to?" And Lawyer Deskey says, "Your Honor, objection as to relevance." Judge says, sustained. Ms. Butler, it appears, understands exactly what's going on because she says, "It does have a relevance, Your Honor." And she gets to ask the question again. "Robert, what school does my kids go to?" And the judge apparently becomes irritated a little bit and he says, "Ma'am, I sustain the objection. You don't get to ask it." And then she passes the witness and then he gives her the stern warning. So all of that is in front of me. I have received that evidence for what it is worth. Can we go on to the next bullet point?
well, yes, I'm trying to advocate for my client, Judge, but yes, we can move on from that little part. Ms. Butler, was that the entirety of the part where he said that he didn't see it with personally? Was that the entirety of it?
You're cracking up.
Can you hear me now?
Yes.
So is that the part of the transcript where the judge just read, is that the entirety of Robert Johnson's saying he didn't see it? Is there anywhere else in the transcript?
I mean, I would have to literally go back through this thing and read it. But as far as I can remember, the judge just spoke on page 45, we were talking about had he witnessed me doing anything to his wife and so forth. So, I mean, I don't know if I answered your question, but.
So let me be clear, Ms. Jones, are you complaining about Robert Johnson testifying this way, or are you complaining about the judge showing bias toward your client?
That's what I'm complaining about, the latter, Judge.
So whether Johnson said this 1 time or 20 times is kind of irrelevant, isn't it?
Well, I don't know that I wasn't at the hearing, Judge. I don't know if that's all I ask my client is there more?
And all I'm saying is, why do we need to go into the more unless there's more conduct by the judge?
Because
you're not trying to recuse Robert Johnson, you're trying to recuse Judge Campbell.
Right, by showing his bias and prejudice. If for purposes of explaining my trial strategy, although I think respectfully I get to represent my client as I know professionally how to do. If there are 40 instances, I'm just picking a number, it's not anything, of the judge stopping my client from asking questions that could help show that she didn't engage in acts of stalking, there's a huge difference, Judge, between whether the judge had behavior 40 times or whether he only had it one time, which is why I'm asking my client, because I was not there, are there other instances? And so I don't want to testify for my client, which is why I'm asking my client to show me these things, because I was not there. And so again, respectfully, Judge, I believe it's absolutely relevant every time the judge lets Ms. Deskey go and ask questions and then keep stopping my client, and she keeps stopping my client.
Okay.
So I
hang-
think that goes directly to whether the judge has bias or prejudice or is making rulings contrary to law, which are what I'm required to show for recusal. And if the court is not going to allow me to show what I need to show so that I can make the strongest case for recusal, then I respectfully disagree. I would object to that. And I don't think the court, even if the court wouldn't try a case like I try a case, I don't think that I have to be told how to try a case, whether the court likes the way I'm trying the case or not. I get my client, this is serious. My client has explained to you why it's serious to her, and I just want for my client to have her day in court. For the entirety of at least the case with me, and from what I hear, the case, the Morris case, my client has always been shut down from being able to give evidence. And I mean, and even when I asked County Attorney Deskey, she didn't recall a lot of things, and I asked questions to try to get her to answer questions that I believe she should know. And so that's all I'm saying, Judge. It just needs to be fair.
Well, we generated a lot of words there, but I'm not sure you've shed any light yet on why it would be relevant, whether Mr. Johnson testified in other places in the hearing that he didn't see his wife being stalked. That was the question you asked.
Okay, so maybe I was inarticulate. Let me ask this. Are there other places, Ms. Butler, where the judge related to Mr. Johnson stopped you from asking questions?
Well, after that, I passed the witness. So as far as Mr. Johnson, no, but you go back to his wife, yes. But as far as Mr. Johnson, no, because I passed the witness. Now, when we speak of Miss Morris, yeah, I was stopped several times. The DA objected.
So let's go back. So you said it does have relevance. The judge did not allow you to explain why it was relevant. Had the judge allowed you to explain why it was relevant, because you did say on line 16, I'm sorry, you did say on line 18 through 19, it does have a relevance, Your Honor. Had the judge allowed you to tell what the relevance was, rather than telling you that he sustained the objection, what would your answer have been as to why it was relevant?
Are we on page 40? What page are we on?
We're on page 45, lines 15 through 25, where Ms. Deskey objected to relevance. The judge sustained it. You said, but it is relevant. It does have a relevance, Your Honor. You asked the question again, and the judge said, I sustained it. Had the judge allowed you to explain why it was relevant, what would you have told the judge? Why was it relevant for you to ask that question?
Because the question was, which is on line 6, I asked him, I said, so I just want to be clear. You said that you have never witnessed me stalking or calling or coming by your home. You were never on the scene, just yes or no. And he said, well, I seen you drive by our house. And the reason why, okay, jog my memory. So the reason why I said it was relevant, because that's when I said, well, what school does my kids go to? Because my children attend a private school, which his home is on the corner of Moore Street. My kid's school is not even, you can walk across the street and the playground to my kid's school is right here. So it was relevant for me to try to explain why I was around there. Because at 3:40, if I go pick up my little ones from school at 3:40, I can't go to the front of the school. If I go to the front of the school, I avoid their home. But if I pick up my kids at 3:40, I have to go to the back of the school because they're on the playground at 3:40. But I was not able to explain that. So that's the reason why you see me drive by your house. And I've been doing this for 17 years. My oldest son is 17. So all of my kids have attended the same private school, First Baptist in Caldwell. So when I pick up my little ones from school at 3:40, I have to go to the playground because that's where they're at. And Mr. Johnson's front door is facing the First Baptist playground where I pick up my kiddos from school.
Okay,
So-
I understand. I understand.
So you're trying to explain that I just want to make sure I understand, Ms. Butler. So you were trying to explain that if he saw me by the house, it wasn't because I was stalking, it was because I was going to pick my kids up.
That's correct. And he knows that. Robert Johnson knows that.
And so that's why you were asking Mr. Johnson that question.
Yes, ma'am.
But because the judge didn't allow you, because he said it wasn't relevant, you weren't able to get that out. So the judge could not consider that information in determining whether if somebody saw you by their house, that you were not stalking, you were picking up your kids.
Correct.
Okay. So you mentioned that the judge interrupted you a lot with Mrs. Morris. Can you go to the transcript and tell me what you meant by that?
Okay. Okay, let me clarify myself. So the DA would object, okay? Ms. Deskey would object, okay? And then if I started back to answer the question, then the judge would say, no, you can't. Like, this is not your time right now, which he interrupted to say, let me get the exact wording. I have it right here. Okay, so when I started speaking with Deborah, okay,
Can you tell us where you are? Can you tell us
sorry,
please where you are?
Page 13, line 23 is when I started speaking, or when I started to question Ms. Morris. How she goes on to say, when I asked her for specific days, if you say, am I stalking you? Then give me specific days, because keep in mind, she wrote down, Miss Morris wrote down in her affidavit, and when she submitted the false affidavit to the attorney, Susan Deskey, she specifically wrote down dates, okay? She didn't write down times, but she wrote down dates.
Your Honor, object as to referring to it as false accusations.
Overruled.
That means you can finish saying what you were saying, Ms. Buck.
Oh, I'm sorry. So to go forth, when I asked her in court, can you give me these dates?
Can you tell us like where you are?
These,
I'm sorry for interrupting you.
I'm still on page 14.
What line?
I'm still on page 14. Page 14, line 10.
Okay.
Okay. And I said, I asked for Pacific. No, I'm sorry. Line 8 is where I asked the question. Can you tell me when I allegedly stalked or harassed you? What dates were these? Okay. And then the answer was specific days, I do not remember. Yet she wrote in the affidavit that she submitted to Ms. Desky, which in my feelings and thoughts, the false affidavit, she specifically wrote down dates, okay? But now that we're in court, you don't recall, I don't remember. As a matter of fact, her whole testimony was fed to her. When she was given her testimony, it was given to her in write, because then the Miss Morris would say, huh? Like, oh, I don't remember that, or
Wait,
did
hold
I
on,
tell
hold
that?
on. I'm sorry, you're just sort of talking. So when you said it was, let's go to something. I want to ask you, I'm asking you questions and I want like a succinct answer. So if you need to think about what the question is, to make sure you just answer the question, okay? So I wanna go to something. You said that you believe Miss Wilson was fed information. Did you just say that? Did I hear you just say that?
Miss Morris, yes.
I'm sorry,
yes.
Miss Morris. I'm sorry, Miss Morris was fed information. Can you find in the transcript where you believe Miss Morris? Hold on, you know what? Let me say where we are right now. I'll come back. On this specific dates, you knew she had given specific dates, correct?
Correct. In the affidavit,
And you were
correct.
And you were in the affidavit because you saw the affidavit when they served it on you on the 20th, correct?
Correct.
So
Correct.
you were trying to cross-examine Miss Morris on things that you say were lies or not true in the affidavit that made the basis of the request for protective order. Is that accurate?
Yes.
So when you're asking her these questions, you're trying to refute her version of things as best you know how, not being a lawyer. Is that accurate?
That's accurate.
Okay. So finish telling me related to Miss Morris. You talked about how there were times where the judge interrupted you. Tell me where the judge interrupted you. Related to Miss Morris. Please.
Okay, so it's kind of, on page 15, if you go down to line 20, and it says question,
Mm-hmm.
and then it says, okay, so, and then there's 2 dashes, and then it says now to go back to, and there's 2 dashes. You said that we are not related, and there's 2 more dashes, okay? So then you go to line 22, and it says, Ms. Butler, which we are not, Your Honor, there is, and then dashes. So every time you see those dashes, those are where the judge would cut me off and be like, so, not like, but the judge would specifically say, so are y'all related or not? And then I would tell him, we're not like biologically related. We're related through marriage, okay? So it's like when I would try to get my brain wrapped around all these lies, to try to make valid points, I was interrupted and threatened, period. I was interrupted multiple times, objected by the DA multiple times. I couldn't get a valid point across. I really could not get a valid point across.
Let me ask you this one. I want to go back to the judge threatening you, threatening to put you in jail. Were you afraid? Like, how did you feel? Were you afraid to prosecute you? Were you afraid to go to jail?
Yes, I was terrified. I mentioned earlier, I'm a single mom. I raise my kids. I pick them up from school. I pick them up from all their activities. I feed them every night. I clothe them. I do everything for them. So me being out of the picture and not being able to care for my children, of course I was afraid. Who else is going to do what I do for my children?
Okay.
No one.
Okay,
So
I got the point.
So let me ask you this, Ms. Butler. You mentioned that you believe Ms. Morris was fed information. Can you show me in the transcript related to where she was fed information and how the judge responded to it?
Yes, so when Miss Deskey, the DA was questioning her, let me find it here. Okay, so on page 6 is where Miss Deskey started questioning Miss Morris, and page 6, line 7, Miss Deskey, Miss Morris, could you please say your whole name? So that's where we start, right? So then if you go down to, sorry, I just had it till my son approached me. So, okay, page 8, line 2, the question was, now you said it began because she was babysitting your stepdaughter. Miss Morris replied with, yes, ma'am. Okay. Then you go on to the next question, line 5. Is that your husband's daughter? Yes, ma'am. Okay. So she goes on to tell Deborah this, because Deborah, if you read above in page 7, nowhere it mentions where Deborah says this. Every question was fed to her and she answered with a yes, ma'am, uh-huh, or I don't recall. So let me be very specific here and go down to, if you go down to page 10, line 2, it says yes. The questions, what type of things? The answer, just cursing. Then it's line 5. And how do you know it was directed to you? Line 6, Deborah says, huh? Then the question was, how do you know it was directed at you? The answer was, how do I know? So it's like she was lying and confused her own self in that lie and was trying to fix it. So then the DA goes on to say, you have to make them be quiet, Mom. Tell them to be quiet. So then the DA goes on to say, because, I'm sorry, the answer was, because I'd be sitting outside by Miss Morris, I'd be sitting outside and I was the one that she had the problem with. So then the question was, okay, and 2 dashes, and this has connected, I'm sorry, and this has continued now that you are married, that you are married by the house. And then the answer was, she's driven by our house since we've been married. So she still really didn't even agree with the DA was feeding her then. She didn't even agree.
But can you help? Sorry. So going back to the question about where your kids went to school, in your mind, that would be relevant to you driving by the house since they've been married. Is that accurate?
It's true. Been driving by that house for 14 years. Long before he bought the property, I was driving by that house for the past 14 years. That's true.
But that's why you were trying to ask about the kids, even though the judge said it wasn't relevant about your kids going to school, so that we'll refute this part of the question. Is that accurate?
That's accurate.
So did the judge threaten to listen to my question. Do you have examples of the judge doing things related to you that made you feel he was biased or prejudiced against you?
Yes. Okay, you can't ask me to go find it in this. You have to let me go off memory, because some things that the judge did, it was not on record, and you can't, he wasn't verbal with it. It was actions, okay?
Okay, well, so explain that to me. Explain that to me.
So body language, his tone when he did speak toward me, and when I say body language, let me detail again, just the flopping all over his chair, rolling his eyes, throwing his head back. He was done. Cut me off, even in cases with you, cutting us off, kept resetting my court dates, pushing it back. So So pushing my court dates back, just interrupting me, the threatening to throw me in jail, even though a protective order states that a protective order can be granted on more than one occasion. He granted a protective order on one occasion that he says took place in November. And he says that I did not defend the November incident. But I'm going to go find it in here. But I did defend the November incident. What I said was, I was not at the corner of 21 and 2000. Okay. I just didn't say, oh, November 17th or whatever day she wrote, that I wasn't there. But I defended that date as well as I defended every other lie that came across the stand.
Had
I
you
know
been allowed, had you been allowed to hire a lawyer and come, would you have been able to give, would you have given the lawyer, would you have given the lawyer like the evidence to prove stuff that you had to go from memory on in August 15th?
Yes, because in May, I was able to give, of course, now this is during the appeal. So when I have an attorney, so in May, I was able to give my attorney proof that I was not driving my black Lincoln, which Ms. Morris testified that I was. My car had been giving me trouble. It was located in Rockdale, Texas, in the service department, okay, in May. Now, when we go to November, she says that I swerved around her at an intersection because she stopped in the middle of an intersection, which it was not me, but whoever it was. It's called defensive driving if someone stops in the middle of the highway and you go around them, okay? So in November, I was not driving because in October, Your Honor, I was in a very bad accident. I was surrounded by fire, 8 feet up, 8 feet wide. My entire face was burned. My left side of my body was burned. So November, I was not out in public. October, November, and December, I stayed home. I stayed out of the sun so that I could treat my skin and get my skin back to as normal as possible. So if I would have had an attorney during that court period in August 15th, I would have been able to give all the evidence that I had for my appeal case, because all of my evidence is true, is correct. My next door neighbor, she was taking my kids to school for me, her and my mother. They took turns. On the days that my mom couldn't take the kids, my next door neighbor took the kids, who's currently still taking my kids to school for me every day and picking them up for me every day when my mom cannot pick my kiddos up. So if I had got a fair chance, again, I would have submitted all the proper evidence to prove that it was not me at the intersection in November. It was not me in May when she says that I told her to come around the corner so I can jump on her. First of all, I don't tell anybody to meet me around a corner so I can jump on them. Because simply, if you think about it, why would you tell somebody to come meet you so they can give you a chance, it gives them a chance to hurt you? That's crazy to me. I live for my kids, I live for myself, and I don't live for anybody else. I don't. And as I also mentioned, that I did not have a problem with Ms. Morris. Until this day, I still do not have a problem with Ms. Morris. I don't have hatred in my heart toward her. It is what it is. The only thing is, this protective order is hurting me because it's hard. It's hard for my mom to get up in the morning, so my neighbor gets up in the morning. But some mornings my neighbor can't get my kids to school. So now my boys have had to go part-time in school instead of full-time in school because she has to get her kids to College Station at 7 a.m. in the morning.
I'm sorry. I've got to interrupt you because I think we're going kind of far afield.
Judge, I'm going to try to get her back on track, please.
Well, either you have, if you don't succeed in doing it, then I have to interrupt.
Okay, I will. Miss Butler, do I see tears on your face? I'm not asking you to wipe them. I'm just asking you, do I see tears on your face?
Yes.
Excuse me a minute while I turn on the fan here in my room.
Okay.
All right, let's go on.
When the judge kept interrupting you and was not allowing you to defend against the specific allegations made against you in the Morris case, like, what did you do?
I had no choice but to just stop.
Okay, I think you just answered the question. Next question.
Yeah.
So in May, did you have paperwork to show you didn't have the car that Miss Morris specifically said you used in the May incident?
Yes, the dealership printed me out their copies from their records that they keep of every vehicle that comes to the dealership. They printed it out and gave it to me.
All right, Miss
Miss
Jones, just a minute. It seems to me that this kind of material that you're presenting to me now, specifically about her not having possession or ownership of the car, might very well have been a proper subject for a motion for new trial in the Morris case. But I fail to see how it has any relevance to the issues about this judge displaying bias toward your client.
So Judge, I respectfully disagree. When my client is forced to go forward on a hearing that she had no notice of, and she's in that hearing and she's hearing allegations for the first time in court, when Ms. Morris is testifying and she's trying to do the best she can because the judge made her go forward, would not allow her to hire a lawyer, even though she announced not ready and explained the situation before it. It absolutely goes to whether he was biased against her. If the judge is allowing Ms. Desky to present her evidence and is shutting down every defense that Ms. Butler is making. On top of that, Your Honor, Ms. Butler is a regular person. She's not a lawyer. So Ms. Butler doesn't know how to object properly. She doesn't know how to do any of those things. And if Judge Campbell is making these, which Ms. Butler has testified, Judge, that Judge Campbell was doing the same thing to me for the very short period that I was able to cross-examine Ms. Wilson in that case, and allowing Ms. Desky to just ask questions with no interrupting and interjecting himself in it, like asking questions that favored the state, that absolutely goes to bias and prejudice against my client. And so for me not to go into these details so that my client can tell you what happened, how she knows the judge was biased and prejudiced against her, is absolutely relevant to whether the judge should be recused, if he can be fair or not. And Judge, if the order is, and which, by the way, Judge, I guess the appeal, I'm not her lawyer, I'm not Ms. Butler's lawyer on the Morris case, but that is up on appeal about whether Ms. Morris, about whether Ms. Butler had a fair trial and notice and issues like that. That is up on appeal. The 10th Circuit hasn't ruled on that, but for purposes of this.
Okay, I got it. Now, show me, if you want to, and if you can, where Judge Campbell excluded evidence that your client wanted to present.
Well, we already showed one example where she was trying to show that if they see me by the house, it's because I'm picking up my kids and not because I'm stalking. So that got kept out.
Granted.
Okay.
Granted. How many times are you going to keep talking after I say granted?
I didn't hear that. I'm sorry.
That's because you're talking while I'm talking. First of all, your client did not explain to the judge why it was relevant. And of course, he did not ask her to explain why it was relevant. So you've got one instance of the judge preventing your client from presenting evidence, where arguably it might very well have been relevant. But there's nothing about his ruling that appears to be based on bias, just responding to an objection by the other side and him not perceiving anything relevant about it. Now, if you have other instances that you'd like to direct me to where the judge excluded evidence, I'm glad to hear it. But to talk in this hearing today about all this evidence she would have presented if she'd only had a lawyer doesn't say anything about Judge Campbell's bias.
Judge, it's not just Judge Camp. I'm sorry, were you finished? Because I do not want to interrupt you.
That's quite all right. Yes, I'm finished.
Okay, so one of the reasons that I filed this was because of his bias or prejudice, but I also filed this because he made a ruling contrary to the law. So and that my client was denied due process. So the court just made reference that my client didn't explain why it was relevant. Well, my client did explain the best way she knew how as a non-lawyer. And what I'm saying to you, Judge, is had this case been reset, just like my Prevset case was reset on the date on August 15th, then my client could have had a lawyer to do all these things. So why would my client know? It's a rhetorical question, Judge. Why would my client know that I can explain the relevance? She just passed the witness because she was trying to get something out. She didn't know any other way. And over the course of every time she's been to court, Judge, the judge has always been favorable to Ms. Desky and not us. So she was exasperated. But to that end, and it goes to his bias and prejudice, and had he allowed her to hire a lawyer, had he not made her move forward for a hearing that she was not noticed on and was not prepared for, then we wouldn't have these problems. And that's why that's relevant exactly to the recusal and the disqualification. It just is. But
I'm sorry. I thought the question, I know that the question I just asked you was to point me to other instances where Judge Campbell precluded your client from presenting her case.
And I'm going to ask for that right now. However, you said some stuff that I thought I needed to respond to. So I won't apologize for it, but I'm advocating for my client. Miss Butler, can you show other instances where you tried to get out evidence to specifically refute what you were learning in the hearing about what Ms. Moore said you did, where the judge did not allow you to present that evidence?
Okay, without reading through the transcript and going back to when I did hire an attorney to represent me on this case, and the judge said that he didn't want to give us a hearing because he wanted to be 15 minutes. Okay, this is with my new attorney, Ms. Jurek. So, and I warned her, I said, if it's not 15 minutes, he's not going to hear you. You have to tell him you can do this in 15 minutes or else he's not going to hear you. So she said, okay, well, I can do it in 15 minutes. So when she responded back to Ms. Desky and said, we can come forward to ask for a new trial. So when we did go to court and ask for a new trial, I truly believe that Ms. Jurek hit every nail on the head and never missed one. Yet the judge still did not want to, I guess I'm saying the right word, like respond to the case in court. What he said was that he would respond like outside of court. He would email us, okay? He still did not want to properly give me a new trial or the chance to provide my evidence to him or Ms. Desky in his courtroom. He still was in disbelief that we had all the right evidence. I had got an attorney this time and we were ready to go forward. And he still did not want to give me a new trial. He denied me of a new trial with counsel, but forced me to move forward in a case with no counsel. So in my belief, that is very biased. That is very prejudiced. When I have an attorney, you say, no, I don't want to hear it. But when I don't have an attorney, you say you will go forward. That's not fair to me at all. And I know for a fact that when Ms. Jones and I appeared in court together, each and every time, the way the DA conducted herself and the way that the judge conducted himself, oh, we didn't stand a chance. We didn't stand a living chance. Because
Okay,
when Ms.
hold on. Miss Jones,
Yes,
let's
Judge.
let's talk about some facts.
Okay.
Tell me some facts.
Well, so let's go back to the June 24th hearing, Miss Butler. In that hearing, in addition to the judge cutting me off during my cross-examination, in addition to that, did the judge volunteer evidence in favor of Ms. Deskey in response to my cross-examination?
Yes, if I'm understanding correctly, that you're basically was favoring her and not us, right? Yes.
So can you go look at the hearing transcripts? Because the judge wants facts. Can you go look at the hearing?
I don't have a transcript for June 24th. I only have a transcript for August 15th.
Mrs. Jones, I would expect you to know where those facts are.
Well, I know the facts with related to my case, but I was not in, and I can't tell by the transcript, Judge, facial expressions and all that stuff, because they don't note that. But I can tell you, I remember facts. So, Miss Butler, after the judge took us off the record in the June 24th hearing, after we were not on the record, when the judge stopped it, before we got reset to a time in the future, do you recall the judge saying that something was going on here related to you?
Okay, I don't know if it's my service or yours. You said the judge said something and then it skipped out.
So after the judge ended the hearing on June 24th, and we were at the bench trying to figure out when we had to come back. Do you recall that?
Yes.
Do you recall the judge, after I asked the judge, like, why we stopped, do you recall the judge telling me that it took too long, that cases of this type shouldn't take that long? Do you recall that?
You saying that or the judge saying that? I remember the judge saying it should only be 15 minutes or less, and that it's unnecessary for it to be 2 days or all day. He refused to believe that we needed more time, especially when they, as in Miss Wilson and Miss Deskey, brought forth all these witnesses.
Okay, so you remember those facts, correct?
I do, yes.
Do you remember, do you remember that I kept imploring the judge that I had witnesses and evidence to show that you did not stalk or commit family violence, and that it was absolutely going to take more than 15 minutes, and I needed to have sufficient time to defend you? Do you recall that?
Yes, and he argued that was not. It should be, and even Corporal Sleet said, "Oh, I've only been in protective order cases where they only lasted a few minutes at most."
Do you recall me asking the judge, or do you recall the judge saying, "I thought this was going to take 15 minutes"? Do you recall that?
Yes, because the DA told him it would take 15 minutes.
I was about to get to that. So do you recall me saying, "Judge, I don't know why you think it was 15 minutes. I never represented that it was going to be 15 minutes.
That's
Do you recall
correct.
that? Do you
Yes, ma'am, I
recall?
do.
Do you recall me asking, like, where did this 15-minute number come from? Because I've never had a hearing where it lasted 15 minutes. Did you hear me
Yep.
ask that?
Yes, and then, well, I heard you tell him that. And then when you told him that, you said, because I did a protective order case that lasted 2 weeks. And he said, oh, we ain't gonna be no 2 weeks.
I forgot those facts, but yes, he did say that.
Yes.
And do you recall the judge telling me when I asked him where he got this 15-minute number? Do you recall the judge saying that that's what was represented to him by Ms. Desky?
True, because she said all of her protective order cases take about 15 minutes, which is crazy to me. How can you give someone a protective order, which is pretty judgmental on their lifestyle, in 15 minutes, especially one that lasts 2 years, especially one that when you can't engage in your children's school activities or get your kids to school. So yes,
So
I think 15 minutes is crazy. You need more than 15 minutes.
So in the hearing for June 24th, your evidence was kept out that would take more than 15 minutes based on Judge Campbell. Is that accurate?
Yes, especially since Miss Wilson's background was extensive, super long. So it would have taken 7 days to get just through her background.
So related to the hearing on the 24th, the many criminal convictions for violence Ms. Wilson had were kept out. Is that accurate? By
Yes.
Judge? Okay, thank you. Let's move to August 15th. What evidence was not able to be presented because of Judge Campbell on your part?
Now, let's pause there a moment. To have any relevance at all to this argument about bias, it strikes me that that evidence would have had to have been brought to the attention of the judge, and the judge excluded it. If he never heard any offer of that evidence, how can he be blamed for not letting it in?
Well, specifically, Judge, when I explained to the judge why it was necessary for me to bring this in, the judge merely told me that he was not going to have a hearing, or actually us, he wasn't going to have, the hearing should be 15 minutes. For whatever reason, he was at 15 minutes. I tried as I might, and this is before the judge, before he like adjourned us for good, I guess, to be reset. I explained that it was going to take longer than that. And the judge told me, the judge told us at the bench that I better, or we better present, like, he said he didn't want to have it for a day. He thought 2 days was too much. And at the time, I'm trying to figure out, how do I get in all this? How do I get in all this stuff? So he said it wasn't going to come in. I mean, what am I supposed to do as a lawyer when I'm telling you, Judge, the allegations are not true, and this lady is the one that's violent? She opened the door to talking about all of that during her cross when she made that statement, which is why the judge overruled Ms. Desky's objection when I went to her criminal convictions, because she opened the door. And he still was not, he didn't want to hear it. And I can tell you, Judge, that when I was cross-examining, I saw the same things that Ms. Butler saw. The judge was very frustrated when I would ask questions about problems or impeachment with Ms. Wilson.
Let's try to hang on. Let's try to stay on track.
But you just asked me why, you said you don't see why it's relevant to bias or prejudice. And what I'm saying to you is, if every time I try to go into Miss
No,
Wilson's bad
no.
act, you
That's not what happened, counsel.
say it again?
What happened was you asked this witness to enumerate all of the pieces of evidence that she was prevented from getting into evidence because the judge wouldn't let her get them into evidence. And I raised the point that if the judge never heard about this evidence, how can he be accused of bias in excluding those items of evidence? And now you're wanting to talk about his body language or something like that.
Well, my client brought that up, that unless somebody just comes out and says, I'm biased against you, or I'm prejudiced against you, most people don't. Some people do, some people say it, but other people don't. So if every tie goes to Miss Desky, and no ties go to Miss Butler, that is indicative of a potential bias. It just is. If Miss Butler, in the Morris case, is trying to bring up specific instances of why what Miss Morris said in her testimony was not true, and Miss Desky objects, right, like to the relevance, and Miss Desky objects, and the judge sustains the objections due to relevance, that is Miss Desky objecting, trying to keep out something that's relevant because she knows my client's children live by Miss Morris, and then the judge sustains it. It's an entire pattern of the entire time Miss Butler has come to court that Miss Desky has tried to keep out relevant information. The judge has sustained, relevant information by objecting. The judge has sustained those objections, which effectively prevented Miss Butler from presenting that evidence. And that's exactly what this is. The judge prejudiced or biased against my client, or is the judge making rulings contrary to the law? So I guess I'm frustrated, Judge.
I'm really frustrated too. Okay. Because I've asked you to show me where the judge excluded evidence. You've pointed to one example. And the reason we're on this track right now is because you ask a question of your witness about all the other evidence that she wanted to present, that she was banned from presenting. And I had the distinct impression she was about to enumerate some items that she would have gotten into evidence, but for the fact that she got intimidated by the judge or something, and she just quit. And she didn't have a lawyer, so she didn't know to get them into evidence. So she just quit. Now you can complain on appeal, and perhaps successfully, I don't know, that the judge made a legal error in making her to go, causing her to go forward without a lawyer. I pass no judgment on that one way or the other, but that's a matter of judicial mistake. It's not necessarily a matter of bias. You can infer that he had some bias, but if you're going to complain about the failure of him to receive evidence, you've got to show me where you offered him that evidence. And he said, I'm not going to listen to that.
Okay, thank you, Judge, for
and just having your client launch into an enumeration of all the facts that she would have wanted to show him is simply going to consume time unnecessarily, because you can't blame him for excluding evidence that he didn't know anything about.
Okay.
Do you think you understand the logic of what I'm saying?
I understand what you'd like for me to try to get from my client, but I also know that when I ask my client to look at the transcript and tell me where, because, for example, I want to ask my client, well, I'm going to ask my client, Miss Butler, did the judge roll his eyes? Because this goes to demeanor. Did the judge roll his eyes when Ms. Deskey was direct examining her witnesses in the Wilson case?
Not one time. He sat up straight, he listened to her and gave her her day. No.
Did the judge roll his eyes when I was cross-examining Cassandra Wilson in the Wilson case?
Yes, ma'am. Rolled his eyes, fell back in his chair, even dropped his pen down on the desk because he was just outdone. And Ms. Jones, you did tell the judge, or you did try to tell the judge about the evidence, but he clearly said, I will not hear that today. We were already off record when you told him Miss Wilson has an extensive background history. And you said, and the judge said, we're not going to go forward today. We're not going to hear that today. So he wouldn't even allow Ms. Jones to give that evidence or even tell him about the evidence of Miss Wilson's extensive background history, because she did try to tell him. And even we talk about bias or prejudice against me, I think it's very biased to say that my kids, my 3-year-old kids, because I have twins and a 5-year-old, so that my 3 little ones can walk 200 yards unattended. That's very biased. And like even the officer Garza said, Ms. Butler, I'm sorry, but the judge gave you no leadway. You can't even drive up and drop your kids off at school. So now my 15-year-old daughter has to walk from Highway 21, and I'm not sure if you're familiar with.
Hang on. Let's try to answer the question instead of giving speeches about the effects of the protective order.
Yes, sir.
Object to the characterization speeches. My client is passionate about children.
It's what it is. It's what it is, Ms. Jones. It's not, it's like summation.
So I will say this, Judge, I've asked my client to just answer the question. And my client is answering like she's answering. Prior to this, I tried to explain it, and she never got the opportunity to testify in the June 24th hearing, so she didn't get any practice. So in the August 15th hearing that you had in the Morris case, what evidence that you tried to get in during that hearing that the judge did not allow you to enter in? And I'm gonna say this, if you have to look at the transcript to jog your memory, I'm going to ask you to do that.
Ms. Jones, do you not have an example in mind that appears from the face of the record? Do you have to have your client search through there to find the evidence that's germane here?
I was not present. I was not present at that hearing. I didn't hear it.
You've got a transcript.
Yes, Judge, but just like in the transcript of the hearing on June 24th, there were things going on in the transcript. I'm sorry, there were things going on in the hearing that the transcript did not encompass. Just like this hearing right here, where I saw my client crying, but that would not be in the transcript, which is why I asked as her lawyer, are you wiping tears? So that would be in the transcript. Otherwise, no one would ever know that my client was crying. So
okay, all right. Hang on. If your question prompts your client to start enumerating some lost evidence, missing evidence that is not discussed in the transcript, it strikes me that it's probably irrelevant unless you can show me how it's irrelevant. This is the discussion we've been having repeatedly over the last 15 minutes. Now, if there's something that does not appear on the transcript that she said and the judge said, I might entertain that. But unless it can be linked to some action by the judge, it's not relevant to any proof of bias on his part.
Ms. Butler, did you understand what the judge just said?
I think you ought to understand what the judge
Right,
just
right.
said.
Judge,
And ask her questions that are directed to a specific point of evidence
I've asked my
or some other display of bias.
Miss. Hold on. Hold on, I just found.
Is everybody comfortable enough to keep going? Does anybody need a break here? I hear no takers, so we'll keep going.
What I could do, Judge, if you'll give us a 10-minute break, I can try to just point out, at least from my notes, point out specific instances of the judge keeping out information so that I can direct my client to it. So she can look at the transcript and comment on it.
Okay, I think that's fair. I know it's late, but I've got to hear this. I want to finish this today. So we'll take 10 minutes for everyone's benefit.
Thank you, Judge. Okay, Judge, hopefully I can direct my client to specific instances. in the August 15th, 2022 Morris hearing.
So before we start back, I think at this point, it's fair to ask, how much more evidence do you think you'll be presenting tonight in terms of time?
Time is it?
Because it may be asking too much of public employees to stay here much beyond 6 o'clock at night.
I don't think I'll be finished judging until 7, just based on the specific instances in the hearing on August 15th.
Then let's discuss, without passing judgment, let's discuss whether it wouldn't be smart to reset this recusal hearing to another day to finish it up.
I told you, I told the court I could clear the courts, the 2 courts I have in Harris County in the morning, said that I could, as long, tonight I have to send them an email and that they would reset my cases.
Well, the problem is the court reporter has to report for another court somewhere. Is there another day that you could resume this on this week without waiving your complaint about the legislative continuance that I denied you?
So
Let me tell you what
on Wednesday I have a deposition, so I can't stop that. On Thursday I have a number of settings. I can't, at least here in Harris County, some judges are okay with you moving stuff and some are not. And I can tell you that I do not, my state staff has gone, so we normally talk about what I have the morning of, and so I haven't spoken with them. If the court, so the place that I was supposed to be at 6 o'clock, my staff is there, even though I was the person who was supposed to be there. So I can't reach them now because they're there. If the court will allow me to look at my schedule and confer with my staff, I can see if there's anything I can move, but I also have obligations. Like I can't remember, I have like a certain day where I have to move into my office in the Capitol. I don't remember when that day is. My staff isn't here. My state staff isn't here. So
do you think you could get the information over the phone if you talk to them?
Well, right now, that one thing, they're not here, they're gone. So I can get it. I just can't get it like right now. I was supposed to be somewhere at 6 o'clock. I was the person and I'm not there. So my staff is there. I'm certain they don't have their phone on. I'm certain of it.
Well,
but I could probably figure it out by in the morning, Judge. I just can't figure it out now because I don't have access to them. They went.
So, Ms. Brown, when do you have to report for another court tomorrow?
My full-time job is tomorrow morning at 9 o'clock in Belleville. And I'm doing this as a favor for this one day for Burleson County, as a favor to them because they're friends of mine over there. So I have another court job that I work and I was free today, so I could take today. So I think I'll be tied up all day tomorrow.
Judge, later on, at least for me, later on this evening
after my staff is finished doing what they're doing, I can get a handle on what I have, well, I know one of my staffers is in Austin today trying to find an apartment. I know that today and tomorrow. So he's unavailable, period. So I'm almost certain I can know by in the morning.
Judge,
Hello?
Judge, I can stay as late as we need to tonight. The only thing I have this week is Wednesday morning is my last grand jury of the year that I can't move. But anything else I'll make work.
I've got a depot on Wednesday morning anyway. And the last depot I had in this particular case took the maximum 6 hours.
Well, let me make an observation here to see if this might compress our time a little bit. Up until this point, I have heard nothing from your side, Ms. Jones. It could not have been the subject of a motion to recuse shortly after August 15th.
Say it again.
I said, I have heard nothing yet in your evidence that could not have been the subject of a motion to recuse before 10 days before November 17th. And the rule requires you to file your motion at least 10 days before the next hearing, unless it was something that you neither knew nor reasonably should have known before that time. So,
May I respond?
Of course, I'm afraid that everything you've presented to me right now is going to be time barred, so to speak, unless you have evidence that you neither knew nor reasonably should have known. Let me read the rule. A motion to recuse must be filed as soon as practicable after the movement knows of the grounds stated in the motion, and must not be filed after the 10th day before the date set for trial or other hearing, unless before that day the movement neither knew nor reasonably should have known that the judge would preside at the trial or that the ground stated in the motion existed.
May I respond, Judge?
Yes, ma'am, of course.
One, I have not finished presenting my case, and
I got that.
You will see that. One. Two, that hearing was November 17th. It is now December 12th. So the motion was filed more than 10 days before December 12th. So I actually believe that, to the extent there was an objection for the November 17th hearing, I don't believe that objection follows for the December 12th hearing. But I will also remind the court that I have not finished putting on evidence. And I have got some evidence in about whether I knew or should have known, as evidence has been testified to by both Ms. Deskey
and by Ms. Butler, I was not Ms. Butler's attorney in the other case, which in conjunction with this case shows a pattern and a practice of the judge based on the evidence I believe that I will be admitting has a pattern in practice. And I didn't know about that. And in fact, Ms. Per, the other lawyer in Ms. Butler's case, in the Morris case, she only got information of what actually happened. Per her, she said she was waiting for the reporter's record, which is why it took her forever to get the stuff to the 10th Court of Appeals in Waco, was because the official record, because she was not Ms. Butler's lawyer for the August 15th hearing, she couldn't file anything with the Court of Appeals until after she received the reporter's record, which was, I know it was after the election because I remember I called her to find out if she could give me specifics and she couldn't, but I believe she filed her, like the appeal, I believe she filed it on November 23rd. I believe she filed it on November 23rd. So
the reporter's record that we've been dealing with tonight, the record of the August 15th hearing, that was filed by the court reporter or transcribed by the court reporter on August the 30th.
No, Miss, I can't remember her other lawyer's name. Miss Jurek. I think her name is Jurek. Miss Jurek waited for the official court, I guess the clerk's file, before they could file anything with the Court of Appeals. So she did not have the information. I don't know when, and I actually didn't realize like that it was, I didn't realize the Morris case had anything to do with the Wilson case. So there was no reason for me to know that. I didn't know or should have known that I should go ask her about what was going on in Morris because it somehow had something to do with Wilson. It was not until we were preparing for that other hearing on November 17th where I learned that. And so I'm saying that there was not I didn't have to reasonably know any of that before I was put on notice that the judge was in both cases, that the case was filed in another court and all these things. So I don't believe, Judge, respectfully, that the date that the reporter's record was filed with the court is relevant to when I should have known of it, because I didn't know it had anything to do with it, and I didn't have access to it anyway. I was not her lawyer.
We'll find.
In that case, in the Morris case.
Well, you somehow got it produced for today's hearing.
I was, well, from the time I spoke with Ms. Jurek back in November, I mean, after the election, right before the thing, she didn't have the record. She didn't give it to me. And I can't just go up there and get protective order records. But I also didn't know that they were relevant. I didn't know that they were relevant because I was clear every time I went to court. I'm not in that case. I don't want to know anything about that case.
Okay. All right. Time out. I'll guess I'll have to judge later whether you should have known. Go ahead and present the evidence that you have to present. We'll try to get it done tonight.
Ms. Butler.
Yes, ma'am.
Before we left, the judge asked for you to give facts in the August 15th hearing where the judge kept you from presenting evidence. Did you find anything?
Yes, ma'am. So on page 41, we can start at line 3. Ms. Desicky said, Your Honor, I object as to relevance as to the protective order. And then I said, Your Honor, I do have a point. Judge Campbell said, what is it? I said, because Robert is saying that, or Mr. Johnson is saying that he terminated me because something he found, okay? So then the court says, I don't know, and there's 2 dashes there, think it's of any interest why he terminated you. So then I apologize. And then the court said, I have no interest in why he terminated employment. So then I go to say, so I guess what I'm trying to get at is basically he's not being honest at all. So then the court says, all I'm really concerned about is what is happening between you and Miss Morris and Miss Morris's 13-year-old child. And that's when I went on to say, there's never been a conflict with me and the child. As a matter of fact, she calls my house every night, and I go on and explain that. So then the judge says, ask a question, don't tell me. So then I said, but okay, well, here's a question. You said that you made a phone call. So then she said, no, my oldest daughter at the time. So, and I read that sentence to say, there goes again to where the judge interrupts what I say my train of thought is and me trying to get my valid point across on that line. So then we go to page 38. So we go to page 38, line 18. Line 19, Ms. Desky said, Your Honor, I'd object to relevance having to do with stalking. So then the court says, I was getting ready to ask that question too. Who filed this, Ms. Morris? So when Ms. Desky was speaking with Ms. Morris, it's like the judge, he got a little confused about what was going on at that time. And he straightened them back up by asking them questions to put Ms. Desky back in line with, as he says, the relevance to the protective order, or how was I stalking Ms. Morris?
Forgive me for interrupting, but what page are we on?
We're on page 38.
All right.
Miss Butler.
Yes,
So
ma'am.
is the reason you pointed out page 38, starting at what line?
I believe I said 18.
Okay, so on page 38, starting at page on line 18, you're bringing it up to say that the judge helped Miss Desky stay on track to try to keep her focused on the protective order stalking. Is that why you brought that up?
Correct, he did. He lined her back up. Like he was like, whoa, you're steering off, and let me get you back straight by asking her direct questions to get her back on the right track, because she was steering off somewhere else.
And so did the judge do that for you?
Absolutely not. And when I did ask a question, he says, well, I'm not going to give you legal advice when I did ask a question. So no. But yet he fed Ms. Desky or got her back on the right path. Because
so he
she
got
was
her back
all over. She was just as confused with the statement.
So he gave her legal questions, but told you he wasn't going to give you legal advice.
Correct.
Is that accurate?
To my knowledge, it is. And I'm reading it from the transcript.
Where did the judge say he wasn't going to give you legal advice?
You have to go all the way to the end, down on page 64, line 19. The court reads, I'm not giving any legal advice.
Line 19. But he gave legal advice. Okay, but so before he said that, who was he talking to?
Before you said what, Ms. Jones?
Before he said, I'm not giving any legal advice, before the court said, I'm not giving any legal advice, who was the judge
Oh, he was
referring?
talking to me. I had asked him a question and he just said, I'm not giving any legal advice. So on page 64, line 17 is when I said, how long do we have to do an appeal? And he says, the court reads, I'm not giving any legal advice. But like I stated, when you go back to page 38, he veered Ms. Desky back in the right direction.
So on page 64, line 21, it says proceedings adjourned. Who did that?
I'm getting there.
It's right after I'm not giving any legal advice.
The judge did. Judge Campbell, I'm sorry. Judge Campbell.
When you were talking about steering Ms. Desky back into legal line, how long does the court lead Ms. Desky from what part? From page 21 on page 38, line 21. Can you tell me how far down that the judge keeps interjecting and leading her?
All the way down. I'm past page 39 now. So I'm on page 40 still. I'm on page 41. I'm on page 42. So I'd say down to page 42.
42 where? Can you identify specifically, ma'am?
The last response from the court was on line 2 of page 42. Ask a question, don't tell me, is what the court read or said. I'm sorry.
But before that, the court was asking questions.
Correct. And then if you jump down to page 43, because then it was back to question answer. If you go back down to page 43, Ms. Desky.
Hold on. 43 and what? You got to tell us exactly where you're looking.
Okay, 43 and line 2. I'm sorry, 43, page 43 and line 2.
Okay.
Ms. Desky, Your Honor, I object. Where is the police report? Then I said, we were not prepared for this case, Your Honor. And then the witness says, and then the judge said, wait. And then your question is facts, not evidence. I'll sustain that. And then Desky says, thank you, Your Honor. So even then.
Even then what?
He sided once again with Ms. Desky.
So are you saying that Desky objected to the police? Desky objected. I'm confused. It says, yet according to the police report, I'm looking on page 42, line 23. I'm gonna start reading there. Yet according to the police report, it states that Deborah called saying that I was beating on the door and shaking the door handle, trying to get inside home. Right? So then Ms. Desky, on page 43, starting on line 1, Desky objects. So you're saying, why was that? You're saying, where did you get the police report from? Where did you get that from? Never mind. I'll move on. But you,
Yeah,
but you had the police report. Is that accurate?
No, I didn't have it in court. No.
No, but you said yet according to the police report. Had you seen the police report?
No, that's what Corporal Sleeth had told me when I spoke with him.
Oh, okay. So you had information from Corporal Sleeve and you were trying to get
Correct.
that evidence out in court based on what Corporal Sleeve had told you.
Correct.
Okay, all right,
Correct.
okay. So when Miss Desky objected, well, let's go back. When you look down on page 43, line 6, it appeared that the witness was trying to answer.
Mm-hmm.
Because you asked him on page 43, line 4, we were not prepared for this case, Your Honor. And then the witness says, because I just, and the court is the court stopped the witness?
Yes, the judge said, wait, as if like, be quiet, I'm siding with you, hush, I got this.
Okay,
Stop.
and then
Just stop. So he stopped.
all right, so he's doing things to, in your mind, is he doing things that are biased against you? Is the judge is doing things that are biased against? And the judge is
He was.
instructing. I'm sorry. What did you say?
He was.
And he
was.
And he interjected with no objection. I mean, after the court said, wait, and then the next thing you hear Ms. Desky say is, thank you, Your Honor.
Correct. So that furthermore let me.
I did not hear that answer. I did not hear the answer.
I'm sorry. I'm sorry, are you speaking to me, ma'am?
Yes, I could not hear the answer. Yes.
Oh, I just said correct. Yes, ma'am, I said correct.
So I want to move down to page 43, line 13. So line 13, you say, okay, after the judge in line 11 says he wanted to, until I hear evidence on it. So ask another question. You said, okay, didn't 2019 when your wife passed away, the minute you dropped her in the grave, y'all are next to my house. The first thing you did was to come to my house. Is that correct? And Ms. Desky says, line 17, Your Honor, and says that is correct. Who is that is correct? Who is that?
The witness says that is correct.
Who is the witness?
Robert Johnson.
Okay, so Ms. Desky then objects. Well, she says, excuse me, sir. The court says, let me hear the objection. So prior to Ms. Desky saying, excuse me, sir, had she said I object?
No.
So do you know why the judge said, let me hear the objection?
I mean, I don't understand all this language, but if you ask me in a different way, maybe I could give you an answer.
So Ms. Desky on line 21 then says, objection as to relevance to the protective order. And the court then says sustained. And then Desky says for Ms. Morris, and then the court says sustained. So what evidence was kept out when the judge sustained Ms. Desky's objection without you being able to explain why it was relevant?
Okay, so if you go back to line 13 on page 43, I was trying to explain to the judge how Mr. Johnson had came like literally running to my house after his wife passed and was trying to like hook up with me, and I wanted the judge to understand that this is not about stalking and harassment as Miss Morris claims. This is clearly about jealousy because her husband wants me. Her husband's been trying to date me for years. He's not my type. I made it clear to him.
Miss
I told
Butler,
him.
Miss Butler, let me stop you because I want you to stay on point. So the judge kept out of evidence what you tried to bring in, that the credibility of the witness and the credibility of Miss Morris making these allegations was not that you were stalking her. It was that she was jealous because her husband, you were trying to show that her husband liked you, and that was the motive behind it. So that was kept out.
Yes, ma'am.
Okay.
Yes, ma'am,
And
it is.
so in your estimation, was that another example of how every time you tried to let the judge know something that you believed was relevant, that would go to why the protective order was not warranted, you were not allowed by the judge to explain it? Is that what that was?
That's absolutely correct. And I mean, and as we all sit here now, I don't know how to, I guess, word things when I'm in court without being objected to, but I did my best without representation. So when I tried to explain to the judge, like this is not what it seems to be, but this is the real picture over here. I was objected to. I was pushed back. I was silenced. I didn't get to have a voice. I didn't get to put forth my evidence.
And I want to be clear. I was not present for this hearing. Is that accurate?
That's true.
I want to be clear. On August 15th, I was not present for this hearing. Is that accurate?
For this hearing, yes, ma'am.
For the
That's
August
accurate.
15th Morris hearing. Is it also
That's correct.
accurate that you did not talk to me about what happened in that hearing? Is that accurate?
That's completely accurate because you were not my attorney and I was not hiring you for that case. I was looking for an attorney.
So okay. So if you go to page 44, line 12. And going down, like till the end of the page. What was going on there? You know what? That's too broad. That's too broad. Let me say this. This was your time to cross-examine Mr. Johnson, correct?
Yes, ma'am. Correct.
And you were trying to cross-examine Mr. Johnson, correct?
Correct.
So you're asking questions from the top of page 44, starting at number 1, all the way down to number 11, correct?
That's correct.
And then the court just jumps in, correct?
That is correct. Page 12 is where line 12 is where the court jumps in. Yes, ma'am.
Right. Ms. Desky didn't jump in, correct?
No, she didn't. The Judge Campbell did.
Okay, so Judge Campbell just hijacks your cross-examination of Mr. Johnson and starts asking questions that Ms. Desky was not asking. Is that accurate?
That's correct. Yes.
So look down to page 44, starting on line 20 and to the end of the page. So when on number 24, you say, yes, sir. That was just a question that the DA asked. So I just know, what was that about from you? Like, did that have any, let me be more specific. Did that have anything to do with you trying, I guess, pick up where the judge left off so that you can go back and cross-examine Mr. Johnson the best way you knew how to show that 30, at cause number 30, 691 protective order should not be granted?
That's true.
So what was the significance of that, of what you said?
Are we on page 44, correct?
Page 44, line 24, and after that. Through 45.
Okay. Okay, so on page 44, line 25, I said, yes, sir. That was just a question the DA had asked. And then the judge interrupted me again. He said, I'm well aware of the hearing and the prior hearing that there's all kinds of fights between this man and whatever y'all's. And then I said, okay. And then the judge said, relationship is or was. And then there was a question asked. So I just want to be clear. You said that you have never witnessed me stalking or calling or coming by your home. So so on page 44, line 25 to page 45, line 5, it was another interruption which threw me off my game again. So when I'm trying to focus on hoping at asking the right questions without being objected to, the judge interrupts, not Ms. Desky. Here, as you can see, the judge stops me and would ask me questions and not the DA. So therefore, in my opinion, the judge was helping the DA with her case and was biased and prejudiced against me in my case.
Did it seem like to you that the judge had already made up his mind about who he believed?
The judge made up his mind about who he believed in our case with Wilson versus Butler before he even got to Morris versus Butler. Because I truly believe in my heart, had he kept going and heard even our case, he still would have said, even with all the facts that I have presented for that case, the judge still would have said, I'm going to grant a protective order based on this. He'd have found something in there to wiggle it around. So yes, I believe his mind was definitely made up.
I'm sorry, I just want to be clear. So you believe that that in the judge's mind, based on his actions and his words and his helping Ms. Desky, that he was going to rule against you anyway?
Exactly. Yes, ma'am.
Let's go to page 49.
Okay.
Hold on. I'm sorry. I think we already talked about that. Let me just look at my notes. We already talked about after his wife's funeral, correct? Yes, we did. Hold on. Let's go to, and again, would you agree that I was not involved in your discussions and your attorney-client privilege discussions with Ms. Jurek in case number 3691? I was not, correct?
You were not. You did not speak with her because, for one, I said no, because it's costing me to pay both attorneys just to talk to each other. And I'm like, well, just ask me what you need and I can get it to you, okay? And the only reason why I agreed to allow you to speak with her last night was so that you could have a clear understanding, because I'm not giving you the words that you need. So I said, okay, go ahead and call, and I'll send her a text telling her it's okay for the two of you to speak. So not until late last night.
So I had, until last night, as a non-lawyer, you didn't believe that that case could bear, I'm sorry, that case is Morris's case, could bear on the bias, the prejudice, and the ruling contrary to the law of the case that I represented you on.
That's right, because I did not understand the language. So after I spoke with you and you explained it to me, I said, okay, go ahead and call Ms. Jurek. I'll let Ms. Jurek know it's okay for the two of you to speak. So when the two of you spoke, and the language that you two speak, totally different from what I speak and understand, then you two ladies were like, oh, wait, so this does make sense, and we do need to do this, that, or the other. And I remember you telling me, yes, I need to file this like right now, because this is, I just learned this and I need to get this done. I need to file this right now. And so we got off the phone so you can write that report up and send it. And that was my memory of yesterday. Well, that's exactly what happened yesterday.
So prior to yesterday, even though I kept saying when you would make layperson explanations of things to me, even though I told you I really need to speak with her because you don't understand.
Why?
Why? I know you just said you had to pay for me to talk to her and whatever. What was different about you? Let me ask this. Once I found out that these documents existed, right, yesterday, did I say to you, I've got to get off the phone now. I've got to file this because I read the rule to you, 18B. Do you remember that?
Yeah.
Do you remember me reading that to
I
you?
do.
Saying I have
Yes,
to file
ma'am.
it as practicable as possible. And so I literally drafted the document. I stopped preparing for this hearing. Would you agree?
Mm-hmm.
And
That's right. That's why we amended.
I told you, I've got to draft it now. I just found out about it. I can't wait until in the morning. Is that accurate?
That's right. That is
Did you not,
absolutely.
Did you not tell me, Ms. Jones, I have family over and I don't know if I'm going to be available? And I told you, you better be available. Is that accurate?
That's right. Yes, ma'am.
And did I tell you that I had to go connect you with a notary because it had to be verified? Did I tell you that?
Yes, ma'am, that she had to verify that it was me that she was notarizing the paperwork for late last night. Yes, ma'am.
And did you not FaceTime? Well, I wasn't a part of that because I just gave her the doc. Did you not FaceTime with the notary last night so that she could verify that? And did you send the notary your driver's license?
I sent you my driver's license. You sent it to the notary. The notary said, well, I need to verify that this is Ms. Butler. So you called us on three-way and said, Ms. Butler, can I give her your number so that she can, do you have an iPhone? I said, yes. You said, can I give her your phone number so that she can call you, FaceTime you, I'm sorry, and make sure that it's you? And I said, of course. So then the notary FaceTimed me and she said, thank you, Ms. Butler. That's all I needed to see was your face to match with your driver's license, and the FaceTime ended.
Okay, so the first I found out, and is that, if you know, is that why in this amended motion that I specifically made reference of documents that I just learned about only because you finally trusted your lawyer?
That's true.
When you go back to your communications with Ms. Jurek, if you know, because I'm not a part of that, when did Ms. Jurek get the reporter's record from the Burleson County Courthouse, if you know?
I can look through my case, but that'll take me a second, of course. But I do recall Ms. Jurick sent over the request for the paperwork, which I know for a fact that Ms. Desky and the DA's, not the DA's office, I'm sorry, that Ms. Desky and the clerk's office did not, they took their time throughout my entire case, even giving Ms. Jurick the information that she needed. That's one, what has prolonged my appeal. And two is why you didn't have it, or why Ms. Jurick didn't have it, because we were waiting to get the paperwork. We had to wait. It was, the ball was out of our court. We had to wait to get the paperwork from the clerk's office and the court.
So let me ask you this. So when you finally, do you know the date that Ms. Jurick filed? Do you have a copy of the reply to response to emergency motion to stay appeal from from case number 3691? Do you have that document?
I'm sorry, Ms. Jones. What document are you wanting?
The document that was filed on November 23rd, 2022 at 5:36 p.m. to the 10th Court of Appeals in Waco, appealing the case in the this case, the Morris case. Do you have that document?
I'm sure. I'm looking it up right now.
And if it helps, it was filed on November 23rd of 2022.
Okay, perfect. It's loading. You said November what? I'm sorry.
November 23rd of 2022. The document that Ms. Jurick filed with the 10th District in Waco to the Court of Appeals. Do you have that document?
Okay, will it be the one titled Notice of Expunction Final?
No. It says
No?
reply to
Okay.
response to emergency motion to stay on protective order.
Reply to motion to response. Oh, now it's giving me some kind of error. So
Let me ask you this. Maybe you can answer this anyway. Do you know why Ms. Jurick filed it on 11/23/2022? Do you know if it's because that's when she finally got the reporter's record and the clerk's file from Burleson County? Do you know that?
I'm sure that's why. Yes, because Ms. Jurick was waiting for them to send her the documents. She couldn't file something without documents. She needed documents and she didn't have that. So she had to wait until she received the documents in order to file.
And so do you know that the first that I knew that this document had been filed and that Ms. Jurick sent it to me was last night?
That is very true.
If you recall, when we were preparing, so first of all, did I call it? Do you know that I was in Austin on Friday? Did you know that? Did we speak?
Yes, you were in Austin.
Right.
We spoke, yes.
did I not also call you and tell you that on Thursday, the 8th, that I was forced to cancel my rental car and my hotel in Austin for Thursday night because I had an obligation in Austin on Friday because I could not leave you in a lurch and not be prepared for a hearing because the judge had denied the first
Correct.
legislative motion for continuance. Did I tell
Yes,
you that?
ma'am. Yes,
But I
ma'am.
told you that I was gonna put it off, lose my money and everything. Is that accurate?
Yes, ma'am. Yes, ma'am.
On Friday, did I not tell you that I had to file another one? And that I couldn't get back to Houston. I couldn't fix up and get back to Houston until Saturday night, but that I was gonna call you on Sunday and prepare for the hearing today.
Correct.
Did I also call you from Austin and let you know that we had to meet in person on Monday? Actually, it was before 6 o'clock. Do you remember that? Me saying that we have court on Monday, so have your witnesses ready to talk to me on Sunday because that's as soon as I can get back. Did that happen?
Yes, ma'am.
At some point on Sunday, after you finally gave me permission, actually, and gave Miss Jurek permission, isn't it true that I called Miss Jurek and she wouldn't answer my phone calls? Isn't that true?
True, because I directed her not to.
Isn't it true that I called you saying, hey, I'm trying to call her so I can understand what you told me? And you was like, what do you need to talk to her for? You can get your answers from me. Isn't that true?
Yes, that's what I said. Yep.
And did I not tell you I didn't understand what you were saying? Isn't that
Correct.
true? And so you finally relented and allowed me to speak with Miss Jurek on yesterday?
Correct, because I couldn't explain it to you the way, in legal terms, the way that Miss Jury could explain to you. So yes.
And so you literally had to give her permission to talk to me after I was exasperated with you. Is that accurate?
That's true.
After I filed the amended motion, did I not then call you back and I guess pick up where we left off before I stopped it to draft the amendment because I just found out about the information?
That's correct.
So did I explain to you after I received the documents in preparation for this hearing today, like after I saw the documents, I explained to you why they were relevant? Is that true?
Yes, ma'am.
So is it your belief that Judge Campbell's impartiality related to you might be questioned?
Should have been questioned. Yes, ma'am.
For all the reasons you said?
Yes, ma'am.
Did you believe that the judge had a personal bias or prejudice
against you in his presiding over your case in the Morris case?
Yes, ma'am, I do.
Do you believe that the judge had a personal bias or prejudice concerning his presiding over the case in the Wilson case against you?
Definitely, yes, ma'am. Not only do I believe, but after the ruling was made in the Morris versus Butler case, you could hear the entire audience in the background say, huh? Everybody in the courtroom was even surprised that the protective order was even granted. It blew everybody away.
And how long did you say that hearing took place?
At least an hour. Definitely wasn't 15 minutes that he was pressuring us to have. It was longer than 15 minutes, way longer.
So he pressured us to have a 15-minute protective order hearing in the Wilson case. Is that accurate?
Yes, ma'am. But he gave Ms. Desky all the time she needed in the Morris and Butler case without me having canceled. Yes, ma'am.
And the judge he wanted the case, the Morris case, he was trying to make it as short as possible. Is that accurate?
You said in the Morris case, he was trying to make it short as possible?
Yes, you were. Let me go back and rephrase that.
In the Wilson case, he was.
Right. In the Morris case, weren't you trying to get evidence out and you were prevented from getting it out because he sustained objections from Ms. Desky?
That's correct.
So the Morris case would have taken longer had the judge not shut you down time after time. Is that accurate?
That is correct.
And you didn't receive any notice of the August 15th hearing. Is that accurate?
That is accurate. No notice. I never knew I even had a protective order against me. And which is scary because I was in the same vicinity as Ms. Morris. So to not know that I had an order against me, and which I was there first and then she came, you know, I could have been arrested and I wouldn't have had an clue why am I being arrested.
So it's not just the judge's rulings and actions in the Wilson case that caused you to know that the judge was not impartial related to you. Is that accurate?
That's correct, because he started in being biased and prejudiced in the Wilson case before we even got to the Morris case. That's why I knew when we got to the Morris case, I was hung before I can even get up. I already knew it.
So your motion to recuse and disqualify is not just based on the Morris case either, related to the judge's impartiality in the proceedings over you. Is that accurate?
That is accurate.
That the judge is rolling his eyes whenever you were presenting evidence, whether that evidence was being presented by me as your lawyer in the Wilson case, or whether the evidence was being presented by you in the Morris case. Did that cause you to question the judge's impartiality?
Yes, ma'am.
Did the judge dropping pencils on his desk in the Morris case cause you to question the judge's impartiality related to you in the Morris case?
Yes, ma'am.
Did the judges asking legal questions for Ms. Desky cause you to feel like the judge was personally biased against you in the Morris case?
Yes, ma'am. Not only did I see it, everyone in that courtroom witnessed it. Because when I stepped outside of that courtroom, people that I don't even know were running outside saying, Miss Butler, I'm sorry. I don't see what the judge seen, because you stated these points and you made it clear that no matter what day Miss Morris said you stalked or harassed her, it was not you. You made that clear. So I was only the only one applaud. Everyone in the courtroom was, of course, but Miss Desky and Miss Morris, because it was funny to them. They laughed all the way out the door. They were literally laughing. They laughed all the way out the door.
Miss Butler, people that came up to you, did you know them?
No, ma'am.
Did you
It's
ask any of
civilians
them?
that were in the courtroom.
So they were sitting there during the hearing.
Yes, ma'am.
So the judge interrupting me in the Wilson case, did that cause you to question the judge's impartiality in the Wilson case?
Of course.
Did that same behavior cause you to question the personal bias or prejudice of the judge related to you?
Of course, it showed it. It clearly showed it. There was no questions and no doubts about it. The Judge Campbell showed his bias and his prejudice toward me and you. He sure did.
Did in the judges, I'm just asking, were you confused that Judge Campbell was hearing the case in the 335th? Were you confused about that?
I was confused because I was, and like I said, I was thinking that if I appeared in the 335th, that's where my case should have been heard, not heard and tried, or the final protective order signed in the 21st. So it was confusing, but I mean, nothing I could have done about it. I mean, I appeared in court and did as I was told, you know?
So did the judge refusing to go forward on a pref-set case, namely the Wilson case, on a date that you were noticed for, did the judge refusing to go forward on that case and instead going forward on a case that you didn't even know you had in court? Did that cause you to question the judge's impartiality as it related to your cases before him?
Yes, ma'am. It was clear, because if you had time to hear another case against me, a false case against me, and other cases in the courtroom, which you assured me and my client and my attorney that case was going to be preferentially set, then you had time to allow me and my attorney to go forth with the Wilson versus Butler case and not hear or allow me to get an attorney for the Morris versus Butler case. Instead of hearing that case, he should have heard our case. But that goes to show how biased and prejudiced he is toward me.
And
because you can't say you didn't have the time. The judge had the time because he heard their case. He heard another case when he should have just kept letting us go forward.
So there were at least 2 occasions on June 24th and on August 15th where we appeared and announced ready to move forward. Is that accurate?
Yes, ma'am, it is.
And on those occasions, on one, we got interrupted, and on the other one, we just got moved.
Correct.
And on the November 17th date, we were pressured to give a date, even though I advised the court that I didn't have any. Is that accurate?
That's accurate.
And did the court forcing me to pick a date, because there's no way I'm that busy in his terms, did that cause you to question the judge's impartiality related to you?
It is, because you know, when I think about it, I've sat in this same courtroom in front of this same judge for other cases where there was custody cases with my children. And I've heard Judge Campbell ask other attorneys, well, and laughed and talked with them. Well, can you look on your books and tell me when you're available? Versus you was more like, well, this is what we're gonna do. So, hey, y'all better be ready. And then when you're ready, I'm just gonna push you back off again. That is what I got. And like I said, I have watched him time after time after time in the Burleson County courtroom, and he treated other people differently than he did myself and my African American attorney. He definitely treated us differently. We were definitely biased. He was definitely biased and definitely showed prejudice in that court hearing on August 5th, on June 24th. Anytime I appeared in that courtroom with Ms. Jones, Ms. Deskey's attitude was different. Judge Campbell's attitude was different. The way Ms. Deskey even approached my attorney was so unprofessional and so rude. The way the judge handled my attorney was so unprofessional and so rude. The way I was cut off and threatened to even be thrown in jail. You
just said something. You just said that you've been in the courtroom you've been in the courtroom and you've observed the judge's demeanor with other lawyers that weren't me. Mm-hmm. When did you have the opportunity to observe the judge's demeanor with other lawyers?
Well, as I stated, when I was going through for my child custody cases, I watched Judge Campbell, and I watched him even with other like, how do you say it, defendants, however you say it, people that were coming forward in front of him who didn't have attorneys. I mean, for worse cases than mine, drugs or abuse or family violence, true cases that they had hard evidence right there in front of him. He allowed them to talk, he listened, he showed sympathy, he understood. But I get up there and I'm pleading to the best I know how and trying to explain, Your Honor, this is not me. This is definitely defamation of character. This is not me, Your Honor. It's not me. He wasn't trying to hear it. And he showed me he wasn't. When he was in front of other people, he didn't throw his stuff around. He didn't throw his pen down. He didn't turn red in the face. He didn't pull his glasses. He didn't do any of that. Judge Campbell sat there straight and he talked to them, or he would sympathize with them, and he smiled even. But me, he was over me before I even could open my mouth and speak. He was done.
Let me ask you this, Ms. Butler. So the judge was professional in your observation of Judge Campbell, both presiding over cases with you and presiding over cases with other people. You're saying that Judge Campbell's demeanor was professional with other people, but his demeanor when it came to you was not the same.
That's exactly correct.
And you're saying that where Judge Campbell allowed people in other cases to present evidence, even when they had much more serious allegations, he did not interrupt them.
No, ma'am. As a matter of fact, when my attorney, I'm sorry.
As a matter of fact, what? As a matter of fact, what?
As a matter of fact, when Attorney Jurek and I went to court, there was a case that was being heard before us where a young man needed to do something as far as probation or violation or something. And he was just like, okay, all right, sir, good deal. very, very, very professional with him. Did not show any type of aggression or attitude or bias or prejudice, none of the above. Were the cases I even sat there that day and heard him on. But it never
So-
fell. When it was my turn, I was treated differently, and that's a fact.
And so when Judge Campbell, so Judge Campbell's demeanor in other cases was, would you agree with me that you believe a judge is supposed to like not have an opinion formed? Would you agree with me that?
Well, he's not. He's supposed to hear you out and then form an opinion, not form an opinion first and then hear you out. No,
So
it's not the way to do it.
So you've actually seen Judge Campbell allow people to present their cases. Is that
Yes,
accurate?
ma'am, I have multiple times. Yes, ma'am.
And he allowed them to present their cases.
Yes, ma'am.
Have you
And
ever
even
seen-
offered some that were in the courtroom that didn't have attorneys. Well, let me appoint you an attorney. I've witnessed it multiple times. Multiple
And-
times.
And so, but Judge Campbell didn't appoint you an attorney in this protective order case. Is that accurate?
Now it was, you're gonna go forward today. Even though Ms. Desky said, Your Honor, she knew about this. No, ma'am. She said that I was served. She said I knew about it in June 2nd. And as I was getting ready to defend that, of course, I was cut off because I did not know about it June 2nd. First of all, I'm no psychic. Secondly, Deborah Lynn Morris and I did not have any type of conflict. So thirdly, why would I even assume that I'm going to have a protective order against me when I know that there is no problem or no issue at large?
Well, so you clearly thought there was no problem, and there was, but that's neither here nor there. But so you've seen Judge Campbell be like the judges that you think judges should be, like fair to all sides. You've seen that.
Correct. Hear the story, then form the court's opinion. Yes, ma'am. Correct.
Except for
Hear both sides first.
So did you seen Judge Campbell outside of your cases with other people? Well, let me ask you this. Have you seen Judge Campbell
Yes.
preside over pro se people? Do you know what pro se means?
No, you're going to have to explain that.
Pro se means you don't have a lawyer.
Okay, yes, I have. Yes.
Okay, so have you seen Judge Campbell preside over people who didn't have a lawyer before?
Yes, ma'am.
And how did Judge Campbell preside over them compared to how he presided over you in the Morris case?
Well, for example, there was a young lady in court one morning with a short bob cut brown hair. I can't say her name because I won't. Who was there for child abuse. He was just as nice to her, offered her an attorney because she said she could not afford one. So he gave her a court-appointed attorney, assigned her a court-appointed attorney, and then told her to go to the desk that was to the left of him and get her court date rescheduled and speak with, I can't remember the attorney's name that was in the courtroom, but that's who he assigned her to. If I'm remembering correctly, he assigned her to that attorney, and then they reset their court date so that that attorney could have.
Your Honor, I'd object to this line of questioning since statutorily CPS matters and felony criminal matters have to have a court appointment. A civil protective order does not.
So Judge, may I respond?
Yes, please.
So Miss Butler believes, and I believe rightfully so, that the judge was biased or prejudiced against her and that the judge was not impartial when it came to her. Her seeing other cases that were not her with people who had, with people before the court, with parties before the court who either had lawyers or who did not have lawyers, gave her a baseline to compare her treatment by the judge to Miss Butler's.
I understand. I overrule the objection.
So, Miss Butler, you saw people charged with child abuse before Judge Campbell. Accurate?
Accurate.
You weren't charged with child abuse, were you?
Oh, no.
You saw people charged with far greater allegations than stalking on 2 occasions. Is that accurate?
Ms. Jones,
That's accurate.
I'm sorry. Ms. Jones, I just got through hearing all that. I listened to it.
Okay.
I understand. You don't have to tell me 3
Okay.
times. You're working on number 2 right now, and that's why I've cut you off.
Okay, well.
I understand the point.
Okay.
I got it.
So you testified earlier, Miss Butler. Somebody told you, oh, you can bring that up on the motion for new trial. Did you testify to that?
You said somebody told me I
Well,
can
then you
bring
said
that up on the.
somebody. Yes, after your August 15th hearing, you said you were told, or you can take it up on the motion for new trial. Do you recall that?
Yes.
If you recall, who told you that?
Judge Campbell.
So after Judge Campbell
Are you-
granted, you have a question, tell me. If you have a question, tell me.
No, I'm listening.
So you believed Judge Campbell, Judge Campbell told you you could take up any concerns about this hearing that you didn't have notice of on a motion for new trial. Is that what you testified to?
Just now, yes.
So did you think you were going to get a fair shake? First of all, did you know a motion for new trial existed?
No, I didn't, but I knew I could appeal. And I was really confused even on exactly how appeals work until my attorney, Ms. Jurek, broke it down to me and explained to me. But I was led to believe that we were going to get a new trial. And even then, we were not. Even though Ms. Jurek was very valid, very straightforward, gave him the 15 minutes he wanted, we still were denied a motion for a new trial. And the evidence was there. We were still denied.
So you knew cases could be appealed. Is that what you just testified to?
Yes. Yes.
But you didn't know about a motion for new trial, except for Judge Campbell telling you, oh, you can file a motion for new trial since you didn't have a lawyer now. Is that accurate?
No, Judge Campbell didn't tell me I can file a motion for a new trial. My attorney, Ms. Jurek, told me I can file a motion that we could go forward and file for a motion for a new trial.
Okay.
The judge clearly said, I'm not gonna give you legal advice. So no, Judge Campbell did not say that. And I'm sorry if I confused y'all. No, Judge Campbell did not say that.
Okay, so in the Morris case, a motion for new trial was filed. Is that accurate?
Yes.
Who heard the motion for new trial?
Judge Campbell, and Ms. Desky was the DA on the case as well.
If you know, the motion for new trial was filed in what court?
Oh, there we go. That's too detailed for me, but
if you don't know, that's fine. That's fine.
I don't know.
And
my attorney would know.
I'm sorry, ma'am, what did you say?
My attorney would know. I don't know what was filed next or where.
Okay. And you don't know where, or you don't know when Ms. Jurek received documents from the Burleson County Courthouse. You don't know that date.
I don't know the exact date, but I do know she said, well, Ms. Butler, I got everything done on our end. Now we're just waiting on them. So, and they're very punctual. her assistant is, I mean, hands down the best. She constantly is letting me know, like, this is what's going on now. This is what's going on now. We still haven't received it. We still haven't received it. I'm sorry, Ms. Butler. You know, we've done everything we can. Now we're just waiting on them. Ms. Desky says that she does not, Ms. Desky says that she does not, she's not available after business hours. Yet earlier today, Ms. Desky said, oh, I work all the time. I work late all the time. But you told Ms. Jurick, or Ms. Desky told Ms. Jurick that she was unavailable after business hours. And not half of the time, majority of the time, wouldn't even answer our phone calls or properly respond back to us.
So Miss Butler, in order for me to be able to let the court know when your other lawyer received the reporter's record and the clerk's file, I would have to get that information from her. Is that accurate?
That's correct, which you didn't get till last night. Yes.
Okay, so I would need her. Okay, because you don't know that.
I'm sorry.
I said, because you don't know that.
Okay.
All right. I pass the witness for now, Judge.
Your Honor, I have a few questions, if you don't mind, or does our reporter need a break?
Reporter, are you doing okay?
I'm doing okay. I don't know. I can't keep going till like 9 or 10 o'clock tonight, but I'm okay right now.
Thank
All right,
you.
ask your questions.
Okay, Ms. Moore. At any time on the record when Judge Campbell said we were proceeding with that hearing on August 15th, did you say, I have evidence to present, I have documents to present, I have witnesses to present? At the beginning, when he asked, were you ready? Did you state any of those things on the record? Ms. Butler.
I'm sorry. Are you speaking to me?
Yes, ma'am. I'm sorry, Ms. Butler.
Oh, it's Ms. Butler, not Ms. Morris.
I know. I apologize. On the Morris case,
Uh-huh.
when the court asked you if you were ready to proceed, did you state on the record that you had evidence to present, you had documents to present, you had witnesses to present?
What I stated was I did not have counsel and I am not ready. That's saying more than enough. I am not prepared. I do not have counsel is what I stated.
Okay, and I believe that you testified that I only had two witnesses, Ms. Morris and her husband. Is that right?
That's right. Those are the only two that you had go on the witness stand. That's correct.
Didn't Corporal Sleeth testify?
Oh, he did. Okay, so excuse my French. He did. Yes. Corporal Sleeth and Mr. Johnson and Miss Morris. So 3 witnesses, but not 12 as in Miss Wilson's case.
So and you said you weren't aware of the Morris case, is that right?
Okay, be more specific.
That you were
I wasn't aware as of June 2nd when you said I was aware. I was not aware then.
No, but as
Yes,
of
ma'am.
June 20th, if the court records show, the constable served you the application, the affidavit and the temporary order on the Morris case. Is that correct?
That's correct. It's about 7:20-ish a.m. That is correct. I was made aware then, but not June 2nd when you said I was. June 20th.
It was June 20th.
That's right. Yes, ma'am.
The second is when I filed the case.
Yes, ma'am.
But you were aware on August 15th this case existed.
I was aware it existed. I was not served to be in court August 15th on a preset case. So.
Okay. But you had been served with the hearing for June.
I'm sorry, I didn't hear you.
I'm sorry, I was what?
That's fine. I'll let it go. And you have since hired an attorney to appeal your Morris case.
You're well aware of that. Yes, ma'am. I hired Ms. Jurek. Yes, ma'am. Who you refuse to be even professional with. Yes, ma'am.
However, she filed a motion for a new trial, which Judge Campbell let be overruled by law because there wasn't a ruling. Is that right?
I'm not understanding your question.
Okay. She filed a motion for new trial with several pages of documents. Is that right?
I guess.
She didn't give you a copy of what your attorney filed?
I have a copy of my attorney's file, but
Okay.
it sounds like you're trying to get an answer out of me that is irrelevant. I mean,
I'm sorry if it's irrelevant. I think your attorney can object.
Let's go on.
Thank you. So there's also, your attorney tried to reach out to me to see if I would agree to a stay for the protective order, correct?
Objection.
she did. Yes, correct.
Oh,
Okay. And I would not agree to that. Is that right?
That's correct. You didn't agree to it. Yes.
However, the Court of Appeals last week has ruled that the stay has been denied.
Well, actually, it's a protective order case. And from my knowledge and from my study in this now, since I'm so new to all this, I have begun to read and learn on my own. Protective order cases are not normally approved for a stay because it's a protective order case,
No, ma'am.
especially when they haven't, the appeal case has not had time to review all the evidence. I mean, what if I was a serial killer and I was after Miss Morris? They're not going to say put a stay on it. They have to wait until they can review all the evidence. So from
All
my
right,
knowledge and my
ladies,
understanding,
ladies, I want to talk a minute. Guess what? If you're both trying to compete for airtime, I can't hear either one of you. And the reporter can't take down what you're saying. And I have to give you a couple of minutes break while I take this phone call. That's very important to me.
Yes, Your Honor.
yes, sir.
thank you.
Sorry,
What's
Judge.
a couple of minutes, Judge?
Hello? Yes. Got it. Just a minute. Let me mute my phone. Okay, everyone. I'm sorry I had to take that phone call from my daughter.
Hope everything is okay.
Sure. Ms. Deskey, it's your witness.
Thank you, Your Honor. Moving on to the second case, the Wilson case, actually, which is the first case, Wilson. Ms. Butler, do you
Yes,
recall,
ma'am.
do you recall when you were served with that case?
Yes, ma'am.
And what date was that?
Woo, that's been so long ago. I can't give you an exact date.
Could it have been January 6th of 2022?
Objection
I just said I
calls for
could give you an
speculation.
exact date.
That's fine.
Okay, look, guys, it both lawyers, I'm sure, know exactly when she was served in the Wilson case. Let's not quibble around about it. Can't we stipulate to that?
Yes, sir.
Quite frankly, Judge, I'd have to go back and look at my files because I just want to make sure that it's accurate. So
All right,
I don't.
Go on, Ms. Deskey.
Thank you. It's been several months. Would you agree to that?
That I was served for Miss Wilson's case, correct?
Yes, ma'am.
Yeah, it's been a while. It's been a while since I was served, yes.
Okay. And have there been several settings on that particular case?
Yes, but my attorney was also notified for each setting on that case.
Right, but Judge Campbell granted all the continuances and resets that were requested, correct?
Requested by whom?
By either party.
You said, oh, I'm sorry, just repeat the last part of your question.
On the Wilson case,
Uh-huh.
there have been several court settings. Is that correct?
Okay. Yes, there has.
And there's been several motions for continuance by both sides. Is that right?
That's correct.
And he has granted all of those. Is that right?
Well, I mean, I post so because they were signed.
Okay. And on August 15th, Judge Campbell set aside a special setting for that November date. Is that right?
No, on June 4th, Judge Campbell set aside a special date for the August 15th date. No,
Okay.
ma'am, not for August to November. No, ma'am.
So
We were supposed to be.
the fact that there were other cases on the docket and the regular docket day, which is our Mondays. Okay, but did he not schedule November 17th the entire day and said, we will stay into the night if we need to? I have no other cases on my docket.
From what I can remember, and to be perfectly honest, that was supposed to happen August 15th.
However,
August 15th, not November.
he gave a new setting for November. Is that right?
I wasn't aware of a setting for November.
Have you ever run into Judge Campbell out in the public where he's been inappropriate or rude or anything like that?
Judge Campbell would have to run into me either at home, at HEB, or at First Baptist, or Caldwell Junior High. I don't go many places.
You didn't like his ruling on the Morris case, did you?
I didn't like his what? I'm sorry.
You didn't like his ruling granting the protective order on Morris, did you?
His ruling on the Morris case was very biased and very prejudice. Yes, ma'am.
As the trier of fact and credibility of the witnesses, do you know how much weight he put on what witness?
Objection calls for speculation.
Just asked if she knew.
Speculation if she has to guess. If she knows, I don't have an objection.
Ms. Butler, do you know how to answer that question?
Okay, Ms. Deskey, ask me again. Your phone's kind of glitching.
Sorry, it's county internet. I apologize.
It's okay.
It might help if you get closer to the microphone.
Yes, sir.
Yeah, 'cause I'm sorry, I can't hear you.
Okay, I'll ask another question. Ms. Butler, do you know how often I go in front of Judge Campbell? How many hearings I've had?
No,
Objection
ma'am, I'm not
relevant.
your assistant. I don't know.
Overruled. You can answer the question, please, if you know.
No, ma'am, I'm not your assistant. I don't know.
Do you know how often he's ruled against me?
Objection to relevance.
Relevance says he's biased and prejudicial towards me. It's just a question.
Actually, that is not the allegation, Judge. In response, that is not the allegation. The allegation is that he's biased and prejudiced against Ms. Butler.
I believe Ms. Butler has testified that he bent over backwards to assist me.
Well,
In my case,
hang on. Don't we all know that this witness, Ms. Butler, has no idea how often he rules for or against you? Unless you expect me to infer some knowledge just based on the question alone.
I'll withdraw the question, Your Honor.
That would be good.
Going back to the Morris hearing, you did have two witnesses yourself, right?
that's correct.
And who were those witnesses?
Miss Burns, Miss Darlene Burns, and Michael Butler. My mother is Darlene, my son is Michael.
Okay. And were you able to question those witnesses?
Yes,
We could-
ma'am.
I don't think we could understand your question.
Were you given the opportunity to ask questions of your witnesses?
Somewhat of an opportunity.
Were you allowed to bring forth witnesses?
Yeah, last minute. Yes, ma'am.
Did you elicit any testimony from either one about burn injuries or things like that?
I
I'm
was
sorry, I
not.
didn't hear the question. I don't know if I need to object, and I didn't understand the question because she went in and out. Could you repeat the question, please?
I apologize. I asked her if she brought forth any testimony from her mother or her son that talked about her burn injuries and inability to drive.
Can I answer, Your Honor?
I'm sorry, what?
Do I answer?
Yes.
Okay. So when the testimony was brought about, no, the case was a total surprise. I wasn't there for it. I wasn't prepared for it. I just wasn't ready. But believe me, if I was ready, you would have had it. The judge would have had all the information. Both of you would have had everything you needed to order correctly on that order.
However, that case is up in the courts of appeals at this time for them to make that determination. Is that right?
That's true, because the judge denied us of a new trial.
Okay, I'll pass the
And you
witness.
know this.
So I need to clarify some things. So I have a question. One of the papers that your attorney asked me to consider is the document that shows when you were served in the Morris case. And it shows you were served on June 20th
Yes, sir.
at 7:00 a.m. And it also says in this paper that there's to be a hearing on the application for a protective order at 9 a.m. on June 24th, 2022.
Mhm.
Did you go to court that day?
Yes, sir, I appeared, but Miss Morris's case was never brought up when I appeared, Your Honor. It was never talked about. I was never reset for it. It was like I only appeared for Miss Wilson's case, not Miss Morris's case, even though I was served, because it clearly shows that I was served for Miss Morris's case. But when I went to court, Miss Morris's name was not even brought up as far as like going forth on June 24th. But yes, sir, I was there. But it was no
So,
mentioning of Miss Morris when I was there.
so none of the clerks there, none of the court officers said anything about the new court date you were to come back to on the Morris case.
No, sir, no one. Not the judge, not the DA, not her assistant, not the judge's assistant, not any of the ladies that sit next to the judge, not the bailiff. I mean, no one, sir, no one.
So how long were you there at court, if you remember? Roughly.
I don't vaguely remember, but maybe 30 minutes, maybe. I don't really remember. It's been a lot. I kind of got a little cold, my head spinning, but I know I was there, and I do know I was not served about a new court hearing. I'm sorry, because I was served June 20th, but I wasn't given any documentation about a new court date, so forth. And Miss Morris's case was never brought up on June 24th.
So what did you do about that? Did you just walk away? Or did you go up to a court officer and say, what about me in the Morris case?
Oh, well, honestly, this is so new. When my attorney said, hey, we've been reset, I was like, okay, do we go home? She's like, yeah, they've reset us.
Wait,
So, and when I say my attorney, I mean,
wait. Who was your lawyer that you're referring to on June 24th?
Miss Jones.
I think you may be confused. We're talking about the Morris case.
Yes, sir.
You were served with a paper that said, come to court on June 24th in the Morris case. You've just
Correct.
testified that you went there.
Yes, sir.
Did you have a lawyer or not that day?
No, I'm sorry. I did not have an attorney that day.
Okay, so you weren't steered away by some lawyer. You just, so my question to you is, what did you do after you showed up?
Me and Miss Jones went back to the witness room, and Miss Desky, I heard her after we came back out of the witness room, we came back into the left side of the courtroom, and Miss Desky, they were talking and said, so are you going to represent her for that case? And she was like, no, I haven't been hired on that case. And that was it. Miss Desky went one way and I went the other way, and Miss Jones went one way.
All right, so tell me why Miss Jones was there on June 24th if she was not your lawyer in that case.
For Miss Wilson's case.
Okay, I understand the hour is late and you may be tired like all of us are, but concentrate on this. We're talking about June 24th, the Morris case.
Yes, sir.
And I got the distinct impression that you were there by yourself.
For Miss Morris's case, yes, sir, I was.
So
But
was Miss Jones also there on the Wilson case?
Yes, sir, she was.
Okay, so she was there.
Yes, sir.
And they rescheduled. So did you start your hearing that day in the Wilson case?
I believe we did.
That's
it was
the one.
discussed about. I'm sorry.
Okay, I think that's the day that your side lists among its complaints that you weren't allowed to finish your side of the testimony. The judge interrupted and said, this is going to take too long. I'm going to reset it to August the 15th. Right? Okay, so
Yes, sir. Yes.
my question to you is, why did you not find out from somebody about what the status of the Morris case was?
Okay, because this is like, respectfully, Judge, this is new to me. I didn't know I had to go and approach the DA because, from my opinion, it's unprofessional to approach the DA and the judge. I'm not to approach either or. So I didn't know that it would be okay for me to go approach Ms. Desky and say, hey, give me the paperwork that you know you need to serve me. I didn't know that I needed to do that. So I dare not approach a DA or a judge asking, I mean, I've always been told it's unprofessional. You cannot do that. So.
Well, there are other people there besides the judge and Ms. Desky. There's a court coordinator. There's probably a clerk. There's a bailiff. They're all kind of court officials. Did you feel any reluctance to ask one of them?
So again, respectfully, Your Honor, I did not know that I needed to go and get a reset date, because I have sat in the Burleson County courtroom and I have watched Ms. Desky along with other coordinators, Ms. C, I have watched them say, hey, here's your new, we've reset you. And I've watched them hand paperwork to tons of other people. So why couldn't I got the same treatment? Why did I have to run up there and go find out? The other people didn't. They were given the correct documents that they needed to appear back in court. I was not, Your Honor, and I didn't know that I needed to go up there. That's how I've never seen it happen. I've always seen it happen to where they approach the, us, the people, and hand us the proper paperwork. I've never seen someone go up there and say, I need my paper. Or I need my next court date. I've never seen that. I was already being threatened to be thrown in jail. There's no way I was going to do that.
Well, just a minute. I believe you were threatened on August 15th.
That's true.
So I don't think you would have been I don't think you would have been fearful on June 24th.
Oh yeah, because that's what I'm saying. I've seen to where other people have I have seen to where the DA or the clerk or even her assistant has went and handed other people their notices to reappear in court. Okay. So when it's time for me to get my notice, I'm not giving my notice. To make me look bad, they did a good job at it because I didn't get my notice, even though I was there, but I was there for another case, not for Miss Morris's case.
Okay, now you've raised something that frankly prompts another question. If you are familiar with the process of the court staff handing people notices, why didn't that make you all the more curious on June 24th about what's becoming of the Morris case?
Because Miss Morris's case was never even brought up that day. It was never brought up. So if it wasn't brought up, that's the last thing that's on my mind. Miss Wilson's case was brought up, not Miss Morris's. And again, I was not going to approach the judge or the DA and say, I need a reset paper when I've seen them give everybody else theirs. Why not hand me mine and keep confusion?
I have a new question.
Okay.
When did you conclude that this Judge Campbell was biased against you?
I gathered that conclusion on June 24th is when I gathered that conclusion. It's like he was more frustrated because of all these false allegations. And then the DA made a comment. Miss Deskey said to Miss Jones while I was standing there, "Oh, your client has a whole list of them coming, or a whole stack of them coming," as she kind of tossed her the witness paper, a piece of paper with the witness names on it.
So was your concern about his bias toward you confirmed or increased even as a result of the August 15th occurrences?
Yes, sir. Even more so. Yes, sir. Just because the way the case was handled. Judge Campbell didn't want to hear my case with Miss Wilson, but he took the time out to hear my case with Miss Morris when I had no attorney. So it was like, well, if you had time to hear that case, why didn't you hear the case where I'm paying an attorney to be here? You see, I'm paying Miss Jones to be here. You should have heard that. He should have heard that case. I'm sorry, not you, but Judge Campbell should have heard that case. Ms. Deskey should have pushed forward on that case where there's an attorney that's being paid to be there versus, well, I have no attorney and it's not costing me a thing, to go forth on a case that honestly I wasn't prepared for. We prepared long hours for Miss Wilson's case and Miss Wilson's case only. I had no earthly idea, Your Honor, that I was going to be in court August 15th for Miss Morris's case, or I would have been prepared.
So tell me why you and your attorney waited until November 14th to file the motion to recuse the judge.
Objection, attorney-client privilege communication, objection, work product privilege communication.
Very well, I'll sustain. When did you file a complaint against Judge Campbell with the Judicial Conduct Commission?
Ooh. I believe in November. I believe in November, Judge, if I'm remembering correctly. You mean, okay, not the appeal, but the complaint, right?
Right.
Yeah, I believe in November.
Which lawyer assisted you in doing that?
Objection, attorney-client privilege.
Explain how the privilege could apply.
Well, the privilege could apply if Miss Butler, judge, is talking to a lawyer about her options based on judicial misconduct. What she says to her lawyers is privileged. The only person who can waive that privilege is Miss Butler.
But I didn't ask her what the lawyer advised her. I asked her which lawyer assisted her.
But that's attorney-client privilege as well, Judge. I don't believe the law requires that someone who has a relationship with a lawyer has to disclose to the court what lawyers they're talking to. I still think that's attorney-client privilege.
You may be right. I'll sustain your objection. So do you remember when you filed the ethics complaint against Ms. Deskey with the State Bar of Texas?
I don't remember the exact day it was filed. No, sir.
You don't have a copy of either of those papers?
Let me look in my case. Give me 1 second. No, so for that complaint, Your Honor, that's not in my case because that's with a different attorney. So this is with Ms. Jones. So I don't have that paperwork. I don't know the exact date that you're looking for. I don't know the exact date.
All right. That's all I have.
Yes,
Ms.
sir.
Jones, Ms. Jones, your witness.
Yes, Judge, I'll redirect. Miss Butler,
Yes, ma'am.
when you remember the questions from Miss Deskey asking you about evidence, documents, witnesses, when the judge asked you if you were ready? Do you recall that?
Yes.
When they asked you if you were ready, isn't it true that you told the judge, I'm not ready? to
That's
go
very
forward?
true. Yes.
Right. And so did you believe you had an obligation to tell the court, I have evidence, documents, witnesses? Did you believe you had that?
No, because I wasn't.
So when Ms. Deskey asked you about the witnesses and you said that she had 2 witnesses, why did you leave off, is it Officer Sleeth or Deputy Sleeth? I don't know what his title is. Why did you leave him off?
Corporal Sleeth, it's late and my head is swimming and I'm trying to keep up, and just an honest mistake, but he was one of the witnesses. So it wasn't that I was trying to keep back or hide something. It's nothing to hide because it shows clearly in the records that he was one of the witnesses that I spoke to. So he was one of the witnesses. And I also want to make sure that it is on the record that the Ms. Deskey claims that the same witnesses for Ms. Wilson's case and Ms. Morris's case were the same. They were not the same.
So there was questions by Ms. Deskey about when you got served with Morris. So you testified that you got served with Morris on June 20th. And so June 20th, would you agree, is how many days before June 24th?
Touching 3 days. Because when the constable called me, he said, I said, well, I can't take anything from you. I need to speak to my attorney first because whatever you have, my attorney should have. Like, you shouldn't be serving me anything. So it was a surprise. So when I reached out to you, I said, hey, the constable's trying to serve me something. I mean, I don't know what to do. Should I take it or should I not? And he's like, well, Ms. Butler, I really need to give this to you. And I waited for a response, and then I'll be darned, I said, well, okay, I accepted it from the constable. And then about 5 minutes after I accepted it from the constable, you texted and said, no, like, just wait, which was too late because I did accept it.
But is that, so isn't it true that you thought that the constable was trying to serve you something in the Wilson case?
Yes, ma'am, because I wasn't running or hiding from him. I just thought, like I told you, and like I told the constable, I said, whatever you're trying to give me, I'm sure my attorney has, or that you guys sent it to her. So I don't know why I would need a copy. My attorney will let me know. It's 7 o'clock in the morning and you're calling me, trying to give me something that my attorney have.
So just to be clear, the reason you told him that he should give it to me is because you thought it was in the Wilson case. That's all I want to know, yes or no?
Yes.
Okay, no more. Okay. So when you hired a lawyer on the Morris case, you hired that lawyer sometime after August 15th. Is that correct?
That's correct.
And that lawyer was not me. Is that correct?
That's correct.
Okay. And you heard some testimony by Ms. Deskey talking about Judge Campbell allowing the motion for new trial to be overruled by law. Do you know what that means?
No.
Okay. So you also heard some testimony by Ms. Deskey saying that, I guess your attorney reached out to Ms. Deskey. So your attorney, Ms. Jurek, reached out to Ms. Deskey to ask her to agree on a stay. Is that accurate?
Yes.
Okay, so you didn't have anything to do with that. That was your lawyer, correct? I mean, did
That's
you?
correct. Because I hired an attorney then. Yes, ma'am. That's correct.
So I'm guessing you presumed that your lawyer knew how to best represent you.
That's correct.
Did you even know about like before you hired Ms. Jurek, did you even know what a stay was?
No, ma'am. No clue.
Also, there was some testimony from Ms. Deskey. I'm sorry, questions to you from Ms. Deskey about the stay being denied. Do you remember that?
I remember her question, yes.
Yes, and so, but there's the case. If you understand, if you don't understand, then don't answer. But if you understand, do you understand that there's still an appeal in the 10th Circuit in Waco?
Yes, I do understand that. Yes.
Okay. So it's your understanding that the only thing that was denied was staying the temporary protective order. Is that your understanding?
That's
Okay.
correct.
So you remember the questions by Ms. Deskey about when you got served for Wilson? You remember all those questions?
Yes.
In preparation for this hearing today, did you believe that when you got served for Wilson went to what was a subject of this hearing about whether the judge was biased or prejudiced or impartial towards you?
I'm sorry. Are you gonna have to re-ask me that question? Like,
when you were preparing for this, did you believe that the date you got served with the Wilson case was germane to whether the judge was prejudiced or biased or impartial related to you, like you getting served with the Wilson case? Did that have to do with bias, prejudice, and impartiality? The date that you got served.
the date that I got served on Miss Wilson's case, did I believe at that time that there was any bias or prejudice against me?
Not at that time.
Is
like
that your question?
I'm sorry. You know what? Let me just move to another question. I'll try to come back and figure out a better way to ask you. There were some questions to you by Ms. Deskey about many resets granted. Do you remember that line of questioning?
Yes.
So on June 15th, I'm sorry, June 24th. On June 24th, in the Wilson case, did we want to be reset on that date?
No, we
After-
didn't. No, we didn't. No.
But were we forced into a reset?
Definitely.
So any representation that it was something that both parties wanted, is that accurate?
That's not accurate because it's not. We wanted to move forward.
Because we had started that hearing.
Correct. And
Okay.
before we started that hearing, cases were being reset by the DA or the judge. I'm not sure which one, because Miss Wilson didn't have witnesses. They had to go dig up some witnesses who was willing to lie for Miss Wilson because they didn't have that at first. And even then, her witnesses continued to change because she didn't have anybody who was willing to go on the stand under oath and lie for her, especially after you told her she was going to be or mentioned something about impeachment. That scared the witnesses off from lying. So the new witnesses came every time we went to court.
Okay, so do you remember there was some testimony about motions for continuances as if we were requesting continuances. Do you remember that line of questions from Ms. Tedeschi?
Right. She was trying to make it like we were the ones requesting these. Yes.
Okay. We did not ask for continuance on June 24th, did we?
No, ma'am. We didn't ask for a continuance June 24th. We didn't ask for a continuance August 15th. No, ma'am, we did not. Especially my pocketbook did not ask for it. No, ma'am.
So all the testimony about regular dockets that you heard from Ms. Tedeschi, you don't know anything about that, do you? Like what
No.
their regular dockets are?
No, I
When
wouldn't know.
Ms. Tedeschi was talking about those dockets you went to I guess to correct a misinterpretation. You testified that you thought that August 15th was supposed to be cleared out for us. You testified to that when Ms. Tedeschi was just questioning you. Is that accurate?
Yes, ma'am.
Let the record show that Ms. Jurek just entered the virtual courtroom, but she has now left apparently.
Okay. So, and I just want to confirm that there was questions about you running into the judge in public, Judge Campbell in public, and you talked about, I can't remember the places that you said where the judge would have had to have been. I guess what was most important about that is you said you hadn't run into him in the public. Is that what you said? Is that your testimony?
That's true.
Is the reason that you said, why did you specifically point out where the judge would have to see you? Why did you do that? Why was that important?
Why did I point out what?
Before you answer, let the record show that Ms. Jurek has re-entered the courtroom again, which is fine, Ms. Jurek. You're certainly welcome to be present. I think the witness does not understand. I think the witness does not understand your question, Ms. Jones.
Why did you think it was important when Ms. Tedeschi asked you, had you run into Judge Campbell why you run it, if you ran under Judge Campbell in public, why did you share with us the places the judge would have had to be? And why was that important for us to know that?
Because I'm a loner. If I'm not with my kids or my mother, you will not see me out and about. You will not. So if you want to see me, you have to come into my personal bubble because I won't come into yours. Meaning you literally have to be where I'm going to be. 7 a.m. I have the same routine I've had for 14 years. 7 a.m. Get up. I take my children to school because they do not have a bus. My kids attend a private school. I have to take them every morning. I have to pick them up every afternoon. I have a
Okay.
restaurant here.
Okay, I think we got the
Okay.
gist of your answer.
And so along with that, when you're taking your children, Ms. Butler, to all these places you have to take them, just because of geography of Caldwell, does it cause you to have to pass by Miss Morris's house?
Oh, yeah. Sometimes twice a day, sometimes 3 times a day.
There were questions to you, Miss Butler, by Ms. Jurek, asking you if the reason that, well, no, it's asking you if you just didn't like Judge Campbell's rulings, right? Is it just Judge Campbell?
Objection. I never said that. I
I'm
never
sorry,
asked
the court
questions.
reporter. May we have the court reporter read back that question, please?
No,
question-
no.
No, that's Ms. Desky, Ms. Jones, not
I'm
Ms.
sorry.
Jurek.
Oh, I'm confused about, there's all these names. May I have, I'm sorry, I'm tired too. May I have the court reporter read back the question to Ms. Butler by Ms. Desky related to her not liking Judge Campbell's rulings on the Morris case?
For what purpose?
So that I can find out what, I mean, I know what I asked, and I don't believe that Ms. Desky's objection is appropriate, but I want to hear what she said, since she said I'm mischaracterizing it.
I'm attempting here to save some time and reduce the strain on the reporter, but it's more important not to needlessly consume time.
Judge, respectfully, Ms. Desky asked my client specific questions on her cross-examination of my client, and I'm now going back and cleaning up confusion about anything related to the questions. If the court will recall, well, the court doesn't know this, I took notes of her questions and what they were, what my client's answers were. So I'm now going back to clear up anything, because one of the things that precludes you having to recuse the judge is if my client's complaints are solely about his rulings. And this is not solely about rulings. So I'm going back to that because it is an element that I have to prove in this hearing.
You do not have to prove that she has no complaint outside of court. And all the evidence is, actually, there's no evidence that there's any interaction between these two people outside of court. Your client's complaints are exclusively, so far as I know, so far as the evidence has presented or revealed, exclusively about what he did in court.
Yes, I agree, Judge. So I'll move on.
Okay, so why do we need to have the reporter read back a question?
I'll move on, Judge.
That would be good.
Okay, thank you. There were some questions that the judge asked you? Do you remember those, Miss Butler?
Yeah, I'm trying to remember everything, but I'm ready.
So the judge asked you about the hearing on, about the setting on June 24th, 2022. Do you recall that?
Yes, I do.
On June 24th, 2022, is it accurate to say that your concern was about the Wilson hearing? Is that accurate?
That is.
And you had, I'm sorry?
She said that's accurate.
Okay. And then the judge asked you about the Morris case and you having to come to court on June 24th. Do you remember that?
Yes, I do. 3 minutes.
So, and the judge asked you, why did you not go and figure out when you were supposed to come back on the Morris case? Do you remember that?
Yes, ma'am.
And you tell me if this is true or not. The reason why you weren't focusing on the Morris case is because you thought that you were there for a trial in the Wilson case. Is that accurate?
That's true. And the Morris case was never, it wasn't brought up. It wasn't asked if I'm ready to go forward with it. It wasn't even brought up.
And it wasn't brought up before the bench, correct?
No, it wasn't. Absolutely not.
So we also began a hearing on June 24th, didn't we?
We did.
And then we got interrupted. Is that accurate?
We did.
And you were upset that we had to stop our case while I was cross-examining Ms. Wilson. Is that accurate?
That's accurate.
Is it fair to say that after we started a hearing, we prepared for a hearing, you're paying me money, and then it gets interrupted, and then we have to move it forward, that you were concerned, at least with me, about, well, how do we know this isn't going to happen the next time?
Correct.
Is that accurate?
That is, yes, correct.
Were you even thinking about the Morris case?
Not at all. I wasn't
Okay.
thinking about it. Again, it was not brought up. And for an example, here's a beautiful example. When we appeared in court on June 24th, 2022, we announced ready to go, okay? Morris was never brought up. Yet, when we appeared in court August 15th of 2022, we announced ready, we were stopped, Morris case was brought up, okay? Even though I was not served of a new court date. So why couldn't Morris case be brought up for the day that I was actually served for, which was June 24th at 9 a.m. in the 335th District Court? That is what I was expecting that day, along with Ms. Wilson's case, but that wasn't even brought up. Wasn't brought to my attention. I wasn't reserved. However it needs to be brought, said could, brought forth. It wasn't brought up, and I didn't go get it, and I definitely wasn't reserved. As everyone else I have witnessed in the courtroom be served. I was not served.
So you remember the judge asking you some questions about why didn't you make sure that you found out about when you were supposed to come back to court? Is it accurate to say, just to paraphrase what you just said, that you didn't know you had to?
Right, it's not my job. It's not. Nobody else do it. Nobody else has done it. They've always went to that person. Nobody else has done it. I've been in Burleson County courtroom enough times to honestly say I've never seen someone approach the judge, the DA, or the court reporters asking for a new court date. Never. They've always said, Mr. or Mrs., go over to the left and get your court paperwork.
So is it fair to say, Ms. Butler, that the way that the way that most people are notified in the court based on what you've seen is they're told when it is, and that with you it was different?
Yes, ma'am, that's true.
And do you consider that bias and prejudice?
very biased and very extremely prejudiced. Why not give me the same fair treatment that you give others? I mean, far as I know, I didn't do any wrong to Ms. Desky. I didn't do any wrong to Mr. Campbell. I'm sorry, to Judge Campbell. No wrong to the two. So why couldn't I be treated just as fairly as everybody else, or get the same type of respect shown to me as everybody else has?
And do you think that them not giving you notice of the next court date and given and what you've seen in that court with Judge Campbell and County Attorney Desky, that you believe that them not that you not being directed by the judge to go to whoever's next to the court, that shows impartiality, or it shows that the judge isn't impartial with you?
It was a setup that was successful.
Does that mean it's not does that mean he wasn't
That's
impartial?
correct. Yes, ma'am, that's correct.
There was some questions to you from the judge about whether about your court appearance on June 24th. I just want to be clear. Am I accurate? Is this accurate? You were in court on the 24th because you've known you had a hearing set on the 24th. You found out on the 20th, before the 24th, that you had this other case, and it happened to be set on the same day, but your focus was on the Wilson case.
That's correct. What's he crying? What are you crying for?
And the judge specifically named people in
Just
the
a minute.
courtroom
Just
who were
just a
not the
minute.
judge.
Just a minute, Ms. Jones. Ms. Butler, do you need to take a minute to calm the child?
Yes, sir. I'm sorry. He's just tired and ready for bed. Just give me 5 minutes to put him down, because my mom's obviously tired and frustrated, and it's just making him scream even louder. So
You do
give
that.
me
You
5
do.
minutes to put my little one down, and I'll.
You do that.
Thank you. Yes, sir.
Your Honor. Hi, this is Lynn Jurek. I guess Jelena Jones left. I didn't mean for her to leave, but
I haven't left. I haven't left. I'm just trying to see if I can reach my staff for something. That's all.
I would just like to have an opportunity on the Morris case to simplify matters and explain the situation on the Morris case, because to be quite honest to Attorney Jones, she doesn't know that case. And I was trying to help her with the case yesterday, but I can simplify it very quickly.
So is that okay by you, Ms. Jones?
As long as it's okay by my client in this case, but we just have to wait. And
no, she asked me to appear, so it's good.
Oh, okay. All right.
Okay.
Okay. So I need to run to the restroom while she's putting her child down. If that's okay, Judge.
I'm sorry, I went off the record. I did not record what Ms. Jurek said, because with the witness gone, I thought we were off the record.
No, that's okay. It's more administrative. I just wanted to make sure it was okay.
I'm just going to run to the restroom, please.
We're on a recess.
Okay.
Okay.
I'm sorry, Your Honor. I haven't eaten and I'm sick. Yeah, yeah, but I'm back now. I haven't eaten all day, so.
So let the record show we have everyone reassembled, Ms. Deskey, Ms. Jones, Ms. Butler, and now Ms. Jurek. And I interpret what Ms. Jurek had to say off the record a moment ago to suggest that she had some information she wanted to share with the court, perhaps so that she could finish her involvement in tonight's hearing. Maybe I read too much into that. What were you trying to get over to me, Ms. Jurek?
I just wanted to ask, so Miss Butler, I didn't know this. I didn't realize that you'd reached out to Miss Butler. To Miss Jurek, so I told the court that I didn't have any objections as long as you wanted Miss Jurek to be here. I just wanted to have that on the record.
Definitely, because she's relevant to the case. Definitely.
Okay, I have no objections, Judge.
All right, as an officer of the court, Ms. Jurek, you're welcome to present facts within your knowledge. But
Thank you, Your Honor.
you may be questioned as a witness.
Oh, thank you, Your Honor. First of all, I would like to ask the court to take judicial notice of the Court of Appeals of Texas case 177 Southwest 3D 232 Wanda Hudson versus Texas Children's Hospital for the proposition that the 10-day requirement for filing a motion to recuse does not contemplate a situation in which a party cannot know the basis of recusal until after a motion for recusal is no longer timely. Meaning that Ms. Jones's motion is timely because, one, when she filed it, she did not know that that Judge Campbell, one, heard a case in the 21st Judicial District Court that was filed in the 335th, that was not transferred to the 21st, that he issued an order, a protective order against Ms. Butler in the 21st, that was filed in the 335th, that was not noticed to Ms. Butler. On July 29th, there was a motion filed. And if you give me a moment to show you the motion, it was filed by Susan Deskey in the Morris matter. I'm not going to discuss the Wilson matter with you, Your Honor, because I'm only part of the Morris matter. But if you give me a minute, I will pull up the motion that Ms. Deskey filed that was never served on Ms. Butler. And at that time, it was never served on Ms. Jolanda Jones, yet it references Ms. Jolanda Jones. And if you bear with me, I'm not going to take very long to prove this to you.
May I ask Ms. Jurek to speak up a little bit, please?
Oh, I'm sorry. Certainly. So if you just bear with me for a moment, I'm going to pull up my screen and I'm going to share it with you.
Okay, I have enabled screen sharing by multiple participants, so you can share it when you're ready.
Okay, thank you, Your Honor. Just one moment. And while I'm discussing this, I will tell you that I filed a timely motion for new trial in the Morris case. It was not responded to by Ms. Deskey. I appeared to Judge Campbell in our motion for new trial. The judge heard arguments from me and then heard arguments in opposition from Ms. Deskey, and I asked the court repeatedly, I'm just confirming for the record that Ms. Deskey filed no response to the motion for new trial. No answer. The judge ended it by saying, thank you very much for your appearance, Ms. Jurek. He treated me with respect at the time and said he was going to take it under advisement and rule. We called every day because we had a deadline to file our appeal. The court kept telling us he hasn't ruled yet. He's going to rule. He hasn't ruled. He may rule. Every day we call, my legal assistant and I can verify that. By the time of the end of the deadline, the 75 days after you file a motion, there's no ruling, so it was overruled by operation of law, which when you have an unopposed motion for new trial especially a verified unopposed motion for new trial. The court should have granted it. He didn't. Procedurally, that's improper. And that shows bias. And so we have filed a motion to stay. And they responded. But Your Honor, there was no notice. And I will show that to you in a moment. There was a response by Ms. Deskey to that. And it was filled with complete lies, deceptive, misrepresentations to the Court of Appeals. I responded. And the order, if you've seen the order, was based on one false finding of an allegation of stalking. It didn't happen because Ms. Butler was injured and was not driving that day. And what the one finding of stalking was an alleged black Lincoln changed lanes around Miss Morris, changed lanes around Miss Morris, and Miss Morris called it in and basically said, Miss Butler changed lanes around me at an intersection.
Your Honor, I would object at this point. If you'd like, I can try to zoom in the appellate attorney who can explain her response.
You signed the response, Ms. Deskey. Did you not?
There is an appellate attorney of record.
Okay. Anyway, I'm sorry. I'm not going to argue with opposing counsel, but let me show you what happened with the notice of the hearing, the fundamental notice of a quasi-criminal hearing, because it's quasi-criminal because the state of Texas is bringing it against my client. So bear with me for just a moment.
Your Honor, I believe we've already addressed this.
I couldn't understand you.
Your Honor, I believe we've already addressed this